November 2021.
And here we are today as the trial for James Crumbley continues. Thank you for joining us. I'm Terrence Friday.
And I'm Meredith Bruckner. As we await for the court to get underway, our Rochelle Graham joins us with the recap of the trial so far.
5 witnesses were on the stand Friday. We saw each of them testify in Jennifer Crumbley's trial as well, the woman who sold James Crumbley the gun.
If the defendant's son would have walked in with the defendant and pointed at that 9mm and said, "Hey, Dad, that's the one I want," would you have sold it to him?
No.
Okay.
Oxford High School's assistant principal.
I went towards the gunfire to see what was happening because I wanted to make sure that our kids were safe.
And 3 law enforcement witnesses.
How many times did the shooter fire that weapon inside Oxford High School on November the 30th? 32 times.
But this video from when James and Jennifer see their son for the first time after the mass shooting prompted debate we didn't hear in Jennifer's trial.
Why? I love you. I love you. I love you. I love you.
James Crumbley's attorney, Mariel Lehman, appears to highlight the interaction as one that helps the defense, bringing it up in her cross-examination.
As James and his wife are leaving, James repeatedly tells his son that he loves him.
Yes, he does.
And he says it over and over. I think I counted 4 or 5 times.
Yes.
But the prosecution has a different take. It implies James Crumbley was only saying "I love you" over and over to cut off his son's confession.
And his son was actually saying, "I did it" at that point.
He did.
So James was yelling, "I love you, I love you, I love you," louder, louder, and louder over his son.
The pace in James Crumbley's trial much faster than Jennifer Crumbley's. It continues Monday at 9 a.m. Rochelle Graham, CBS News, Detroit.
Right, we are joined again by our legal experts to continue the conversation about what we're going to see today.
Attorneys Arnold Reed and Rick Convertino join us now. Thank you so much for being here this morning. Arnold, what can we expect today?
You can expect much of the same that we've seen from the prosecution, continuing to back up their theories that they laid out in opening statement. You can expect the defense, I believe, to continue to not overly object, not overly speak in court, make a few objections here and there, move this case along. And I think that she's, like we've been saying, she's got an uphill battle here, the defense attorney. But I think so far she's done a very good job, at least compared to what we've seen in the first trial.
And what's your take?
Well, as Rochelle said, that the case is moving along quickly in a manner that's speedier than the last trial. I think I compared my notes this weekend with the last trial, and we're 2 witnesses ahead now than the last trial at the concurrent time. So I think what we're seeing is a more focused, succinct, more surgical defense than we saw in the last case. The openings were shorter. The direct examination, these are witnesses who have testified now. All of them that have testified, this is their 3rd time they've testified about the same facts in the same manner. The direct examination questions were the same. There's no glitches or additions to the testimony from the from the Miller hearing and the first trial. And the only difference is the cross-examination and the defense strategy and the way the defense is going about the prosecution, if you will, of their case. Which is much cleaner and neater, and no needless objections, as we saw in the first case. And there aren't, one of the things that we don't see now is, you remember in the first trial there were all of these needless objections to evidentiary issues that were decided months prior to the trial. So attempts to get evidence excluded that was previously admitted in an order by the court, or efforts to include evidence that was previously excluded by the court's order based on a defense motion. So the defendant, kind of sua sponte, in a more an emotional way, decided for whatever reason, I'm going to admit this evidence. I'm going to admit evidence in an unredacted way, even though it was decided that it wouldn't be admitted. And so those kinds of things took time. There were evidentiary issues that were argued outside the jury's presence that took time, that aren't being done in this case now. And so it's streamlined, and it's effectively moving along in a quicker pace, and I anticipate that
she's got to pick
today.
She's got to pick her arguments, I think, too, wisely, We just saw the clip there, Rick, where they were in the interrogation room, for example, and the prosecution and defense are diametrically opposed on what the I love you, I love you, I love you means. Of course, the prosecution is saying that, oh, that was just a veiled attempt for dad to cover up and signal to his son, right? The defense, I think, has got to come back and indicate everybody knew that he was the shooter. There was nothing to cover up at that point. A confession at that point would have been academic. So she's got to pick her points that she can win. She's got to win points that she knows she can prove. Cross-examining these witnesses, as Rick has indicated, that, you know, have been humanized, so to speak, is not going to get it for her. She's got to pick and choose areas where she knows that she can win these arguments and hopefully convince some of those jurors that dad didn't know that his son was capable, again, of such a heinous act. And so far, I think she's done a good job, and hopefully she'll be able to pull it together.
Well, on the I love you, I love you, I love you, you know, I think the danger to that, the pursuit of that by the prosecution is that, you know, you have potential jurors who are thinking, well, that's overreaching, and that's detracts markedly from the credibility of the prosecution in the case. If you have to overreach on that, you know, that's seemingly that point for either side is irrelevant. I mean, whether or not he loves his kid and he was saying it to emphasize I love you is totally irrelevant at that point. Whether or not he was trying to cover up is also irrelevant, because I think it is overreaching. And as Arnold said, it's a point, you know, he said, I did it. He obviously did it. He's on tape, video. He said he did it at the school. They caught him literally red-handed, so to speak. So there's no issue regarding the confession. And so to emphasize that point, to try and overreach on that issue is you know, ridiculous, really.
Are there any other points where you see that the defense has a clear opportunity to carve out her case?
I think the biggest opportunity in these cases, I always say, well, let's roll the tape. You don't know what you're going to see until you roll the tape, and imagine we're at the end of the trial. She's got to embrace certain things and not run from them. She's got to embrace the heinous nature of this act. She has to embrace the public perception. And then she has to be very skilled at separating her client's conduct from his child, right? That's what she has to do, embrace these things and then differentiate to the jury in her closing argument.
All right, we'll see if she manages to do that. We'll see. All right, we do.
Welcome back. We are waiting for court to get underway for the trial for James Crumbley. We're going to bring in our legal experts to help us continue the conversation about what we've seen so far and what we will see moving forward.
Yes, attorneys Arnold Reed and Rick Convertino are here with us this morning and throughout the trial. Thank you both so much for being here.
Thank you.
So do we know how many witnesses that the prosecution is planning to call in this case and where we are at now?
You remember in the first trial it was 80. And then it went down to 50, and then it went down to 25, and I think they ended at about 15. The prosecution said last week that they have 15. So now 15 may be 12 or 10 or maybe 15, but typically, you know, in the prosecution, during the prosecution, if you're seeing less pushback, there's less issues on the admission of evidence because it's not really controversial. There's no basis for an objection. You know, you don't need those witnesses that you anticipate you might need. One of the witnesses who was huge was Special Agent Rogowski, who testified about the downloading of the data from the cell phone and the cameras, and then also interpreted the actual videotape that was in Hallway 200 and others regarding what he saw and how the evidence played out from his perspective, which was, I thought, irrelevant and should have been objected to, but wasn't. But that saves the prosecution witnesses who are in line to come in and testify about the same thing. We're going to see the witnesses this week, the students that are the new student who's going to be powerful, and it's going to be very an emotional piece of testimony as well.
All right, well, we see the witness being brought in. That appears to be Sean Hopkins, a counselor with Oxford High School. We're going to listen in now as the trial continues. A reminder, what you're hearing and seeing could be disturbing.
Sir, how are you?
I'm here.
Sir, do you work for the Oxford School District?
I have been employed for the Oxford School District. I am currently on leave at this moment.
Now, I'd like to direct your attention specifically to the fall of 2021. Were you working with Oxford School District at that point?
Yes, I was.
In what role?
I was a counselor in Oxford High School.
Okay. And tell us, please, what general duties are associated with that particular role?
I managed a caseload of about 400 students. With that, I was in charge of scheduling for those students, preparing them for life after high school by helping them kind of look through different potential job opportunities, caring for social emotional wellness for students, and being kind of just a general person who would be consistent throughout their time in high school working with them.
Okay. You said you had a caseload of about 400 students?
Yes.
How many students went to Oxford High School at that particular time?
There were approximately 1,800 students. Divided amongst 4 counselors, there were 1,600, and then approximately 200 in an early college program as well.
So in November of 2021, approximately how long had you been employed with Oxford High School?
I started as an intern in 2014 and was hired full-time in fall of 2015.
Okay. Tell me a little bit about your background, please.
I came out of college, graduated with a degree in youth ministry, worked as a youth pastor starting in 2009, and then did that and went back to school for a master's degree in counseling. I graduated with that, actually walked in December of 2014 and started working in the high school thereafter.
Okay. Now you mentioned your role included helping students transition into post-secondary either education or employment, scheduling, as well as social, emotional issues.
Yes.
Would one of those roles take precedence?
It would ebb and flow depending on the time of year, but there was never anything that you did that was, this is the most important thing, because it was what student you were with at the time.
Okay.
To a senior going to college, helping them with that college application took precedence in that moment. To a student sitting in front of you with social emotional needs, that took precedence in that moment.
So did you have regular check-ins with students, or was it an as-needed basis?
It depended on what it was for. We did have regular meetings with students in regards to scheduling, but when it came to social emotional, that was more of an as-needed basis.
Did your role as a counselor involve disciplining students?
No.
Okay. Who took care of that?
That would have been the dean or our administrator.
In November of 2021, who was the dean?
Nikki Jack.
All right. And did you work with him a lot?
No, I didn't. He was actually new to the district that year.
Okay. So is there a reason why the counselor would be separate from the discipline of students?
The counselor's role was to be a student advocate, to remain on the side of the student through difficult situations oftentimes, to give the student somebody that they could build that trust and rapport with, where the dean would be enforcing code of conduct.
Okay. What code of conduct? What's that?
The standards that are expected to be followed by students.
Okay, so a rule. Would that be fair?
That would be a part of it,
okay.
Yes. Yes.
Now, in the fall of 2021, was Oxford High School in person, hybrid, or remote?
Oxford High School was in person.
Okay. Were all students and teachers wearing face masks at that point?
Yes, they were.
In the fall of 2021, what sort of issues would you face with the students' social emotional health?
Social emotional health was definitely on our radar in the fall of 2021. Coming out of COVID, coming out of time being out from school, the anxiety that was associated with that time period, we saw a lot of issues for students, whether it be anxiety, whether it be depression, and in a few cases, it was suicide attempts.
Okay. Now, that year, did you encounter any students who actually had attempted suicide?
I did.
How many?
At least 4.
Sir, are you familiar with the term suicidal ideation?
Yes, I am familiar with that term.
Could you please explain to us what that means?
Suicidal ideation
Here, I'm
is...
going to object to relevance.
Judge, I believe this witness will testify that he indicated that the defendant's son was expressing signs of suicidal ideation that was expressed to the defendant.
Well, that was his belief at the time, right? So I'm going to allow it.
Thank you. What's suicidal ideation?
Suicidal ideation is looking at themes, ideas, behaviors which could be associated with suicide. So when you take sadness, depression, anxiety, those on their own aren't necessarily suicidal. And when we look at them, we may see somebody who's not actively suicidal that may not be expressing a date or a plan or a method, but we see themes that, if left unchecked, could be associated with potentially becoming suicidal.
Okay. Now, as your role as a counselor at Oxford High School, as you dealt with students who were expressing suicidal ideation separate from those who actually attempted suicide?
Yes.
Could you put a number on how many?
Dozens.
Now, you mentioned that there were 4 counselors for a school of around 1,700, 1,800 or so. How was it that each student was assigned to a counselor?
Of the students who are not in the early college program, they were divided out alphabetically amongst their counselors.
Was James Crumbley's son one of the students assigned to your caseload in November 2021?
Yes.
Is James Crumbley in court today?
Yes, he is.
Could you please point to him and describe something he's wearing today?
He is seated at this table wearing a suit coat with a blue tie.
Your Honor, would the record reflect identification of the defendant?
The record would reflect the in-court identification of the defendant, James Crumbley.
Sir, when is the first time that you would have interacted with James Crumbley's son?
The first time that I likely interacted with him would have been scheduling during his freshman year.
Okay, so for context, November of 2021, he was a sophomore, is that right?
That is correct.
Okay, so this would have been August or September of 2020?
No. When students are in 8th grade, they're scheduled at the middle school level.
Okay.
I may or may not have been in his classroom because it's divided out within their 8th grade classrooms. And we don't know the students at all at that point.
Okay.
I would have done scheduling with him during his freshman year, approximately February of 2021.
February of 21?
Yes.
Okay.
Those meetings were done virtually and were not in depth and were only to discuss their next year's schedule.
Do you remember anything about that meeting if you
I
had?
don't remember that meeting in particular, no.
I'm going to show you. First of all, if you recall, when is the next time that you had any interaction with the defendant's son?
I don't recall this particular meeting, but I know that there was a phone call in spring of 2021 from a teacher to me, and then I called into the student's classroom to meet with the student.
Okay.
I do not remember that meeting.
All right, I'm going to show you what's been, if it is Exhibit 198. This is an email, May 13, 2021, 1:46 in the afternoon. Without telling us that person's name, who was that person who sent you the email?
Without telling.
Well, who does she work there at Oxford High School?
She was an English teacher at
English
Oxford
teacher,
High School.
okay. And the email is, "Hi, when you get a chance, can you call the defendant's son down and see how he's doing? He is failing my class and tries to sleep all the time. In class, thanks." That's Exhibit 198, May 13, 2021. You received this email?
Yes, I did.
Okay. And the response from you at 2:07 p.m. is, "I'll catch him before the end of the day." And then her response at 2:08 was, "Thanks, just a little worried." Okay, did you have any interaction with the defendant's son because of this email?
I have, through phone records, I called into a student's classroom and called him down to my office. I don't remember that particular meeting.
Okay. But at least your recollection is that you would have had that meeting.
The evidence from everything suggests that I had that meeting.
Sure, that's fair. Did you contact either James or Jennifer Crumbley then?
I did not.
Okay. And why or why not?
It was a check-in, and it didn't raise to the level of concern where I would contact a parent.
Now, as a counselor with Oxford High School, did you have a sort of method or protocol for when you determine when to contact a parent?
There isn't a set, there isn't always a set level of when you do it, but when something becomes repeated or when something becomes more concerning, I am going to then involve a parent.
Okay. Are grades available to parents on a district-wide basis?
Yes, they are. They are available through a system called Power School, which is available online.
Okay, and that's the system that a parent can log in daily if they would choose to?
As often as they would like.
Now, the next interaction you had with the defendant's son would be September 2021?
I did not actually have an interaction with the defendant's son. I received information about the defendant's son.
Okay, I'm showing you Exhibit 199. This is from a different teacher to September 8th, 2021?
Yes.
Okay. And why don't you go ahead and read the email here that you received.
Hi, Sean. Could you please touch base with student? In his autobiography poem, he said that he feels terrible and that his family is a mistake. Unusual responses for sure.
Okay, that is September the 8th, 2021. Do you recall any interaction with the defendant's son at that point?
I do not.
Okay. Now, do you recall any meetings, check-ins, or phone calls from September to November of 2008 or 2021?
No. So to give context on this, what I did was have a conversation with the teacher to gain a little more context of what was meant by the email. And then the teacher filled me in that the student was actually joking with others in the class, and that it was not at the level of concern that she had believed when she sent the email.
Okay, so if I'm correct, then you received the email, then you made contact with the teacher who sent you the email?
Yes.
Okay, and then the determination was made that no further involvement was required?
Correct.
Okay. I'm going to show you what's... Oh, this is your response. Thanks for the heads up. I'm in senior meetings throughout the day, but we'll try and catch up with him. That was to the same teacher, September 8th, 2021, 9:15?
Yes, that is correct.
This is People's Exhibit 200. This is November the 10th, 2021. The same teacher emailed you, "Hi, Sean. The defendant's son is having a rough time right now. He might need to speak with you." Do you recall that email?
I do.
Okay. And tell us what you did when you received that email.
I checked in with the student in the hallway in between classes to just let them know that if they were having a hard time, that I was available to talk to.
Okay. And here's your response at 4:44 p.m. "I'm sorry, I was in a meeting through the end of the day. I'll catch up with them."
Yes.
So you recall that interaction with the defendant's son?
Yes.
Okay, tell us about that, please.
It was in between classes. I believe the morning after I had responded to this email, and I just spoke to him briefly in passing to let him know that if he needed to talk for any reason, that I would make myself available for him.
Okay. Did you make a decision to contact a parent at that point?
I did not.
Okay. You did not contact a parent?
I did not contact a parent.
And tell us why, please.
Because I wanted to gain any information from the student and allow the student the opportunity to talk. Being sad isn't unusual, but if I had no information other than the student is sad, it's not something I would call a parent over.
And when's the next time you had any interaction with the defendant's son?
November 29th.
Right, I'm going to show you what's been admitted as People's 201. This is an email from a teacher to Mr. Ejak and Ms. Fine, and you eventually were CC'd on this email?
I was forwarded this email.
Okay.
Yes.
And the email says, "Good morning, I had a student during first hour today," the defendant's son, "who was on his phone looking at different bullets at the end of first hour today as I was walking around the room passing out their essays. I didn't get a chance to investigate it a bit further since it was the end of the hour. Now that he's on my radar, I'm also noticing some of his previous work that he's completed from earlier in the year leans a bit toward the violent side. I can bring down these things later today during my 5th hour prep if you would like them." And then it was forwarded to you at 9:34 a.m.?
Yes, it was.
Okay. And then your response was, "Thanks, Jacqueline, I'll be touching base with him as well."
Yes.
Okay, and tell us what happened with this, please.
I ended up going down to Ms. Fine's office, who was on the initial email.
So who's Ms. Fine?
She was our restorative practices coordinator at that time. And she called the student down to her office to chat about the email that had been sent.
Were you present for that meeting?
I was present for that meeting.
Okay, and tell us about that, please.
The student came down towards the end of the second class of the day, and Ms. Fine led the meeting. I was there to be a support for the student in case it became a disciplinary issue, but it was very cordial.
We say support for the student in case it became a disciplinary issue. That's not for you to discipline, correct?
That is correct. I would be there just as somebody who's able to be a comfort to the student during a time where they may potentially be experiencing discipline.
Now, at that point, was everybody wearing a COVID face mask?
Yes, they were.
And in fact, had you ever interacted with the defendant's son without a COVID face mask?
No, I did not.
So you said Ms. Fine led the meeting? I'm sorry, I interrupted you.
Yes, Ms. Fine did lead the meeting. She had a conversation with the student about the email that was received and led it in a way to see if the student would bring any information available based on what the email was received, where she asked him, "Were you looking at anything in class? Were you looking at, what teacher were you looking at this information in class?" to see if he would acknowledge that it was Ms. Kadena who sent the email. He did. He was compliant during that meeting. And the conversation centered around how it was not school appropriate. The student understood, or at least stated he understood, and was returned to class. A phone call was then placed to the student's mom from Ms. Fine.
Okay, and we heard that last week during the trial. That was from Ms. Fine to Jennifer Crumbley?
That is correct.
Okay, and was that a voicemail that was left?
It was left as a voicemail, yes.
Okay. Did the defendant's son indicate that he received a gun for Christmas a few days before?
No.
So what happened next?
In terms of that meeting?
Yes.
The meeting was over, he returned to class.
How long was the meeting?
5 to 10 minutes.
Now, in the realm of either discipline or your role as a counselor, what does it take to move from a check-in to a phone call home?
It can be subjective. Oftentimes it would be if there's information we feel that is necessary for parents to know. Somewhere it's obvious as if you feel the student may be a threat to himself, or if there's any potential that that could be a possibility. if you have concerning information that the student has shared. Or it could just be simply to confirm what a student has said is true.
Okay. So that's a phone call home. What does it take to actually call the parents in for a meeting immediately?
I would have to have a high level of concern that needed parental involvement.
And when was the next time you had any interaction with the defendant's son?
November 30th.
Okay, so that would be Tuesday the next day?
Yes.
All right. So let's talk about the 30th. I'm going to show you People's Exhibit 202. This is an email on Tuesday, November 30th, 2021, 8:05 a.m. From a teacher to you, Ms. Fine. Good morning. I know Jackie emailed you guys yesterday with some concerns about the defendant's son in our first hour class. Today he's watching videos on his phone of a guy gunning down people. It looks like it's a movie scene and not security footage / real event, but definitely still concerning when taking into account some of his other behaviors. Just wanted to keep you guys updated. Do you recall receiving that email?
I do.
Do you remember when you received it?
It was sent at 8:05. I believe I saw it approximately 20 to 30 minutes later.
Okay. And what was your reaction when you received this email?
My initial reaction was frustration of a student that just had a conversation about school appropriate behavior. And I wanted to make sure that I met with him.
Okay. So this is Exhibit 203. This is from another teacher to you at 9:32 a.m. Again, Tuesday, November 30th. Here's the photo I took of his paper in case you need it, with a picture of a math assignment. Now, what happened in between the time you saw this email, it was sent at 8:05, to this email sent at 9:32?
So I was on the phone with other parents at the time I received the first email. And when I was done with that phone call, and Mr. Ejak actually was in my office as I was wrapping up the phone call.
Okay.
He had been presented with a picture of the math assignment from the math teacher and wanted to make sure I was involved in that conversation. I don't know exactly what it was. I know he was showing a picture on a cell phone.
Okay.
I would believe it was the initial one, but I do not know that for a fact. I never saw the cell phone.
That's fair.
So he wanted to involve me in a conversation with the student about the math assignment, and I wanted to talk to the student about the email that had been sent that morning. I do not know if he was on that email, Mr. Ejak was on that email about the watching the video or not.
Okay. So we talked about the email from that morning. We're referring to this email regarding the video.
Yes.
Okay.
So this is the information I had at the time that I was making a decision to meet with the student, and Mr. Ejak had the information that there was a math assignment with something on it.
So at the time that you decided to meet with the defendant's son, you hadn't even seen this picture yet?
That is correct.
Okay.
So
go ahead.
When Mr. Ejak came and mentioned that there was something going on with the student, I made the decision that I was going to go to the math class and retrieve the student. It's less concerning oftentimes for a counselor to walk into a class than a dean because I could be talking about 50 different things with the student.
Okay.
So it just isn't going to raise suspicion for others. So I went to the class and asked the student if he could come with me, and I grabbed the math assignment as part of it.
So you grabbed the math assignment. So it was been admitted as Exhibit 128. Now this math assignment looks different than the one that was emailed to you. Did you receive an explanation as to why?
I didn't know there was a difference initially because for the first 30 minutes, all I had was the actual physical copy.
And that would be this in Exhibit 128?
Yes.
Okay.
Yes. So as I was meeting with the student in the office, I had the email about what had been sent about watching videos, and I had the copy that is currently on the screen of the math assignment. Okay. So I initially asked the student what was it that you were watching in class? Why am I receiving an email from a teacher one day after I know you just had a conversation about what's appropriate in school and what's not? The student told me he was watching a video game on his phone, not uncommon, also not school appropriate, especially given the context of what we had just had in the conversation.
Okay.
So we had a conversation about making that good choice and making wise choices. And then I grabbed the math assignment and I put it in between the student and I. So Mr. Ejak was actually in that meeting as well. He sat kind of off to my right. The student was across from me, across from my desk. And I asked him, okay, so we can talk about, making good choices in the classroom, but let's talk about this. And I put the assignment in between us.
And what stood out to you when you saw this?
Well, I wanted him to explain it to me, but some of the things that actually stood out to me the most were what was written on it. Because I read something like, the thoughts won't stop, and I could read help me underneath it being crossed out.
Is this the part right here that I'm highlighting?
Yes.
Okay.
I read harmless act. I saw what looked like one body, and my initial concern was that this student's drawing some things that lead me to think he might have hurt himself.
Okay.
So I asked him to explain what's on here, because I didn't want it to just be me interpreting what he wrote. I wanted to hear what he had to say about it. And he told me initially that it was a video game, that he liked drawing video game characters, liked that area of entertainment, and that he wanted to go into video game design. So then I told him, okay, you can tell me that, but let's explain these words. Here you write, the thoughts won't stop. Here you write, harmless act. And here you write, I'd have to look at it, I think it was like, my life is useless, or something like that, where he crossed it out.
This part that's highlighted right here?
Yeah, and I said, that doesn't sound like a video game to me.
So I take it then you didn't accept his explanation of the video game?
Not in totality, no, because I wanted to gain more context.
So did you make a decision at that point to do something?
Well, as he continued talking, he then started talking about things that were going on in his life.
What do you mean things that are going on?
Well, he mentioned that school's been tough during COVID, that a family member had passed recently. A family dog had died. He said a friend moved away. And as he was talking, I just kept hearing all these themes of sadness.
What was his demeanor like?
Appropriately sad. It matched what he was saying.
Okay.
And so at that point, I told him, okay, this is a lot that you've got going on, and I want to make sure that we get you help. And so I told him, when I hear all of this, what I do is I'm going to call a parent. And I asked him, is there a parent you'd rather I call? He told me mom would probably be easier to get a hold of. So I called mom first and left a voicemail. This would have been approximately 20 to 25 minutes after the meeting started.
Okay.
So at this point, I just decided that it was enough that I wanted to involve a parent.
All right. You said you called mom first and left a voicemail.
I did.
Did you also call the defendant, James Crumbley?
I did, and it was right after leaving a voicemail. I'm not entirely sure if he answered or not. I think he did, but it was almost like there was just air on the other end.
Okay.
So I wasn't able to leave a message or anything. Mom then called me back a few minutes later, and we talked for, I would guess, 5 or 6 minutes. She was on speakerphone with her son for a brief part of that conversation, and I asked her to please be able to come in, that I had some concerns I wanted to go over. I texted her.
Did you specify those concerns?
Well, I texted her a picture of the math assignment, and by that time I also then received the email that I think you put up earlier of the math assignment.
By this point in time, this was 9:32 a.m. that Ms. Morgan sent it. Was the defendant's son already in your office at that point?
Yes.
Okay. And then, did you have a chance to look at this picture as well?
I looked briefly at it, but I was already on the phone with Mom at that point.
Okay, this is Exhibit 130. This is what we refer to as the original drawing.
Okay.
And you said you were on the phone with Jennifer Crumbley at that point?
Yeah, so I emailed her then the original drawing as well.
Okay, so you sent this to the student's mother?
Yes.
Okay. And did you have a chance to look at this?
I did look at it. Most of it confirmed what I thought was under the scribble outs, and I also noticed some words were added.
Okay. What words stood out to you?
What do you mean?
When you said words were added, what did you notice?
On the one where he added words, I know he added like OHS rocks, or we're all friends here, which I kind of took as just a 15-year-old writing things. It
Okay.
didn't.
So you're referring to this Exhibit 128, some additional words?
Yes, he added video game this is, OHS rocks. I think I love my life so much.
Okay.
Things that were facetious.
And that was after he was seen with this, is that correct? It was after he created this, Exhibit 130?
Yes, it existed in its form as Exhibit 130 prior to the edits that
Okay.
I had seen on the paper.
Now, at some point, did both James and Jennifer Crumbley come to your office?
Yeah, so I ended up being on the phone with Mom for that 5 to 6 minutes. She stated she was going to try and get Dad to come to the office, and she was unable to. And so during that point, we had about 20 minutes where I was sort of just waiting. During that time, I showed the student the list of resources I was going to give to his parents.
Tell me about that, please.
It was about a 3-page list of just different mental health services in the area. On it, it gave contact information for them. It gave specialization areas for them. And it gave oftentimes insurance, if it was accepted, if they worked without insurance, anything that they would work with payment plans.
Okay.
So I wanted him to see what I would be providing his parents.
Was the defendant's son with you from the point that you brought him out of class to the point that James and Jennifer Crumbley arrived at school?
Yes.
Okay. And approximately how long was that?
It was approximately an hour and a half. So around, I want to say a little before 10, probably like 9:45, 9:50, I received another call from Mom stating that she was unable to get a hold of Dad and that she would be coming in.
Okay. Now, if I told you that we saw surveillance video that indicated you welcomed them, both James and Jennifer, in your office at 10:40 a.m., does that sound right?
Yeah, that sounds about right.
Okay. Now, what was your expectations of what was to happen at the end of that meeting?
My hope was that they were going to take him and either take him to get help or even just to take him to let's have a good day. Let's have a day where we just spend time with you, where we are with you.
To take him out of school?
Yeah.
Did you believe that he could be left alone at that point?
I didn't want him left alone. I didn't want to make that decision that he was okay to be left alone. So that's why I stayed with him for as long as I did, until I had parents there.
Did you express to the student or his parents that you identified suicidal ideation?
Yes, I said that the student, when I asked the student if he had a plan, if he was a threat to himself or others, the student said, his words were something to the effect of, I can see why this looks bad, I'm not going to do anything. So I had all this information, but the student was saying he wasn't going to be doing anything. So when the parents came in, I went over all of the things I had seen over my time with the student. That he expressed the sadness over a dog passing. He expressed that COVID has been hard, that a family member passed, that a friend left. He expressed an argument the night before with parents.
Did he tell you details about the argument?
No.
Did he tell you that he received the gun a few days ago?
No.
Tell us about the meeting when James and Jennifer arrived.
It was initially odd to me that they were both there because I wasn't expecting that. But not to the point where I asked anything about it, just it was unexpected. Both parents followed me back to my office. The student, that was the one time he was in there by himself, was when I went out to greet the parents and brought them back. The student and his dad sat across from me, and Mom sat in a chair kind of diagonal from me. And Mr. Ejak had left once we had confirmed parents were coming, and he returned for that portion of the meeting. So really, I felt like parents were confirming what I had said without giving additional information.
Well, hang on, let me ask you about that. You say confirming without giving additional information. I want to make sure I understand what you mean by that. So first of all, you've had these kind of meetings with parents in the past?
I have.
Okay. When you say confirming, is that something that would typically happen in these meetings?
It could, but oftentimes you might gain additional information. As you know, as a school employee, I had 90 minutes.
Okay.
He's 15 years old.
So did James or Jennifer give you any additional information?
No.
So tell me what you did and what was said.
So to start off the meeting, I asked Mom if she had received the phone call from the previous day and that those events were true. She said yes. I talked about how the student had expressed these different areas of sadness, that his dog had passed, yes. Family member had passed, yep. Friends left. And all of those were just confirmed.
Were there any details about the circumstances of the friend leaving and the impact on their son?
I didn't know any details about it. No.
They didn't share any with you?
No.
Okay. I'm sorry. I interrupted again. Go ahead.
It's okay. So a lot of it was, I felt like I was bringing information and they knew it, but I wasn't gaining information. So at that point, I know I handed Mom the list of resources and said I'd like him to get support outside of here. I'd like him to get help and have somebody that he can talk to. And Mom made mention that they would, but they couldn't right away. So I told Mom that I wanted him to get help as soon as possible, today if possible, and was told that wasn't possible.
Okay, told by James, Jennifer, or both?
By Jennifer.
Okay.
James at that time, to my memory, was talking with his son.
Do you recall what he said?
I remember it, yes. He was looking at the math assignment with his son.
When you say math assignment, are we talking about
It's
this
the hard copy.
So we're referring to this, Exhibit 128?
Yes.
Okay.
And he was talking to his son and mentioned that, you have people you can talk to. You can talk to your counselor, you have your journal, we talk. And it felt appropriate at that time, but...
At that point, did he share any details about anything you had discussed?
I don't recall any additional details, no. But my concern at that point was that there wasn't any action happening.
When his wife said that they can't, did he protest that?
No.
So you said you had a concern that no action was happening, so what did you decide to do?
Well, I told them that with getting help, I said I wanted to see movement on within 48 hours, and then I'd be following up.
Okay. So if the shooting didn't occur, what was your plan?
I was going to meet with the student the next morning and see if they had had conversations about it, if they had made some plans to move towards some sort of therapy.
And if that didn't occur, what were you going to do?
I was going to call Child Protective Services.
Now, Generally speaking, within Oxford High School, is it preferred to send the student home when an issue arises, or keep the student at school?
I'm not sure I understand what you mean with that.
So you didn't call the police?
As a counselor, I can't send a student home anyway.
But you didn't want him to be alone?
I didn't want him to be alone. So in this context, my thought was when parents were saying they had to return to work, I wanted to make sure the student was with people. Because my concern was him, was his well-being and his ability to be safe and cared for.
Did James Crumbley elaborate at all on the fight they had the night before?
No.
Now, how long did tell us how the meeting ended.
Jennifer asked if they were done, which felt abrupt. And during that time, the student had also expressed interest. He wanted to go back to class. I asked Mr. Ejak if there was any, like from a discipline standpoint, is there anything you need to do? Is there any reason he can't go to class? And I was told no. So I wrote him a pass to return to his end of his third hour.
Okay. When Jennifer asked, "Are we done here?" did James protest at all?
No.
So tell us what happened as you wrote the student the pass.
I told the student that I cared about him and wanted him to know that I just wanted him to know that.
Did either James or Jennifer say that to him?
No.
Mr. Hopkins, do you have any knowledge of firearms?
Very limited.
Would you know what this firearm depicts? What kind of firearm?
A handgun.
Is that the extent of your knowledge?
Yeah.
What about this bullet here?
A bullet.
Just a bullet? And neither James nor Jennifer said anything about the firearm or the bullet?
No.
Now, you indicated that you passed on a 3-page list of resources for mental health providers?
I did.
Okay. I'm going to show you a screenshot of 137 here. In James's hand, does this appear to be that list of resources?
Objection. I would say that calls for speculation. I don't think Mr. Hopkins knows what's in Mr. Crumbley's hand.
Do you know what's in his hand?
I know that it's multiple pages of paper, and I handed him a stapled 3-page piece of paper.
Okay. Do you see anything in Jennifer Crumbley's hands?
I do not. Or a phone. And something in her right hand, but I'm not sure. Maybe. I see a phone.
Now, in years as a high school counselor, how many times have you had to call a parent in and tell either mom or dad or guardian that you identified suicidal ideation in their child?
15 to 20, over a dozen.
Okay. Any of those meetings, did a parent fail to take their child home?
I can't think of any, no.
Now, you indicated this was a confirming responses from James and Jennifer Crumbley. In those other meetings, were parents sharing information?
Oftentimes, yes. Oftentimes, parents would come in and want to paint a more complete picture of their student, of their situation. Oftentimes, all the time, I feel parents know their kids better than I do. I have, if all I ever did was meet with students, I might have 2 hours a year with each student.
Do you rely upon the parent for that information?
Absolutely.
I have nothing further. Thank you, Judge.
Yes, Your Honor. Thank you. Good morning, Mr. Hopkins.
Good morning.
I'm going to go back to your first interactions with Mr. Crumbley's son. I'm I'm not going to use his name, so if for some reason the way that I'm referring to his son confuses you, just let me know. If we're using too many he's. Does that make sense?
Okay, I will do that.
Thank you. So your first interactions with Mr. Crumbley's son were in the fall of 2020.
Well, fall of 2020. No, it would have been spring of 2021.
Okay. So it would have been before the 2021 school year.
Yes.
And that was for planning his class schedule, is that correct?
That would have been the main reason that we would have met with every freshman. And then I had that email that was displayed earlier from his English teacher.
The May of 2021 email.
Yes.
And after that May of 2021 email, you didn't specifically recall having a meeting with Mr. Crumbley's son.
I don't have memory of that meeting, no.
In fact, you went back and reviewed your records and determined that there appears to have been a phone call. That you called him down to your office?
I called into his class and called him down to my office.
Okay. But you don't remember ever meeting with him?
I don't remember the meeting.
You did not contact Mr. Crumbley or his wife after that May of 2021 email?
That is correct.
So other than discussing Mr. Crumbley's son's class schedule with him and then maybe meeting with him in May of 2021 about that email, you don't recall any additional interactions with Mr. Crumbley's son before November 10th of 2021?
That is correct.
In September of 2021, you received another email from a teacher which was displayed, I believe it was Exhibit 199, which would be an email from a teacher talking about a poem. Am I understanding that correctly?
Yes, that he had a class assignment of writing an autobiography poem.
And he had said to that teacher he'd made some concerning statements in that poem.
Yeah, so if I can give a little more context to this was actually a Spanish class, so the poem wouldn't have even been in English.
Okay. So he used words in Spanish?
That is my understanding after talking to the teacher.
And the Spanish teacher had concerns about the Spanish words that he used?
That is my understanding based on the email. I also followed up with the teacher and gained further context about it.
Right, and as a result of gaining further context, you were not concerned?
Because the teacher lowered the level of concern for me, yes.
So even though your response that you were going to catch up with Mr. Crumbley's son, even though that's in the email, you didn't actually meet with him because you had the conversation with the teacher?
That is correct.
Again, you didn't notify James Crumbley or his wife about the teacher's concern in September of 2021?
No, I did not.
And you didn't forward them the email?
No.
And that was because in your mind, based on the information that you had, there was nothing to be concerned about?
Well, I just gained further context from the teacher and made the decision based off of that information.
And had no concerns?
I think that you're putting those words in to make it a little more extreme, but what I would say is I gained context and made a decision based off of that.
And if you had been concerned, if you had had sufficient concern, you would have reached out to Mr. Crumbley or his wife?
If it had raised a level of concern where I felt I needed to, I would have, yes.
So then on November 10th of 2021, you received another email from a different teacher?
From the same teacher.
Oh, thank you for correcting me. It was the same teacher. She asked you to check in with Mr. Crumbley's son on November 10th.
She said he might need to speak with you.
And she said that she believed he was having a hard time?
She said he's having a rough time right now. He might need to speak with you.
The next day, you responded and indicated that you would check in with him.
Later that evening, after the school day was over, I responded, I believe.
So you obviously couldn't have met with him that day because the school day was over, correct?
She sent the email at the end of the school day, and I responded approximately 2 hours after the end of the school day.
So you couldn't have met with him that day because the school day was over. Is that fair?
He would not have been there.
So you would have met with him the next day?
Yes.
And do you believe that you did meet with him on November 11th?
Yes.
You spoke with him in the hallway?
Yes, I caught him in between classes.
You simply told him that you were available if he needed to talk?
Yes.
There was no further discussion with him at that time?
No, because the way the email was written was that he might need to speak with you. So I just wanted to let him know that there was an opening if he wanted to speak with you.
And having a rough time, like the teacher indicated in her email on November 10th, having a rough time isn't necessarily something that raises red flags. Is that fair?
I didn't have any other context as to what was going on, and I just wanted to offer a chance for the student to speak if he needed to do so.
And his response, if you recall, was something along the lines of, okay, thanks, okay. And I'm not asking you to quote him because I don't know if you remember, but it was not an uncommon response. Does that make sense?
Yeah, it was a normal response given the situation.
You did not email James Crumbley or his wife about that November 10th email, correct?
I did not email them, no.
Or the November 11th brief meeting with their son?
Correct.
You did not forward that email to Mr. Crumbley or his wife?
I did not.
So then the next interaction that you had with Mr. Crumbley's son was on November 29th of 2021, and that was a Monday, if you recall?
Yes, that would have been a Monday.
You were forwarded another email that was sent to Nicholas Ejak and Pamela Fine. Is that correct?
Yes, I was.
And this is the third email you've received from a teacher since the school year began, if you recall.
Yes, it would have been.
September of 21, November 10th of 2021, and now November 29th of 2021. The email advised that Mr. Crumbley's son was looking at bullets on his phone at the end of class.
Could I see the email?
Yes. Exhibit 201.
This is just the forward, so it doesn't have the actual email.
You were advised that that was the concern, was that Mr. Crumbley's son was looking at bullets on his phone.
I believe that to be true, but this email you have on the screen isn't the one that says that.
Correct. The email doesn't say it, but you were aware that that's why the teacher was concerned, and that's why the teacher was emailing. I don't know if that's in the email.
That email was displayed earlier, I think. It was sent to Mr. Ejak and Ms. Fine.
That was the one.
It's at the bottom.
Oh, there we go. There we go. Thank you.
Yeah, so this is the email I was forwarded. And it just was at the end of the hour. The teacher didn't get a chance to really find out what was going on, but it just glanced at it and had seen that.
And I'll leave that up in case you need to look at it.
Thank you.
So you were aware that on November 29th of 2021, at the time you received this forwarded email, that Mr. Crumbley's son was looking at bullets on his phone in class?
Yes, after reading this email, I was aware.
At some point, well, let me go in order. Shortly after this email, you then met with Mr. Crumbley's son and Pamela Fine.
Yes.
And you met in your office or Ms. Fine's office?
It was in Ms. Fine's office.
And you were there just as support, but Ms. Fine did most of the talking. Is that fair?
Yes, I would say that was fair.
And Ms. Fine talked to Mr. Crumbley's son about looking at bullets on his phone?
She did. She actually asked him to describe why would a teacher be contacting me right now. And the student was forthcoming in what had happened in class.
He was forthcoming. He was honest, to your knowledge, right?
To our knowledge, he shared what we had in the email.
He told you what class he was in looking at bullets. He said he was looking at bullets, and he even explained why he was looking at bullets, if you recall.
He said that he and Mom had been at the shooting range over the weekend, and he was researching what they had done.
And if you recall, Ms. Fine acknowledged that what Mr. Crumbley's son was doing may not have been appropriate, but there really didn't seem a lot of concern. Would you agree with that?
Well, the concern was that it wasn't appropriate, and that the concern was then expressed by placing the phone call home.
So the concern was the appropriateness of the behavior in class?
Yes.
And at that point, a voicemail was left for Jennifer Crumbley?
Yes.
You said that, if you recall, Mr. Crumbley's son was understanding during the meeting. He didn't fight with you about it. He listened, and eventually he went back to class.
Yes, I would agree with that.
Later in the day, you received an email from the same teacher who expressed that some of Mr. Crumbley's son's prior work may have been a little violent.
No, that was in the same email.
It's in the same email?
It is.
Or was it in an email sent later in the day?
No, it's in the same email from that morning. It was up on the screen. It's at the bottom of it.
The one that was originally sent to Mr. Ejak and Ms. Fine?
Yes.
That was later forwarded to you?
Yes.
You didn't see any of those assignments prior to meeting with Mr. Crumbley's son?
That is correct.
If you had seen those assignments, it probably wouldn't have changed your approach to the meeting, correct? Because the approach was really more about the appropriateness of the behavior. Is that fair?
I mean, it's a hypothetical of what we would have done. We acted on the information we had.
And the information that you had was that he was looking at bullets in class?
Yes.
And looking at bullets is not necessarily something that is in itself concerning to you, correct?
I think you're kind of trying to put it in like a pigeonhole. We were trying to gain context of what was going on in the situation. Because a student looking at something on their phone at the end of the hour is different than a student brazenly doing it throughout the entirety of the class. But our conversation was, is this school appropriate or not?
And in fact, if you recall, your position was at the time, it wasn't necessarily concerning because he was honest about it. It seemed kind of a commonplace thing given the Oxford community and the gun culture in the Oxford community and things of that nature that you took into a factor.
We took a lot of things into a factor, including the fact that we conversed of how it was not school appropriate. And that's why a phone call was placed home.
As I just indicated, the Oxford area was and may still be a hunting community if you know.
Okay.
I'm asking.
People hunt who live at Oxford.
In 2021, you would classify it as a hunting community.
I would say that there are people who are hunting, yes.
Activities with guns were a common hobby in 2021, if you know.
I mean, there were people who had guns as a hobby, yes.
It was common for students to be interested in guns?
I'm sure there are students who are interested in guns.
And to go to the shooting range?
Yes, students would go to the shooting range.
I'm just going to object to make sure that the witness is speaking with personal knowledge. It appears counsel is asking him to give general speculation.
Well, if you know, if you know, you're not familiar with guns yourself, it sounds like. So just if you know.
Okay.
Students going to the shooting range isn't viewed as unusual or concerning in and of itself. Is that correct?
I think that you've got to have context with all of these.
Right, and I'm just asking, in and of itself, a student going to the gun range, the shooting range, is not concerning in and of itself.
It depends on the context. Because the student weightlifting is not concerning in and of itself unless they're doing it inappropriately, right? So you're taking something that's a broad statement that can have a wide context.
And on November 29th of 2021, Mr. Crumbley's son told you and Ms. Fine that he'd gone to the shooting range with his mom the weekend before.
Correct.
That in itself is not concerning to you.
He did it in a way that was appropriate.
You would agree, and can you refresh my memory, how long were you in the Oxford School District as of 2021?
7 years.
And in that 7 years, you learned that many households had firearms in the household. Would you agree with that, if you know?
What is many? There are people
More than
who own
10?
guns. There are people who own guns.
Okay. And you, as a counselor at the school, you were aware of that?
Yes.
It wasn't completely unheard of?
No.
It was also relevant when looking at the situation, it was also relevant for you to note the fact that Mr. Crumbley's son was not hiding that he was looking at the bullets, or didn't hide it from you when he spoke with you and Ms. Fine.
Well, he didn't lie about what had happened.
And that was important to you?
Yes.
As a result of the meeting with Ms. Fine, with you and Ms. Fine, Mr. Crumbley's son was not disciplined.
To my knowledge, no.
There was a phone call placed to his mother, which we've talked about. There was a voicemail left. You did not yourself call Mr. Crumbley.
I did not.
You did not forward him the emails that you received.
I did not.
You don't know if that voicemail was ever shared with Mr. Crumbley. Is that fair?
Well, we talked about it in our meeting the next day.
Okay. On the 29th, you don't know if Mr. Crumbley was ever made aware.
I would have no way of knowing that.
Right, you wouldn't know. You responded to the situation of Mr. Crumbley's son looking at bullets on November 29th on his phone with the information that you had.
I did.
And from what you knew at the time, other than the behavior being inappropriate for school, you didn't see anything else that might have been concerning.
Well, and I want to make clear, I wouldn't be the one doing discipline in this situation. So...
And I'm asking, and let me clarify, I'm just asking from a counselor's perspective. I'm not asking for discipline. You clarified that Mr. Eject did discipline in this
okay. So could you repeat your question, please?
Yes. As a counselor, on November 29th of 2021, you didn't see anything overly concerning about what we've just talked about with looking at bullets on the phone. That the focus was more that looking at bullets on his phone was inappropriate for school.
So are you asking from a mental health standpoint, did I see anything concerning?
Not really. I don't know that you're a mental health professional. I mean, you're a school counselor and you do have some training and education in that. I'm not asking for you to go anywhere outside of your education and experience. Just as a high school counselor, sitting in Ms. Fine's office with the information that you had, you didn't see a bunch of red flags. We've talked about, and let me give you some, let me go over it a little bit. You've discussed that you know that there are households in Oxford that have firearms in them, right?
Yes, there are.
You know that people in Oxford hunt.
Some do, yes.
You know that students are interested in guns.
Some can be, yes.
You know that students look at bullets.
We had one student who did that in that situation, yes.
You know that that student, Mr. Crumbley's son, was honest about looking at the bullets when he was asked about it.
To the extent of our knowledge, yes, he was.
He told you that he'd gone to the shooting range with his mom.
Yes.
The weekend before. Yes. Those things were not concerning to you.
Taking those things in a vacuum is why we called home. That's why Ms. Fine called home.
And she said, we had this meeting, we told him it's not appropriate, he understands, no need to call back unless you have questions, right?
I don't remember the exact voicemail that was left.
The voicemail was not, we need you to come to school right now.
To my memory, it was not, but again, I don't remember the exact voicemail that was left.
On November 30th of 2021, you received another email. It's this one, Exhibit 202, which was from another teacher who was talking about Mr. Crumbley's son looking at a video of a guy gunning people down. Correct?
Yes, so this teacher was a co-teacher in that same first hour class.
From the day before?
Yes.
Okay. You reviewed that email on November 30th of 2021.
I did.
You made the decision to, I think you said you didn't see it for about 20 or 30 minutes.
I didn't. I was on the phone and I actually responded to it while I was on the phone. And then upon ending that conversation, was going to go meet with the student.
And this is the fourth email that you've received about Mr. Crumbley's son since the beginning of the 2021 school year.
Yes.
The third email in 2 days.
Is it?
You would have received
I think it's the second in 2 days.
The November 29th email about the bullets, and then do you recall receiving a follow-up email later that day?
It was a confirmation of that.
Okay.
Yeah, so this is the second one with additional information.
Okay. The second one on a different issue, is that fair?
Yes.
Okay. The teacher described the video as a movie scene but not a real event.
Yeah, she said it looks like it's a movie scene and not security footage / a real event.
She expressed some concern based on, quote, some of his other behaviors.
Yeah, but definitely still concerning when taking into account some of his other behaviors, yes.
You did not forward this email to Mr. Crumbley after you received it.
Well, no, but over an hour later, I called him into the school.
Right. And you decided after receiving this email that you were going to meet with Mr. Crumbley's son.
Yes.
Approximately an hour after receiving this email, Mr. Ejak advised you of another report made by a teacher about Mr. Crumbley's son.
Yes, as I was about to go and call down his son, Mr. Ejak actually came into my office with information about the math assignment.
And that there were some concerning comments and markings on the math assignment.
I didn't have any context about the math assignment. I just knew there was something about it.
At that point, you hadn't seen it. You were just going off of what you were being told. Is that fair?
That is fair.
Okay. So you went to Mr. Crumbley's son's classroom.
I did.
You called him out of class.
I walked to his classroom.
Yeah, when I called out, I meant like at his classroom you went and got him.
Yes.
Okay. While you were there, you also obtained a copy of the worksheet that we've seen.
I did.
And that would have been what I call the modified worksheet. That would be the one that had the things scratched out and the words added that you identified and things like that.
Yes.
Okay. You and Mr. Crumbley's son went back to your office where Nicholas Ejak was waiting in your office, if you recall.
Yes, that is correct.
It was at that point or shortly thereafter that you called Mr. Crumbley's wife.
Approximately 20 minutes into our meeting, yes.
So you met with Mr. Crumbley's son for about 20 minutes.
Yes.
It was during that meeting that Mr. Crumbley's son told you about his family member passing away.
He did.
About his dog passing away.
Yes.
About his friend moving away.
Yes.
Talked about COVID being hard on him.
Yes.
He had a hard time with virtual school, if you remember.
He did say that, yes.
And you asked about the drawings and the markings and the things on the assignment that you had in front of you.
Yes, I asked him to clarify what was going on in the assignment, but I also talked about the email I had received, and I had also talked about in context of the conversation we had yesterday.
Okay. So some of the meeting was about inappropriate behavior. Is that fair?
It started off with a conversation about that because I didn't know what was on the phone. So I asked him what he was watching.
Okay.
And then we talked about, look, we just had a conversation yesterday about appropriate behavior in class. This feels like the same thing that we're dealing with here. And after we had talked about that for a few minutes, I brought the math sheet out and asked him to start explaining to me what was on there.
And when the prosecutor was asking you questions, you said initially when you got that email around 8:30 when you saw the email from the teacher, initially you were frustrated. In fact, you used the word frustrated.
I was frustrated.
And it was kind of like, we just talked about this yesterday. Does that kind of explain what you were feeling at the time?
Yes, I would say that it was, we just had a conversation about this. Why am I hearing about something similar again?
So you talked a little bit about that, and then you talked about the homework, or the math assignment or the math paper that we saw, and you asked for some more context about what was on the paper.
Well, initially I asked him to just describe what was on the paper, and he started talking about how it was a video game, that he liked designing them, liked drawing them. And then I asked for him to explain the words on it, because I didn't feel those were as easily explained by simply stating, well, it's a video game.
And in fact, you said that you didn't want to give context to his words. You didn't want to assume what he meant. You wanted to hear from him what those words meant.
Yes.
And he gave context.
He did. That's when his demeanor changed from kind of being like, what do I have to say to get out of here and to stop getting in trouble, to he became sad.
And you used the word appropriate to describe his level of sadness based on what he was telling you.
The way he was acting matched what he was saying. To me, it's sad if a family dog dies or a family pet dies. It's sad if a relative dies or a friend moves away. So his demeanor matched what he was saying.
And again, in and of itself, being sad is something that you talked about you saw an increase of after COVID in your students. Do you recall that?
Yes.
And that was not, again, in and of itself. And I'm not asking you I'm not trying to trick you by asking these questions. I'm not trying to give meaning to something that isn't there. I'm asking you, based on the information that you had at the time, you felt that his sadness was an appropriate level of sadness, not overly concerning. We'll talk about it a little bit more, but the sadness itself was not necessarily overly concerning beyond wanting him to talk with someone.
Appropriate and concerning are two different things.
Okay.
When I say appropriate, I mean it matched with what he was saying. Something can be an appropriate response, but also be heavily concerning, right? Like, I don't know a good example off the top of my head, but what I'm saying is his demeanor matched with what he was saying, but to me it was concerning, which is why I called parents.
Right, exactly why you called parents. So if he had been sitting in front of you and talked about these losses and was kind of like, yeah, it's no big deal, it's not a big deal, that could also be concerning.
It would be a different type of concern,
okay.
Yes.
If he said, I lost the top to my pen and was crumbling in pieces and falling into a puddle of tears on your floor, that would be concerning, but for different reasons.
It would be memorable. Okay. Concerning, yes.
So the losses that he experienced, you agree, I think we can all agree, were significant.
I think when taken in totality, yeah.
And he was showing you that he was sad.
Yes.
He was also expressing during this meeting that he had concerns about missing class, if you recall.
He did, especially as after classes changed, which is a normal thing. He expressed that he was worried about missing his chemistry class, which was his next class after the math class. So during that time, Mr. Ejak went and retrieved his belongings and went to go get homework for his chemistry class.
And I'm going to go over that in just a second too, but if you recall, and I don't know if you pay close attention to your students' attendance, but if you recall, Mr. Crumbley's son had pretty good attendance.
He did.
He didn't miss school a lot.
No, he did not.
If you recall, his grades weren't great.
No, but he was on track for graduation. He was passing. I believe he was failing one class at the time, and it was not by much.
So he was close to passing all of his classes. One of them he was failing, but close to passing.
Yes.
So his attendance and his grades obviously were not overly concerning to you.
I wouldn't say overly concerning, but a student who cares about class and wants to, he had expressed an argument the night before and wanted to go to class, had expressed, frustration of missing school during COVID and just that entirety. So it wasn't strange at that point to have a student not want to miss class.
Right. That wasn't odd to you at all, given his history. Now, if he were somebody who missed school all the time and was failing all of his classes, he's like, I really want to be in school, I really want to do my homework, you might feel a little differently. Is that fair?
I would say it was in line based on the information I had.
Okay. And you said that after Mr. Crumbley's son expressed these concerns about missing class, that Mr. Ejak went to his first hour class to get the backpack?
It would have been in his second hour class where his belongings were, yes.
So he went, Mr. Ejak went to his second hour class to get his belongings and brought his belongings back to your office?
Yes, this would have been after we had confirmed parents were coming, probably a little after 10 a.m.
He, if you recall, began working on schoolwork, waiting for his parents to get there.
That is my recollection, yes.
Also, if you remember, while you were waiting for his parents, you also began watching some videos with him?
Yep, so he had expressed different things he wanted to do after high school. And he had expressed wanting to go into video game design. I know that when students are waiting for parents, it can be high anxiety time for them. So I wanted to try and engage him as best as I could. So we actually watched videos from the OTEC, the Technical Center campus, where they had programs that were centered around what he wanted to do. So we talked about what it would look like to do an application for them, because he was a sophomore and he would be able to apply for the next school year. And so I did that, one, to kind of just bridge that time that could be high anxiety, and two, if you have any inkling that a student may potentially be displaying any signs of suicide or suicidal ideation, getting a gauge of future plans is crucial. So I wanted to get that gauge as well.
And he did that, and he picked out some videos to watch, is that fair? And you picked some out?
Yeah.
You also asked him during that time if he was a threat to himself or anyone else.
I asked him that earlier.
And that is part of your assessment of the situation, is that fair?
Well, it was a question I felt needed to be asked based on what I had.
And based on your education, your experience, and your training, you know that that's an important question to ask.
In that situation, yes.
And he basically said, I know this looks bad, but I'm not going to do anything.
Yeah, it wasn't said as flippantly, but it was, he understood, like, I can see why this looks bad. I'm not going to do anything.
Okay. So, although you had concerns, you also had the student in front of you reassuring you that he was not going to hurt himself or anyone else.
Based on what he told me, yes.
Mr. Crumbley and his wife arrived at approximately 10:30. I think that there was some time lag between them getting to the school and actually getting into your office of about 10 minutes, if you recall.
Okay, I don't know when they arrived at the school. I know when they arrived to my office.
Their son was in your office when they got there.
Yes.
Mr. Ejak came into the office after Mr. Crumbley and his wife came into your office.
Yes.
Okay. Because at some point he'd left while you were sitting with Mr. Crumbley's son.
He left once we had confirmed that parents were coming.
Mr. Ejak comes back in. When Mr. Crumbley and his wife walk in, I just want to lay the room out a little bit. So there's your desk. You're on one side. On the other side was Mr. Crumbley's son.
Yes.
There was a second chair in front of your desk.
Yes.
Mr. Crumbley sat in the second chair next to his son.
Yes.
And then Mrs. Crumbley sat in a third chair that was available in was it behind Mr. Crumbley a little bit?
So there were two across from my desk, and then there was one that was kind of off on a corner.
Okay.
And that's where she sat.
Your office was not the size of this room, is that fair?
Yeah, that is fair.
Okay. Fairly small?
It's not small. It's a decent-sized office, but it had space where there were two seats across from me, one seat kind of on a kitty corner, a door, and then some space kind of off to what would have been my right as I was sitting in my office.
And Mr. Ejak would have been kind of off to your right, is that fair?
Yes.
Okay, so he wasn't sitting in one of the 3 or 4 chairs with your chair. He was kind of off to the side.
That is correct.
You testified when the prosecutor was asking you questions that while you were talking with Mrs. Crumbley, that you recall Mr. Crumbley was interacting with his son.
I do.
You said that Mr. Crumbley looked at the math assignment, the modified math assignment, because that's the one that you had, that he looked at the modified math assignment with his son.
That is correct.
They looked at it together, and that he showed concern for his son.
Yeah, it felt like he was interacting with his son, and that he mentioned some things that were available for his son.
And we'll talk about that in just a minute. You felt that Mr. Crumbley's interactions with his son, that he was showing the appropriate level of care and caring for him at that point in your office.
Yes, on the surface level, yes. Yes.
You confirmed that Mr. Crumbley's son had gone to the shooting range the weekend before.
I did.
You confirmed that he'd had those losses. He lost a family member, his family dog, and a friend had moved away, that he experienced all those things in the year of 2021.
I also asked, and he had mentioned the argument the night before as well.
And they told you about the argument?
They confirmed that there had been a disagreement, yes.
It's not uncommon for 15-year-olds to argue with their parents, is that fair?
In a surface level statement, yes, that can happen.
Mrs. Crumbley also confirmed that her son had struggled with virtual school during COVID.
She did.
And that confirms what Mr. Crumbley's son had also told you about not liking virtual school.
Yes.
You told Mr. Crumbley and his wife that, well, let me back up a little bit. You told the prosecutor that your hope was that Mr. Crumbley and his wife would take their son out of school, either get him to see someone to talk to, or to go have a really fun day.
My words to them were, I'd like him to to get help as soon as possible today if possible.
And so you expressed to them that you wanted him to get help as soon as possible today if possible.
Yes.
And Mrs. Crumbley said, we can't do today, we have to go back to work.
Yes.
They assured you, though, or at least you felt assured, that they were going to get him help.
They were not against it, and they made it seem as if it would be something that they would be willing to do.
Okay. So you handed these 3 sheets of paper to one of them. They didn't toss it in the garbage, right?
Not in front of me, no.
Right. They didn't scoff about it and say, we're not doing this.
They took the paper.
Right. So you had no reason to believe that they weren't going to get their help, either at some point, get their son help, either some point that day or as soon as possible.
Based on the conversation, no, but that's also why I planned the follow-up meeting with the student the next day, was to ensure that there was some movement.
And you planned the follow-up meeting kind of in, and I don't mean this in a disrespectful way, but you kind of planned that in your head, like this is my next step.
Yes.
Okay. You didn't express that during the meeting.
No.
In the meeting, you expressed that you were going to follow up in about 48 hours.
Well, because when Mom said that today wasn't an option, I said 48 hours then, I'll be following up.
Okay. So in your mind, you had some kind of timing that you were going to follow up to make sure that things were being followed through on. Obviously, we know that first check-in point didn't come. But you told them within 48 hours you wanted something done by the next morning. And based on your meeting, you didn't have any reason to think that Mr. Crumbley or his wife were not going to follow up.
I would agree.
Essentially, you wanted to ensure, and I believe that you expressed this to Mr. Crumbley and his wife, wanted to ensure that their son's situation and his sadness didn't get worse.
Right. I wanted to ensure that we had something that, if left unchecked, could get worse.
Right. So, sitting in the meeting, you weren't concerned necessarily that that day, or even by the next morning, that their son was going to harm himself.
Based on what he had told me, I did not believe him to be actively harming himself, no.
Or anyone else.
Based on what he had told me, no.
Mr. Crumbley's son expressed that he wanted to stay in school.
He did.
He wanted to stay in school for some of the reasons we've discussed. He didn't like virtual school. He wanted to make sure he could stay up with school. He didn't want to miss class. These are some of the reasons that he gave you.
Yes, those were some of the reasons. He really just said that I struggled with virtual school. I want to make sure I'm staying on top of what I have to do.
And that wasn't concerning to you, that he wanted to stay in school?
No.
Obviously, it's not concerning, right?
In that situation, no. It's not, but given the context of what I was hoping, you take the kid's desires into consideration, but at the end of the day, you want a team making that decision.
And if you recall, you had just had 2 virtual days of school, I think the week before.
Yes, leading up to Thanksgiving, we did have days that were virtual.
And we talked about this a little while ago. To your knowledge, if you recall, and if you don't, just please tell me, he'd only missed 1 day of school that school year.
I know he had good attendance. I don't remember the exact days.
With Mrs. Crumbley expressing that she and Mr. Crumbley had to return to work that day, and Mr. Crumbley's son expressing a desire to stay in school, you felt that it was okay for Mr. Crumbley's son to remain in school.
I felt that I was not given full options at that point, because really what I was left trying to decide between was I have parents saying they have to return to work. I have a student that I don't want left alone. And so that's when I asked Mr. Ejak, is there anything from a discipline standpoint, is there any reason he can't stay in school? Is there anything you need to do? And then I made the decision, I made a judgment call based on what I had. I didn't want a student potentially home alone.
So based on the information that you had, you decided that it was okay for him to remain in school?
I decided that that was the best decision I thought I could make on the information.
Okay. on that meeting, Mr. Crumbley's son, to your knowledge, was not contemplating suicide. You said that he had suicidal ideations, but that's different than being actively suicidal.
It is. The student stated that he was not actively suicidal.
You knew that he had been to the gun range with his mom the weekend prior.
Yes.
You knew at a minimum that he had access to a firearm the weekend before because he went to the gun range.
I knew that he had been to a gun range and had used a firearm at a gun range, yes.
You did not ask him on November 30th of 2021 if he had access to a firearm.
I did not.
You had no reason to look into whether or not he had access to a firearm. Would you agree with that? Based on the information that you had.
It's easy to go in hindsight on a lot of things. Based on what my concerns were, I was concerned about student well-being.
And again, you said it's easy to go in hindsight. So we know what happened within a couple hours of this meeting.
Sure.
We all in this courtroom know what happened. It's easy for us to look back and say that different decisions could have been made, right?
I made the decisions I made based on the information I had.
At the time.
At the time.
You don't have the benefit of hindsight at 10:40 or 10:50 a.m. on November 30th of 2021. Is that fair?
I had 90 minutes of information.
You suggested that his parents find a therapist for him to talk to or evaluate him.
I did.
You have had experience with parents who have refused to provide mental health treatment to their child. Is that accurate? Do you recall that?
Off the top of my head, I'm not recalling a specific instance of that.
If it occurred, do you remember testifying previously about that?
I don't know.
Okay. Would reviewing your testimony on that help to refresh your recollection?
If we want to bring it up, sure.
May I approach, Your Honor?
Sure.
Thank you.
If you would like to read the highlighted portions, thank you.
You can just read that to yourself and let us know if it refreshes your recollection. All right?
Thank you, Your Honor.
Yeah, so I had asked, like, if it's occurred, and I say it's not overly common, but I'm sure it does happen. But I'm giving a for instance of what we would do in that type of situation if it were to happen.
May I approach, Your Honor?
Sure.
Thank you. So reviewing, based on what you just said, reviewing the transcript has helped to refresh your recollection.
Well, what I'm stating in the transcript is in a situation where that could happen, that what we would do is involve CPS and make sure that the student is receiving ordinary care.
In fact, the question was...
You told the jury what CPS is.
Child Protective Services would be involved if that situation were to occur.
In fact, the question was, thank you, okay. Had you ever dealt with a kid at school who you felt needed psychiatric care and yet the parents didn't provide it in some fashion or another? Your answer was yes, that had occurred.
And then I go on to explain what would happen in that type of situation.
Right. You said it's not overly common. It does happen. If it did happen, this is what we would do. Correct?
Correct.
And I know I've asked this a couple of times, but you didn't have any reason to believe on November 30th of 2021 that James Crumbley or his wife were not going to follow through and obtain a therapist for their child to talk to.
I didn't have enough time to know if that would happen or not. Given our context of our conversation, no, I didn't have reason to believe that at that time.
If you recall, the meeting with Mr. Crumbley and his wife and their son concluded at approximately 10:50 in the morning.
That sounds about right, yes.
Their son left the room first, if you recall, and went back to class.
Yes.
The shooting began at approximately 12:51 p.m. that day.
Okay.
After you heard that there was a shooter at the school, you did not immediately suspect that it was Mr. Crumbley's son, if you remember.
I did not.
In fact, you didn't suspect that it was Mr. Crumbley's son until you looked into his attendance after the shooting.
Correct.
This is also after Mr. Crumbley's son had already been arrested.
Quite a bit after this.
I'm going to talk about just a few things. Just go back to your direct testimony with the prosecutor. said that calling a parent in is a high level of concern.
Yes.
And that could be a concern for appropriate behavior.
It could be, yes.
It could be a concern for the student's well-being.
It could be.
It could be a concern that the student needs immediate care or help.
Yes.
It could be for any number of reasons. A high level of concern is dependent on the situation. Is that fair?
Yes, I would agree.
Your concern with going to Mr. Crumbley's son's class on November 30th of 2021 is you specifically mentioned that you went because it doesn't basically raise concern or red flags if a counselor goes down to get a student out of class.
Yes, that is true. And I had very little information at that point as to what was going on. So I wanted to make sure to do it. And I knew that the dean wanted me involved in the conversation. So I knew that student support was at least a potential plan at that point.
When you were discussing, you said that you told Mr. Crumbley's son while you were meeting with him before his parents got there that you wanted his parents to get him help. Do you remember discussing that with the prosecution?
I do.
Okay. At that time, Mr. Crumbley's son didn't say, "Thank goodness, I've been begging my parents for help and they haven't given it to me."
I'm not sure many students would.
He didn't say, "I'm glad you're going to ask them because I've asked them and they didn't listen."
He did not say that, no.
He didn't say, I really need this and I'm really glad that you're doing this for me."
He did not.
He didn't say any of that.
No, which also would not be, it's not uncommon for students to not have a big response to something like that.
If he had said any of those things, obviously your reaction would be different when Mr. Crumbley and his wife got to the school.
It would be different information that I did not have, yes.
And when Mr. Crumbley and his wife were at the school, they also didn't say anything about, or Mr. Crumbley didn't say anything specifically about, wow, son, you really did need some help. You've been asking me for it, right?
No.
The discussion was simply looking at the math assignment, the modified math assignment, and then Mr. Crumbley expressing to his son, you know you have people to talk to, right?
That was a piece of it over the 10 minutes, yes.
That they've talked. Mr. Crumbley and his son have spoken.
He did say that they talked.
When discussing the impact of Mr. Crumbley's son's friend leaving, you don't know that Mr. Crumbley's son had ever expressed how significant that impact was on him. Is that fair? Until sitting in your office.
I had very little context, even when he was in my office, over what that was. All I knew was that a friend had left recently and moved, and that was hard.
You indicated on your direct testimony with Mr. Keese that Mr. Crumbley mentioned you have people you can talk to, we talk, and then mentioned something. Your testimony was that his son mentioned something about a journal, or I'm sorry, that Mr. Crumbley mentioned something about a journal.
Mr. Crumbley's statement to my recollection was, you have your counselor, you have your journal, we talk.
Okay. Mr. Crumbley didn't say your journal, you know, the one that's in your backpack.
No.
He didn't say the one that you always keep with you.
No.
He didn't say a color.
No.
He didn't describe it at all.
No.
So, to your knowledge, based on that conversation, you can't say that Mr. Crumbley's son knew what his son's journal would look like if he had a journal, based on that conversation.
No, I had no knowledge beyond that there was an existence of some sort of journal.
One moment, Your Honor.
Sure.
Mr. Hopkins, You made decisions on November 30th of 2021 based on your education, your training, and your experience, correct?
That was a piece of it.
Also based on the information that you had in front of you.
That was a majority of it.
Which included 4 emails from teachers in approximately 2 months regarding Mr. Crumbley's son.
That was a part of it, yes.
Concerns that those teachers had raised.
Yes, that was a part of it.
Much of which you did not share with Mr. Crumbley prior to that November 30th meeting. Is that fair?
Correct. It was shared during the meeting.
Based on all of these things, you did not believe that Mr. Crumbley's son was an immediate danger to himself.
I did not believe that, no.
Nor did you believe that he was a danger to anyone else.
Based on the information I had now.
I have no further questions.
Redirect.
Thank you. Mr. Hopkins, it appears that information and context would be important to you in these kinds of meetings.
Yes, it was.
Okay. Now, did James Crumbley tell you that November 30th wasn't the first time that his son asked for help?
No.
Did James Crumbley tell you that his son asked for help in April of 2021?
No.
Did James Crumbley tell you that, despite that, never once was an appointment with a medical health provider set up?
No.
Did James Crumbley ever tell you that as early as June of 2021, his son had obtained his own firearm?
No.
Did James Crumbley tell you that his son had been begging for a 9mm firearm?
No.
Did James Crumbley tell you that his son actually sent him a screenshot of a 9mm for sale a few weeks before the meeting?
No.
Did James Crumbley tell you that his son actually obtained a 9mm just 4 days before this meeting?
No.
Did James Crumbley tell you that the 9mm he obtained looked identical to the 9mm that he drew right here on this picture?
No.
Did James Crumbley tell you that he worked for DoorDash, he hadn't begun work that day, and he could have taken his son home?
No.
Did he tell you that when his son was talking about his friend leaving, it was actually his only friend?
No.
So you took what you learned from the defendant's son, you described those losses he felt as significant?
I did.
And that's without knowing all of that information?
Yes.
You mentioned that you would hope that a decision about a student would be made by a team.
I did.
Who's on the team?
The student, the parents, and any caring adult with the school.
And did either James or Jennifer Crumbley share any information with you?
They did not.
Had they what would you have done?
Objection, Your Honor. Speculation.
She asked the same question on cross.
Did you ask that question?
She asked, what would you have done? Talking about calling CPS and such.
No, actually, that was related to if they had.
She asked if they had not obtained treatment for their son.
Yes.
By the following day or within 48 hours.
If they had refused, if they had refused to obtain mental health treatment, what would he have done? Not.
I'll rephrase, Judge. That's fine. Mr. Hopkins, you testified earlier that your plan was to call Child Protective Services within 48 hours.
Yes.
And that's based upon just the information that you learned from the defendant's son?
It is.
Would this meeting have ended differently had you known all the other information that we just went through?
Objection, Your Honor. Speculation.
I think it does call for speculation.
I believe he can offer a definitive answer here, Judge.
A definitive answer about what would have happened if they had not contacted a therapist. Is that what you mean?
No, Your Honor. He's asking about a definitive answer for what Mr. Hopkins would have done if there had been additional information. And Your Honor, can we approach? Can we approach, please?
Okay, can you turn off the audio?
All right, we have lost audio. They've turned it off intentionally, so we cannot hear what's being discussed at the stand with Judge Cheryl Matthews and the defense and prosecution attorneys. They are currently questioning a witness. There's been a cross-examination and then a redirect, just clarifying some things, so that audio should be back soon. So Rick, just explain a little bit about their
Thank you, Mr. Hopkins. You were asked on cross-examination that you didn't ask the shooter on November 30th if he had access to a gun. Do you remember that?
I do.
And your response was what?
I did not.
Okay, and did you have reason to ask him about that?
At that time, I didn't feel I did.
And you were asked about the shooter's recitation of what happened at the shooting range with his mother.
Are you stating I asked that?
No, you were asked that.
Oh, by Cross.
Okay, so you learned on November the 29th and November the 30th that the defendant's son went to a shooting range with his mother that prior weekend.
I did.
Did James Crumbley tell you that the shooter actually shot his new gun?
No.
Thank you. I have nothing further.
You can step down when you're excused. You guys need a break?
Thank you, Judge.
All right, so about a 10-minute break.
All rise for the jury.
Are you going to be seated? What's the next one?
We need to find out right now, Judge. We have somebody traveling in, so I want to make sure it's here.
All right, so about 10 minutes.
That'd be fine, Judge.
Thank you, Ryan.
If you could all just remain seated, please. All right, court is going for a 10-minute break. Still with us are Arnold Reed and Rick Convertino. Thank you both for staying with us throughout this. So we just saw the first witness testimony of the day, Sean Hopkins, the school counselor who, as we know, had a meeting with the Crumbley parents, with the student, with the shooter, really moments before the shooting took place. Rick, what stood out to you in this testimony?
Well, this is the most important witness for the defense. Clearly, this and the other school administrator who will testify, the assistant principal in charge of discipline. And so this is a critical witness for the defense to attenuate the information. And she is attempting to draw similarities between Mr. Hopkins and her client, James Crumbley, in the sense that the healthcare professional, the counselor, the person who had information regarding the emails and the damaging drawing in the math test that was provided to him, he had all this information and still believed that the shooter was neither a threat to himself or a threat to others, and therefore didn't take action, which is akin to her saying that that's why the defendant didn't take action either. He didn't have the information, and it was reasonable that he didn't. But I wanted to point out one quick thing. When they approached the bench here, they approached the bench because the prosecution was giving what I've referred to often as a speaking objection, and that's an objection that's improper, and that kind of formulates and focuses to the jury while answering an objection to the court why the information is important, kind of a mini summation as to why the information that's objected to needs to get into evidence to assist the jury. And so the question was asked, basically, if you had all this information, the prosecutor went in redirect and said, you didn't know this, you didn't know this, you didn't know this, and the parents didn't tell you these things, the information they had exclusively. But if you had that information, what, if anything, would you have done? Objection. speculation. Well, that's the clear objection. And then the answer was on the record. Well, Judge, it's important to tell the juror that, you know, what he would have done had he had this information. Of course, the answer would be, I would have immediately taken him out of school. I would immediately, you know, check the backpack, et cetera, all the things that one would have done in 2020 hindsight. In other words, had he had all the information, he would have prevented this horrific act. And that's what the defendant should have done. That was the purpose of the speaking objection. And in this case, unlike the first trial, the speaking objection was cut off by the defense attorney. And the defense attorney said, Judge, may we approach? And that's what was settled at the bench, and the objection. Not in a speaking manner, as the prosecutor has been doing, but she cut it off, and the question was never asked. So now, in practicality, the question was asked, and the question was answered in the jury's mind because they did just what we're doing here. You know, what, if anything, would you have done had you had that information? Objection, and that answer didn't come in, but it really did come in because everybody knows exactly what he would have said he would have done. So critical witness, you know, the cross-examination did all she could. The redirect was good in rehabilitating the witness and showing that the information that he had was limited and that the parents had the additional information, and they did not act.
The redirect felt very effective. His quick questioning and no, I didn't have this information, no. That to me was incredibly effective. Arnold, what was your take on this entire exchange this morning?
Let's start with the defense. I've been saying for the last week, she's got to pick and choose her moments to pounce, if you will. This was a failed opportunity. Her cross-examination was too long. There was no clear message. She was all over the place. She did not control the witness. You could tell the witness's demeanor was much different when she cross-examined versus the prosecution, to the point where it appeared that he was acting a bit. His facial expressions, the way he would hold his mouth and be really, really solemn and sad when the prosecution was questioning him. Recall when the defense was questioning him, oh, I think you're twisting it around a little bit. You need the context for that question. He was kind of controlling the defense attorney. Too long. A lot of attorneys fall victim to cross-examining a witness for an hour. What that does is continue to repeat certain themes, repeat certain things, and it reestablishes his credibility in front of the jury. It should have been swift, quick. She opened the door for the recross or redirect of the prosecution to say those things. Did he tell you this? Did he tell you that? Did he tell you this? That was very, very powerful, and that's going to go a long way, I believe, in the jury's mind. Let's talk about a couple things that I observed here with regard to the defense. Her cross was kind of all over the place. She said, I don't want to go into your mental health background. I know you're not a mental health expert. That's exactly what she should have done. Think about this. You have an individual that's on a witness stand that does have a mental health background, has extensive knowledge, extensive training, and you let him off the hook. You don't examine him on that. You know this kid, just like the 15 or 20 others that come in here and talked about suicidal ideations. And this kid, Ethan Crumbley, you couldn't detect whether he was going to do anything bad or not. Then how could you expect to put that burden on the parents? With this man and his training, his knowledge, his dearth of experience.
Interesting.
But
she let him off the hook, and she should have nailed him down.
Here is one thing that rebuts that, Arnie. I think she did a more effective job than you do. This was a witness who was in a real tough position, because remember, there's civil litigation going on, and he is a focus and target of that civil litigation for his omissions in that area. But he said clearly, you know, I had information in a vacuum, and the information that I had, what did I do? I called the parents. So he was asked several times, you know, you were told that a friend moved. Yes, I was. You were told that his his grandmother died. Yes, I was. You were told his dog died. You were told there was a fight the night before. Plus, he had these nefarious signs. So he had that information. Plus, he had the video of a shooting that was discounted as an Unreal or a video game, but a teacher was concerned about that. You had the drawings on the math sheet. You had the blood everywhere statement, that I need help statement, the gun and the bullets in the drawing. You had this information. What did you do? His answer, I intervened. I took affirmative steps. I took an act. I called the parents in. I notified the parents of what we had. I told the parents that they should get mental health within 48 hours. I took action. Now, the parents who had considerably more information about the damaging, spiraling mental health issues that was confronting their son, the downward spiral since April to November, all of these intervening things, plus additional things that were going on at home that were demonstrated in the text messages, and they failed to act. When they had the opportunity to act, they decided, nope, we can't take them home. And he said, this witness Hopkins said, I was forced into making a decision. I had no choice but to keep them at school. So I think it was an effective cross-examination and the limited ability she had, even though this is a critical witness, and I think the prosecution did a very good job in the direct and redirect.
To piggyback off of that, and I get what you're saying, but this whole answer about I had information in the vacuum, she asked him a direct question. And when he said I had information in the vacuum, she didn't come back and pounce on him and say, excuse me, sir, in all due respect, I didn't ask you whether you had information in the vacuum. I'm asking you specific questions. She let this witness off the hook. This witness then said, I made a judgment call. Listen to this. He met with 15 parents whose children had suicidal ideations. How many took their kids home? He says, I didn't know. What's the difference between, initially, obviously, it's a terrible massacre here, but what's the difference between those 15 children and Ethan? What's the difference? Make him articulate that. Don't let him off with, well, I didn't remember. Based on your training and your knowledge, he let that kid walk out. Now, you're not going to get much mileage at all. I'm not talking about blaming this guy. I'm not talking about blaming the administration. But you have to at least implant in the jury's mind that not only perhaps did dad have some kind of previous knowledge, but he's not a counselor, he's not trained. Yes, he's dad. He was in the hands of somebody who observed him, who has observed hundreds of kids. He counsels over 200 kids. I think she let him off the hook a little bit more than she should have, did not control him, just like he made a judgment call, right? So did dad. And she's got to bring those things up and make her cross-examination a lot shorter. When you were looking at that cross-examination, you ask any of those jurors right now if we could, they didn't get a clear message of where she was going. Well, she was all over the place. And again, open the door for the prosecution to come back. Do you see what the prosecution did? Boom, 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 boom.
It felt very effective.
Pounded her, hit her over the head.
Within 30 seconds.
Exactly, and sat down.
You know, when he was asked about 15 to 20 students who had suicidal ideations, how many went home with the parents, my recollection is, and based on my notes, he said all of them. Maybe one didn't, he said, but then he said he thought all of them went home with the parents. But what we saw too with the defense here, which was similar in the first case, was an empty chair defense. Because initially during the cross it was asked, there are many households with guns, there are many kids that hunt, there are many kids who are interested in guns in Oxford. You didn't send the emails to the father, you didn't send the voicemail to the father, just the mother. So we had this empty chair defense that Jennifer Crumbley had all of the collective information, and I expect that'll be refuted in part by some of these text messages that are still going to come in regarding communications between Jennifer and James, in the morning of the shooting and after the shooting, and conversations of, regarding pulling James back in. Remember, this week is the James Crumbley show, so we're going to have more focus on that. But I disagree with Arnie to some extent. I think all told, and I may be, comparing this subconsciously to the first case, which is, exponentially better by the defense. So I think she did about as good a job as she could do with this witness in getting him to say that he had this information. The information that he had was damaging. He assessed it in the best light that he could, that the shooter was neither a threat to himself or others, and therefore, how could you expect the father and mother to come to a different conclusion? That was the thrust and sum and substance of the cross-examination.
I agree. I mean, I think overall it was a better outing, so to speak, for the defense, markedly improved from what we saw from the previous case. It was interesting. There were some things that were objectionable that I thought should have been raised. For example, when they were even talking about suicidal ideations of other students, that's not really relevant to what's going on here. It should have been objected to, but since she didn't object to it, I'm sitting here thinking she's going to get some cannon fodder out of it, if you will, and just use it to her advantage, and she used it kind of poorly. But there were other things that should have been objected to, and the prosecution got some things out. But again, overall, compared to what we're seeing here, she's trying to put in the juror's mind, but in a long-winded way, that if you didn't know about it, how could the parent have known about it? But it's a much more effective way to do it. But again, overall, she is doing what she can. Everybody knows. I mean, this is David and Goliath battle-wise, right? But she's got to have more than a slingshot to win this one. I mean, especially with that elongated cross. But maybe she will rebound, in my view, with the next witnesses. And again, the key here is not to blame the counselor. The key is to show that they were in a position to know just as much, if not more, than the parents.
And the parents have a responsibility, for their child. The school has a responsibility for every single person in that building.
Right.
And so that it's part of a conversation we've had throughout all these trials, is how much responsibility falls on the school.
Well, how much responsibility falls on the school for the purpose of determining the guilt of James Crumbley in this case is the cold hard truth is it's irrelevant. The school's responsibility here, that's for Attorney Van Johnson and others who are rightfully pursuing civil litigation and liability against the school district, which I think it's clear beyond all peradventure, listening to this testimony and the previous testimony, that the school should be blameworthy for their neglect and omissions. But there's statutory limitations that preclude that right now that are being battled out in federal and circuit court. So it is, but this witness was, between a rock and a hard place, because he is fully aware of his potential liability. He has a criminal defense attorney who's representing him, and so he has, he's walking this line between being forced to testify, which he certainly doesn't want to do. He's testifying under subpoena, and he's also has to be very careful in how he structures his testimony, but be truthful. He doesn't want to go crossways with the prosecutor, but he's also got this, crushing weight on his shoulders about what's coming down the road.
So he will not be privy to share much of anything.
Right.
Yeah.
Yeah.
He'll be very careful. And he said he's on leave. He's still on administrative leave since the attack happened.
Yeah, I listened to that. I thought that was very interesting. We didn't get to hear why exactly.
Well, there was a motion
there was a motion in limine. Rick raises an important point. In the civil case, they're facing potential continued litigation, but when you're suing a governmental official, which all teachers, all principals, all educational personnel, no matter what level, they're considered governmental agents, and therefore they are protected by immunity. You have to prove the concept of gross negligence under a case called Ross v. Consumer Powers. That's the seminal case in the state of Michigan on proving gross negligence. Principals, assistant principals, high-level officials, they enjoy absolute immunity. Absolute immunity. I'm not sure whether counselors fall in that category of absolute immunity, but they do enjoy a certain level of protection that is probably being litigated as we speak. But again, with this particular witness, he was vitally important. Hopefully in closing argument, the defense will be able to tie in some of these points that we have been talking about, short of trying to shift the blame over to him, because I think that would be a huge mistake, a huge mistake. She has to walk a fine line here and just try to analogize the knowledge of trained people and what they did in their judgments call juxtaposed to the parents.
One of the things, Meredith and Arnie, that we didn't hear in the first case was in closing argument by the previous defense attorney was, you heard the testimony of, Joe Bag of Donuts, and this is what he said, and this is how it fits into this case. You heard the testimony of, Jane Willoughby, and she said this, this, and this. None of that happened. Instead, in the first trial, we heard, my kids are, crazy kids, and we get crazy text messages and, all of this personal stuff. And so I think that this attorney will do a much better job pulling in the witness testimony and the holes in the prosecution's case in the closing arguments.
All right, well, Rick and Arnold, thank you so much for providing your insights. We're going to go back into the courtroom in Pontiac. Let's listen in.
Who's the next witness?
Mr. Nick Ejak.
This one doesn't go on automatically.
All rise for the jury.
Yeah, is there a button over there? This one doesn't go on automatically. The other ones.
I got it.
Is there a button on the back?
Yes.
It's, yeah. You may be seated. Who's the next witness?
Nick Ejak.
Good morning. Could you raise your hand? You swear or affirm the testimony about to give is the truth, so help you God.
I do.
Okay, can you step up and have a seat? And then could you state your name for the record and spell your first and last name?
Sure. Nicholas Ejak, first name Nicholaas, last name Ejak, E-J-A-K.
Go ahead.
Thank you. Good morning, sir.
Good morning.
In the year of 2021, where did you work?
Oxford High School.
Okay. And what role did you work there?
I was the Dean of Students.
Could you keep your voice nice and loud?
Sure. I was the Dean of Students.
Okay. And tell us, please, what does the Dean of Students do?
So the Dean of Students is primarily responsible for student code of conduct, so behavior and discipline, overseeing the attendance of the school, academic intervention, behavior intervention.
Okay. So Mr. Hopkins just testified, and he indicated he was a counselor, whereas you are the Dean of Students. So it would be fair to say that you handled discipline, whereas he handled the student advocacy?
Yes.
Okay. As of November of 2021, how long have you been in that role?
Just about 4 months.
Okay, so you were hired for that school year in the fall of 2021?
Correct.
Now that's part of administration, is that correct?
It's an extension of it, yes.
Okay. Was James Crumbley's son a student at Oxford High School in November of 2021?
Yes.
Prior to November of 2021, did you have any interaction with James Crumbley's son?
I did not know.
I want to direct your attention to what's been admitted as People's 201. This is an email from November the 29th, 2021, 9:32 a.m. And the email reads, "Good morning. I had a student during first hour, the defendant's son, who was on his phone looking at different bullets at the end of first hour today as I was walking around the room passing out their essays. I didn't get a chance to investigate it a bit further since it was the end of the hour. Now that he's on my radar, I'm also noticing that some of his previous work that he's completed from earlier in the year leans a bit toward the violent side. I can bring down these things later today during my 5th hour prep if you would like them." So you and Miss Pamela Fine were both on that email?
That is correct.
Okay, and tell us, please, who's Pamela Fine?
So Ms. Fine is the restorative practices coordinator and the anti-bullying coordinator for the school district.
Okay, and tell us a little bit, if you know, what that role entails.
Sure. So restorative care and anti-bullying across the district, she would be working with students to restore situations between two different students, a student and a teacher. It deals a lot with behavior, and so it's more of like, how do you fix or repair the situation? And so she often would collaborate with me on student discipline, and then the anti-bullying programming for the district would be like mentoring kids together to prevent bullying and to report it, when they see it, and it's more of a proactive approach.
Okay. So correct me if I'm wrong, but it sounds like you, Ms. Fine, and Mr. Hopkins have separate roles, but sometimes they intersect.
Absolutely, yes.
Okay. Now, did you have any interaction with the defendant's son on November the 29th of 2021?
I did not know.
Okay, and tell me what happened after this email was received by you.
So it was received by me when I was in a meeting that morning. So I wasn't made aware of it until after there was a meeting that took place between Ms. Fine, Mr. Hopkins, and the defendant's son.
Okay, so by the time that you had read this email, that situation had already been addressed by Ms. Fine and Mr. Hopkins?
That's correct.
Okay. Did you have any follow-up emails, conversations, or any other interaction regarding the defendant's son or with the defendant's son on Monday, November the 29th?
I did not know.
I'm going to direct your attention now to Tuesday, November the 30th, 2021. This is People's Exhibit 203. This is from a teacher in the school. Email sent Tuesday, November 30th, 2021, 9:32 a.m. It's addressed to you and Mr. Hopkins. Reads, "Here's the photo I took of his paper in case you need it. Signed, Becky." And there's an attachment. Did you receive this email?
Yes, I did.
Okay, tell us about your interactions with either students or administrators prior to receiving this email with regards to the defendant's son.
So I had received this email after I had alerted Mr. Hopkins to the worksheet because this teacher brought a photo of that.
Okay, let me back up just a little bit. So before this email was received by you, did you have a conversation with a teacher regarding the defendant's son?
No, I did not.
Okay, so tell me how it is that you became aware of this math worksheet.
So the morning of November 30th, 2021, I was in my office when Miss Morgan, who was the teacher that sent this email, came down to our front office looking for anybody that she could speak with about a student that had drawn some inappropriate things on a worksheet.
And you were there?
I was the only one available at the time, yes.
Okay, and tell me about that interaction, please.
So she entered the threshold of my office door and said she was just looking for somebody to report something, and so I had waved her into my office, and she had stated that there was a student that had drawn some inappropriate things on a worksheet, and then she proceeded to turn her phone around and show me a photo of the said worksheet.
Okay, so this is Exhibit 130. Do you recognize this?
I do, yes.
And how do you recognize it?
That's the photo that was on her phone.
Okay. And so she turned her phone around and shows you this?
Yes, that's correct.
And tell me what happened next, please.
So I briefly read the statements and looked for a name in the corner and noticed that it was a name of the student that had been in the meeting with Mr. Hopkins and Ms. Fine from the day before.
Okay, so you looked at the worksheet, what stood out to you when you first saw it?
The phrases that were written on there.
Specifically, which ones?
The thoughts won't stop. Help me. The world is dead.
Okay. What happened next?
My response to her was, I need to get his counselor. And her response to me was she needed to return to class.
Okay. So she went back to class?
Yes.
And then what did you do?
I walked down to the counseling portion of our front office to alert Mr. Hopkins.
Okay. And tell us about the interaction you had with Mr. Hopkins.
Sure. So when I arrived to his office, before I even mentioned anything, he brought up the defendant's son in sort of a question form, and my response to him was, yes, how did you know? And then he proceeded to share with me that he had received an email that morning regarding that student and thought that that's why I was there at his office. And then I had shared with him that I had just been shown a photo from Miss Morgan.
Okay.
And kind of explained what I had saw on the worksheet. And he immediately stood up from his desk and said, I'll go retrieve him from class.
Okay, so he received a different email the morning of November 30th than the picture
Yes.
that you were shown?
Yes.
Okay. Now, when you saw this picture, were you considering this in the realm of student discipline?
Not at all, no.
Okay,
I
so
was more concerned that there was a mental health concern.
Is that why you decided to get his counselor involved?
Yes, that's correct.
Okay. So after you shared what you learned with Mr. Hopkins, he went and retrieved the student back to his office?
Yes.
Okay, and tell us what happened next, please.
So I waited in Mr. Hopkins' office for him to return with the student, and he came in and sat down and began to kind of talk through what was going on that led him to write those things on his worksheet and draw some characters on there. And the defendant's son repeatedly made sure that we were aware that he understood why we needed to do this and that it made sense and that he understood how bad it looked.
Okay. Did you lead that interaction with the defendant's son, or did Mr. Hopkins?
Mr. Hopkins did.
And why is that?
As the school counselor, therefore, looking into a potential mental health concern, that would be his responsibility.
Okay. Did your perspective, based upon the information that you were told, ever change from a mental health lens versus a discipline lens?
It did not, no.
So tell us what happened next after the defendant's son went through the drawing with Mr. Hopkins?
So he had sort of explained that he was interested in video games and that part of those drawings on there were him trying to get into graphic design, which led into a little bit of a conversation about how there could be potential avenues during his time at Oxford High School to delve into that deeper with some other programs. And then he kind of leaned in more towards the statements that were written on there and talked about how those didn't necessarily explain the video game aspect. And then I listened to the defendant's son speak about him feeling sad lately, which in high school is not that unusual.
Were you involved in the decision to contact the parents of the student?
I was there for it, but Mr. Hopkins had mentioned that we were going to reach out to his parents.
Okay. At some point, did you leave Mr. Hopkins' office?
Yes, that was after we were able to speak with a parent on the phone. And so I left to retrieve the students' belongings since our class periods had changed.
Okay. At that point in time, COVID protocols were still in place?
Yes.
Okay. Did students carry their backpacks with them?
Yes.
Okay. So you retrieved the defendant's son's backpack from the class that he was in and brought it to Mr. Hopkins' office?
That is correct, yes.
Okay. And did the defendant's son stay with Mr. Hopkins until his parents arrived?
Yes.
All right. Were you there in Mr. Hopkins' office the entire time, or did you come back in?
No, I came back in once the parents had arrived for the meeting.
Now, what was your expectation of what was to happen that day after the meeting with the parents?
My understanding and expectation was that, based on the recommendation from the counselor, that the student would be leaving that day, based on prior experiences at schools where parents are called in for to talk about student mental health. Typically they leave when it's suggested that they leave.
With the student?
Yes.
You were there for the, how long, first of all, how long did the entire meeting last between James and Jennifer Crumbley and Mr. Hopkins yourself?
I was there for 10 minutes of it, and it had there had been maybe 3 or 4 minutes prior to my arrival.
Okay.
I'm not sure if they waited for me to start or if they had already begun, but I know that I arrived a few minutes after they did, after I was alerted that they had arrived.
So were you there when Mr. Hopkins explained his concerns about the drawing?
Yes.
Okay. Now, he just testified, so I don't need you to go through everything he said, but do you recall if James Crumbley said anything?
During the meeting?
Yes.
He did. He expressed concern for his son, that he knew, or he reminded his son that he could always speak to him about stuff, and that he had a journal that he could write stuff in if he was feeling frustrated or going through something.
Now, as a dean of students, when are you permitted to search a student's personal belongings?
So when I have a reasonable suspicion that the student might have something illegal or something that's not allowed at school, and so there needs to be some sort of sign, like a report from somebody. Oftentimes kids will be seen with it, or they'll be showing whatever the things are that they brought to school they're not supposed to. There needs to be some type of a suspicion or alert that I have that will allow me to do that. Okay. And so in this situation, there wasn't something that alerted me that indicated I needed to search.
Okay, and why
not? Nothing that he said, nothing that none of the behavior that he exhibited when I returned with his bag indicated that. There wasn't any suspicion that I had at the time that allowed me to believe I needed to do that.
At any point were you informed about the defendant's son's access to weapons?
I was not, no.
Okay. Were you given details by either James or Jennifer Crumbley about the words and drawings on this exhibit? 130?
I was not.
Thank you. Beth, finish.
Thank you, Your Honor. Good morning.
Good morning.
Prior to becoming the Dean of Students at Oxford High School, you worked in various schools and school districts. Is that correct?
Yes.
For most of your career, in fact, you worked with at-risk students.
Yes.
Normally, that includes students with some sort of academic or behavioral problems.
Yes, that is correct.
In fact, your role at Oxford High School, you testified today, primarily you dealt with the code of conduct.
Yes.
Behavioral and academic intervention.
Yes.
And issues with attendance.
Yes.
You had not had contact with Mr. Crumbley's son until November 30th of 2021.
That's correct.
So, as far as you know, once you became employed by Oxford High School, there were no behavioral issues with Mr. Crumbley's son?
There was not.
No academic issues? No attendance issues?
No.
You learned on November 29th of 2021 that Mr. Crumbley's son was looking at bullets on his phone in class.
Yes, that is correct.
But once you had been made aware of it, or once you learned of it, you learned that that had already been handled by Mr. Hopkins and Ms. Fine. Is that correct?
That is correct.
So you didn't do anything else with anything that day?
No.
Okay.
I didn't need to do anything further based on the fact that Ms. Fine and Mr. Hopkins did everything that I would have done in that situation.
Okay. So you didn't see any need for additional discipline or any additional intervention or anything like that, correct?
That's correct.
On November 30th of 2021, you were advised by one of Mr. Crumbley's son's teachers that he was writing inappropriate statements on his on a math assignment.
Yes.
You were quickly shown a picture of the assignment on a cell phone, if you recall.
Yes.
You didn't look at it very well, correct?
No.
You saw that there were drawings.
Yes.
But you didn't see necessarily what all the drawings were. Is that fair?
That's fair, yes.
You did see the words blood everywhere.
Yes.
But you didn't see much beyond that.
That's correct.
To you, the words on the page were more concerning than the drawings themselves, right?
I would agree with that, yes.
And that's because sometimes kids in high school draw violent things.
Absolutely, yes.
That's not abnormal.
That's not abnormal.
You felt that what was on the paper was not appropriate for school, is that correct?
Yep, I would agree with that.
But that it wasn't in and of itself concerning.
Yes.
And that you didn't see it as a threat to anybody.
That is correct.
You didn't see a correlation of violence with the drawings on the paper?
I did not know.
Again, Mr. Crumbley's son had no prior disciplinary history.
He did not know.
No prior bad behavior.
He did not.
He was a pretty average student.
He was, yes.
He'd only missed one class that year.
I can't speak to that.
You said you dealt with attendance, so that's why I was asking.
Sure.
So you're not aware of his attendance
I'm not
history?
aware of specifically his attendance.
Okay. He had none of the typical early indicators that there would be an issue of concern other than these isolated incidents from November 29th and November 30th that you were aware of.
Judge, I'm just going to object to the form of the question. Typical indicators. This witness can testify regarding code of conduct and discipline, but that's it.
Yeah, unless he is able to testify about what a typical indicator would be, or by his experience.
And I can ask him that, Your Honor. Based on your experience dealing and your education and training with at-risk students and for your position as the Dean of Students, there are what you would consider early indicators of potentially concerning or threatening behavior. Is that fair?
I would say that's a fair statement.
Some of those include prior disciplinary history,
Yes.
prior bad behavior by the student,
Yes.
issues with grades,
Yes.
issues with attendance.
Yes.
Okay. So knowing all of that, none of those, what I'm calling early indicators, were present other than the two incidents that you were aware of on November 29th and November 30th of 2021.
As far as I was aware, yes.
Okay. You sat in on the conversation between Mr. Hopkins and Mr. Crumbley's son on November 30th of 2021.
Yes, I did.
And that was before his Mr. Crumbley and his wife got to the school.
That's correct.
Based on the information that you had at that time, you did not believe that Mr. Crumbley's son posed a threat to anyone.
That's a fair statement, yes.
You were even less concerned after you confirmed some of the information that you'd learned from Mr. Crumbley's son with Mr. Crumbley's wife.
Yes, after she had confirmed all the information he shared with us, my concern from a discipline standpoint was pretty much lowered all the way to none at that point.
Okay. And you said all of the information that he had shared with you. And we've heard some about that, but I just want to confirm. That was about the losses that he'd experienced in 2021, correct? The loss of a family member?
Yes.
The loss of his family dog?
Yes.
A friend had moved away?
Yes.
He'd struggled with COVID?
He did, yes.
He had a hard time with virtual school?
Yes.
Those were the things that you confirmed with his family, with his parents?
Along with his desire for graphic design and video games, and that they thought he should focus more on academics rather than that, which is what he had shared with us during the meeting.
Okay. When you say he had shared with us, are you referencing a discussion or an argument he had with his parents the night before that related to video game design and grades, or was this something separate?
Both. No, he had shared that he was interested in that and that he didn't feel his parents supported that, and that led to an argument the night before, but he didn't provide any context to that at all, and they had confirmed that, but they also didn't provide any context to that either.
So there was a confirmation that the student and Mr. Crumbley's son and Mr. Crumbley and his wife had an argument with their son the night before. It sounded to you like it may have related to video game design and grades, but you didn't have any context beyond what you believed it to be about.
That's correct, yes.
Now, obviously, during these meetings, you expect for a student's parents to give you information about things that they are concerned about, correct?
Typically in these meetings, parents come to them and they provide additional context, stuff they're seeing at home, a history of, especially in a mental health situation, a history of any kind of counseling, and any issues they've had at other schools or whatever, but they usually provide additional information.
So you said specifically things that they see at home, things that they're concerned about. Obviously, in order for a parent to see something at home or be concerned about it, they have to be aware of it. Is that fair?
Speculation too, Judge.
I don't know how a parent could be concerned if they're not aware of something.
The Dean of Students can't testify as to how a parent would be aware of something at home in a meeting, not even specific to what we're talking about here.
Actually, my question was different, Your Honor. My question was, he would expect that, or it's his belief that if a parent is concerned about something, then they're aware of it.
Well, then it's a lack of personal knowledge. Mr. Ejak was the Dean of Students in Oxford High School in November of 2021, in charge of discipline and code of conduct issues, Judge. Mr. Hopkins was the counselor. He's already testified.
Okay. I think are you asking him if the parents aren't aware of something, they're not aware of it?
Kind of, Your Honor. Obviously, and I can ask my question differently and see if it makes it a little more simple.
Right.
Mr. Ejak, based on your experience, your education and your training, and just your knowledge in general of you're a human being, if someone doesn't have knowledge of something, they can't talk about it. Is that fair? Does that make sense to you?
I would say that's a fair statement.
So we can't talk about things we don't know about. Would you agree with that?
Yes.
Obviously, James Crumbley can't tell you about things he may not be aware of. I'm sorry.
Yes.
You weren't concerned on November 30th of 2021 by Mr. Crumbley's son looking at bullets or drawing guns. Is that fair?
I think there was a level of concern there, which is why we called the parents in for the meeting.
And if you recall, the level of concern was regarding the appropriateness of behavior in school.
Yes.
You didn't find his interest in guns or bullets concerning, especially in the Oxford community, if you remember.
Yes, that's correct.
You've had students draw guns on papers in the past.
Yes, that's correct.
In fact, students in Oxford, not all of them, I'm not saying all students in Oxford, but there are students in Oxford who have guns in their home.
Yes.
You know that there are students in Oxford who handle firearms.
That's a fair judge.
Okay. So you would agree that it's not unusual?
No, it's not unusual.
In that community?
In that community, yes.
I'm not asking you to speak about any other community, but in that community it's not unusual for students to handle guns.
That's correct.
When faced with a situation where a student has drawn guns on papers, you typically use your education and training to assess the risk.
As far as a discipline standpoint?
Discipline or otherwise, whatever your role is in that assessment.
Yeah, so my role would be to look for any violation of our code of conduct. And so that by itself, the drawings on the worksheet, don't violate a code of conduct.
And a violation of the code of conduct would also encompass any sort of a threat to other people. Is that fair?
That's a fair statement.
So as part of your assessment, you're also determining whether or not there's a threat.
I'm determining whether or not I need to alert somebody to something that could potentially be a threat.
And in this situation, you didn't make that alert. Is that fair?
That is correct. There wasn't any information that led me to believe there would be a reason to alert somebody else.
And part of your assessment is, again, looking at those typical early indicators that we talked about, whether there's a history of violence, correct?
That's correct.
A history of discipline.
That is correct.
Bullying behavior.
That is correct.
You look to see if there's a direct threat.
That is correct.
If those things are not apparent, if those things are not present, then it's just a student who drew a gun. Is that accurate?
That's pretty accurate, yes.
You were part of the meeting after Mr. Crumbley and his wife arrived. And let me go back a little bit. So you sat in on the meeting between Mr. Hopkins and Mr. Crumbley's son, correct?
That is correct.
If you know, that meeting occurred, lasted approximately 90 minutes?
I don't remember.
Okay. You left that meeting at some point?
Yes.
Then you came back once Mr. Crumbley and his wife arrived?
So I left the meeting to retrieve his belongings, the students' belongings, and returned back to the office and then left again until the parents arrived.
Okay. You entered Mr. Hopkins' office after Mr. Crumbley and his wife arrived in Mr. Hopkins' office?
That's correct.
You saw that Mr. Crumbley was seated next to his son?
Yes.
Which was directly across the desk from Mr. Hopkins?
Yes.
It was your perception that Mr. Crumbley was showing care for his son?
Yes.
That he reassured his son that he can always talk to him?
Yes.
You mentioned something on direct with the prosecution about a journal?
Yes, I did.
And you seem to recall that Mr. Crumbley made reference to a journal?
He did, yes.
You don't recall Mr. Crumbley saying the one that you always keep with you?
I don't recall that, no.
He didn't say anything like the one that's in your backpack?
I don't recall.
Specific colors?
I don't remember.
How long he's had it?
I don't remember.
There were no specifics about anything about a potential journal?
Not that I can recall.
So to your knowledge, you don't know if there was one journal or 15 journals. Is that fair?
I can't speak to that, no.
Right, you have no knowledge of that. Is that fair?
Yes.
After meeting with Mr. Crumbley and his wife, you felt that they were receptive of getting their son help, as was suggested by Mr. Hopkins.
Yes.
You and Sean Hopkins did not insist that it be done that day. Now, I'm going to clarify because I know that Mr. Hopkins indicated that he preferred that it would be done that day, but neither of you said, you need to take him today and you need to go get him help right now, and if you don't, there's going to be a problem.
What Mr. Hopkins had stated was that they needed to find him some counseling as soon as possible that day, if possible.
And that he was going
He would be following up within 48 hours to ensure there was something secured for the student.
And that was going to be my next question, that he was going to follow up in a couple of days, 48 hours.
Yes.
And in fact, you didn't feel in that meeting that Mr. Crumbley's son was in need of immediate care based on your education and training and perception and the knowledge that you had in that meeting.
I can't speak to that.
In no way did you feel that Mr. Crumbley was being neglectful of his son.
No, I did not.
You felt that Mr. Crumbley showed the appropriate level of emotion with his son in that meeting.
Objection is, he can't speculate as the appropriate level of emotion. He's the Dean of Students regarding code of conduct, November of 21. Speculation.
Was there anything odd about his interaction with his son?
I wouldn't say there was anything odd.
Okay.
You also didn't find it strange that Mr. Crumbley and his wife did not take their son home that day because there was no reason for him to go home that day. Is that correct?
As far as the discipline goes, no.
During the meeting, you said that you retrieved Mr. Crumbley's son's backpack from his classroom and brought it back to Mr. Hopkins' office.
That's correct.
You indicated this backpack was heavy.
Yes, such as every other student in the school.
And let me clarify, that day, you didn't say that today. That day, November 30th of 2021, you commented to a teacher that the backpack was heavy.
Yes, I made a joke at how easily she picked it up, and then when she handed it off to me, my arm dropped down. So it was more of a joke at how strong she was compared to myself.
And if you recall, at the time, the students weren't using their lockers.
They were not using them.
So it was fairly common for a student's backpack to be heavy.
That's correct.
You didn't look in the backpack?
I did not.
You didn't, and I think you said you didn't have reason to look in the
I didn't
backpack.
have reasonable suspicion.
You didn't ask Mr. Crumbley's son to look in his backpack?
I did not know.
You did not ask Mr. Crumbley or his wife to look in the backpack?
I did not know.
You didn't look yourself or ask anyone else to look because you didn't feel that there was a reason to look in the backpack. Is that fair?
There was nothing from our conversation or from anything that we had heard so far that would indicate it was enough to reach to that level. Correct.
You've had numerous discussions about this case since November 30th of 2021.
Yes.
You've talked with various attorneys.
Sure. Yeah.
And I'm not asking you about what your communications were with your own attorneys. I'm not asking about that. I'm just asking if you've met with attorneys.
I've met with many different attorneys.
You've met with the prosecutor's office?
Yes.
On more than one occasion?
Yes.
And some of those meetings with the prosecutor's office were to prepare for testimony?
Yes.
Some were to get more information about what occurred on November 30th of 2021? One
was, yes.
You learned through some of those meetings that there was no indication that there was a handgun in Mr. Crumbley's son's backpack.
Can you restate that?
Sure. You learned through some of the meetings with the prosecutor's office that there was no indication that there was a handgun in Mr. Crumbley's son's backpack while he was in Mr. Hopkins' office.
Object to the form of the question.
Yeah, what do you mean? Can you restate that?
Yes. I will be more clear. Do you recall testifying in September of...
What are you referring to, counsel?
There was testimony in September 14th of 2022 that relates to this. If you'd like, we can approach to talk about it further.
I think we should.
All right, the court has once again caught audio as the defense and prosecution approach the bench to discuss a matter with Judge Cheryl Matthews. It should be back up soon.
Okay, go ahead, Ms. Lindley.
Thank you, Your Honor. As you know, approximately 2 hours after the meeting, after this meeting with Mr. Hopkins, yourself, and Mr. Crumbley and his wife, Mr. Crumbley's son began the shooting.
Yes,
You saw the footage of the shooting.
I did, yes.
You were not aware that Mr. Crumbley's son was the shooter
Initially.
at the time.
When I saw all of the footage?
No, let me go back. So at some point early on the day of the shooting, you saw footage of the shooting.
Yes.
And that was while you were in the office of the school.
On the phone with the 911 operator?
Yes. And at that point, the thought didn't cross your mind that the shooter may be Mr. Crumbley's son.
That's a fair statement, yes.
In fact, you didn't know that it was Mr. Crumbley's son until you were told that it was him after the shooting.
I believe as the video footage continued to play and we were still on the phone, it wasn't confirmed, but I had a pretty good idea that that's who it was.
Okay. Even looking back, after you know what Mr. Crumbley's son did 2 hours after that meeting, his behaviors did not show a pattern of what he was planning to do 2 hours later.
Based on the information I knew, no.
It's fair to say that you have years of experience with at-risk students.
Yes, that's correct.
Years of experience with behavioral, academic, attendance, issues of that nature.
Yes.
You have education and training about concerning things to look for in students.
Yes.
You knew that Mr. Crumbley's son was looking at bullets on his phone on November 29th of 2021.
Yes.
You knew that he had drawn a gun and some concerning words on his math assignment.
Yeah, that's correct.
You knew that he was at the shooting range with his mom the weekend before.
Yes, that's correct.
You confirmed that during the meeting with his parents, correct?
Yes.
You knew that he had experienced significant losses in the months before November 30th of 2021.
Yes.
You knew that Mr. Hopkins was recommending that his parents have him talk to a therapist that day if possible.
That's correct.
You knew that his backpack was heavy and commented about the weight of it to a teacher.
That's correct.
You knew that firearms were not uncommon in homes in Oxford.
That's correct.
You knew that students at the high school handled firearms and that it wasn't uncommon.
We're asked and answered numbers.
You knew,
Yeah, he answered that.
you knew that the shooter was going to stay in school that day.
At the end of the meeting?
Yes.
Yes.
Partly because he wanted to,
Yes.
and partly because his parents had to go to work.
That's what I was told, yes.
And with all of this, all of the knowledge that you had on November 30th of 2021 at approximately 10:52 a.m., you did not feel that he was a threat to anyone, and you didn't feel that you had reasonable suspicion to look in his backpack.
No, because you have to remember, I knew very little of what we all know today. So when we're looking at the big picture today, I knew a fraction of what we all know now.
And we talked about this a little bit with Mr. Hopkins as well. We all know what happened at 12:51 on November 30th of 2021. But the information that you had at 10:52 a.m. or approximately 10:50 a.m. when that meeting ended, is the information that you were going on.
Yes, and that does not rise to the level of suspension or of discipline, especially when you're considering mental health.
And it doesn't.
That supersedes any type of minor discipline or behavior violation.
So, and Mr. Hopkins talked about this a little bit. Looking in hindsight, there was more information.
Yes, we now know there's a lot more information.
You might look at things differently looking in hindsight.
I would 100% look at things
Right.
differently.
But the information that you had on that day, at that time, is what led you to make the decisions that you made and feel the way that you felt about the situation that you were presented with in Mr. Hopkins' office.
That's a fair statement, yes.
No further questions, Your Honor.
Read your
Thank you. Briefly. Mr. Ejak, let's talk about the information not shared with you at 10:52 a.m. on November the 30th, 2021. Okay, so you formed your belief that you did not have the requisite level of suspicion to search the shooter's backpack based upon what you were told. Is that right?
That is correct.
Okay. Did James Crumbley tell you that he had bought his son a 6-hour 9mm firearm 4 days before that meeting?
He did not.
Okay. Did anybody, either his son or his wife, tell you that?
No.
Did his son tell you that, or did James Crumbley tell you that his son had been begging for a 9mm handgun?
No.
Did James Crumbley tell you that he actually got him a different firearm in June of 2021?
No.
Did James Crumbley tell you that the details and severity of his son's friend being taken from him at the beginning of the month?
No.
Now, you indicated that as far as a discipline standpoint, your belief was that the mental health concerns would override.
Yes.
Tell me about that.
So when you have a student who is being seen for mental health, and there also are some minor violations, this being a second day of insubordination, essentially, the mental health concern is what takes precedence because you want to build that relationship with the student and let them know that it's a safe space, and you don't want to follow it up with some kind of a negative interaction, such as a discipline.
Is that one of the reasons why Mr. Hopkins led the meeting?
Yes.
Okay. Did your lens ever change from mental health to discipline?
It never did, no.
And is that based upon the information that you learned that day?
Yes.
Did James Crumbley ever tell you that the 6-hour 9mm handgun that he bought for his son was kept unlocked in the home?
No.
You were asked about certain indicators in your experience when you consider discipline. Is access to an unlocked firearm, is that an indicator?
Yes.
Is that something to consider, had you known that?
It would be something to consider.
Okay, but that information was not shared with you?
No, it was not.
Now, just so we're clear, sir, the information that you and Mr. Hopkins were told on November the 30th, that information wasn't shared with anybody else in administration, is that correct?
That's correct.
Okay. I don't have any further questions. Thank you.
Very brief request, Your Honor. Very brief.
Okay.
Mr. Ejak, you don't know whether James Crumbley knew that his son had access to a firearm that was in the home. Is that correct? You don't know whether James Crumbley knew.
So the question was he told that?
I don't know how he would know what the defendant knew.
Right. He
Unless
testified
he was told.
what he was not told, Judge. That was the question.
Yeah, he said he wasn't told, but I don't know how he would know what your client knew unless he had a conversation about that.
Thank you. You don't know whether Mr. Crumbley's son had expressed any sadness over his friend moving to his parents, based on the information that you had on November 30th.
Can you say?
Yes, it was kind of a convoluted question.
Whether it was discussed in that meeting or
whether Mr. Ejak knew that Mr. Crumbley's son had expressed any of this sadness that they had identified to his parents prior to that meeting. Do you know if he did?
I'm not sure what you're trying to ask. I'm sorry.
Yes. Do you know if James Crumbley was aware of this sadness that you all had identified during this meeting with Mr. Hopkins?
I do not know.
No further questions, Your Honor.
Was the information that was shared from Sean Hopkins regarding the emails that he received?
Yes.
Okay. And he went through the drawing with James and Jennifer Crumbley?
Yes.
And at no point did James or Jennifer Crumbley ever say that the firearm purchased 4 days before mirrors the firearm drawn on that math worksheet?
They do not.
Thank you. Nothing further.
All right, you can step down and excuse. Your lunch is in here. This spot is wrong, obviously. If I were taller, it would have been fixed already. I'm going to ask you to return at 1 o'clock. It's not about 5 to 12. I'm going to ask you to return at 1 o'clock. In the meantime, I'm going to ask you not to discuss the case with each other or anyone else. Don't look at any news media. Don't talk to anybody. Don't Google anything. Don't do any research on your phone or anything. Any questions about the case now? Okay. All right, we'll see you at 1 o'clock.
All rise for the jury.
You may be seated. Who's the next witness?
We're going to find out. I just spoke with counsel about that, and we'll let her know as soon as we know.
Okay.
Thank you, Judge.
I'll see you at 1 o'clock.
Thank you, Your Honor.
Thank you.
moment.
You're watching our continued coverage of the James Crumbley trial, now in day 3. Court has gone on a lunch break, but we will be back with the latest analysis at CBS News Detroit at noon. See you then.
Parents know their kids better than I do. If all I ever did was meet with students, I might have 2 hours a year with each student.
Do you rely upon the parent for that information?
Absolutely.
Thank you for joining us here at CBS News Detroit at noon. I'm Meredith Bruckner. Today we're continuing our gavel-to-gavel coverage of James Crumbley's trial, as we've been providing since the beginning of this case. James is the father of the Oxford High School shooter. He's facing multiple involuntary manslaughter charges for allegedly not doing enough to stop his son before the massacre. Court is in break now. We'll return to the courtroom once they're back in session. And our Andres Gutierrez has been following this case since the beginning. He's live outside the Oakland County courtroom now.
Andres, what have we seen so far this morning?
Yeah, Meredith, for the better part of the morning, we heard from Sean Hopkins. He's the school counselor who met with the shooter and his parents hours before the kid carried out the massacre. Hopkins testified that three teachers reached out to him in the spring of 2021 concerned about James Crumbley's son. One of them said that he was failing her class and was falling asleep in that class. Another said Crumbley's son had written in a poem that he was feeling terrible and thought his parents were a mistake. And the third teacher, days before the shooting, was worried that the teen was having a rough time. That counselor followed up that third time and told Crumbley's son that if he was there if he ever needed to talk. The questioning zeroed in on November 29, 2021, when a teacher reached out saying Crumbley's son was looking at bullets in a class during that time. Then the next day, on the morning of the shooting, another teacher reached out concerned that the teen was watching a movie scene of a person gunning down people. That was followed up by another teacher reaching out saying talking about that notorious math assignment in which the shooter drew a gun, writing "The thoughts won't stop, please help me." That counselor called his parents for a meeting, and here's how that meeting went.
I told Mom that I wanted him to get help as soon as possible, today if possible, and was told that wasn't possible.
Okay, told by James, Jennifer, or both?
By Jennifer.
Okay.
James, at that time, to my memory, was talking with his son.
Do you recall what he said?
I remember it, yes. He was looking at the math assignment with his son.
When you say math assignment, are we talking about
It's the hard copy.
So we're referring to this, Exhibit 128?
Yes.
Okay.
And he was talking to his son and mentioned that, you have people you can talk to. You can talk to your counselor, you have your journal, we talk. And it felt appropriate at that time, but
at that point, did he share any details about anything you had discussed?
I don't recall any additional details, no.
Now, during cross-examination, Crumbley's attorney ended up asking Hopkins if he ever did reach out to the shooter's parents during those 3 times that he had gotten those emails from the teachers, and he said he hadn't. Reporting live in Pontiac, Andres Gutierrez, CBS News, Detroit.
And Andres, if you could speak to the pace of this trial, because compared to Jennifer Crumbley's trial, it certainly feels to be going faster, doesn't it?
It is. So during opening statements, the prosecution says they anticipate calling between 15 to 20 witnesses. The dean of students that just wrapped up is witness 8, so they are now at least more than halfway through their list. The defense hasn't indicated how much witnesses they'll call, but if you remember, in Jennifer's case, it was Jennifer herself who took the stand, and that was the only witness that the defense called in that trial. So at this point, we will see if James will take the stand and if he will be the only one or not.
Yes, that is certainly to be determined. Andres, thank you so much for your live report from Pontiac. We will continue to speak with you throughout the day. And let's bring in our team of legal analysts now. We're joined today by Rick Convertino and Rick Convertino. Thank you so much for being here.
Thank you.
So give me just your take on how things are progressing this morning.
I think the cross-examination is effective, infinitely more effective than in the first trial, if you even consider that there was cross-examination in the first trial. I think what the defense attorney is doing in this case is taking both of these witnesses from the school, Mr. Hopkins and Mr. Ejak, and utilizing them as an expert witness in an informal way for her purposes, and showing the jury that here are 2 witnesses who are boots on the ground, who have dealt with students exponentially over the years, and including 20 or so students every year, have experience with students with mental health issues, have experience with students with disciplinary issues, and all of that information that they had regarding Exhibit 128, which was the math test that had the gun and the bullets and the blood everywhere and the "I need help" statement, and the videotape that he was looking at on his phone regarding the shooting. All of that information these experts had, and they still did not believe that the shooter at the time, the morning of November 30th, was neither a threat to himself nor a threat to the community. And that is the crux of the case. if these experts could know, how can these parents know? Prosecution did a good job on redirect of saying that there's still all this information. You had a fraction, that was Mr. Ejak's testimony. I had a fraction of the information that I should have had at the time, and that's why I based my decision. Mr. Hopkins said I was operating in a vacuum, the same type of testimony, that he was also limited in the information that he had. And the prosecution did a good job on redirect of showing that only the witnesses had the agglutination, the accumulation of all of this information, and those were the two that should have, could have, and absolutely must have acted to prevent this tragedy.
Mm-hmm. And Arnold, you know, in the last, before the break, before this show, early in the stream, you said you felt the defense attorney fell a little short when it came to her cross-examination of the school counselor. How do you think she did now with the dean of students?
The difference is night and day, Meredith. She took us through the litany of questions, whether or not the inappropriate statements, the blood, the drawings, did that give you any indication as to what would happen? Did that give you the slightest inkling, the slightest peek into the future? He said not at all. He didn't search. He didn't think that there was anything untoward. He didn't even think that the parents or Mr. Crumbley was neglectful. That was powerful testimony. You saw too also on her recross of him, she got right to the point based on your knowledge, your experience. You didn't see anything untoward. He said no. Remember I said in the beginning, and we've been talking about this, pick your points, pick your points. She picked her points and she was extremely effective, extremely.
Thank you. And as we have with all other hearings related to the Oxford shooting, we're covering this trial in its entirety as part of our community commitment. November 30th, 2021 was a day that not only impacted the village of Oxford, but also our state and the nation. We'll be right back. Welcome back to CBS News Detroit at noon. I'm Meredith Bruckner. The trial of James Crumbley, the father of the Oxford High School shooter, is underway today. Court is in a brief break. We'll head back to the courtroom once the trial continues. But for now, let's take a look at today's other top stories. This afternoon, Michigan State Police are still searching for a person they say shot and killed a man at a hotel in Oakland County. It happened Saturday morning at the Baymont Inn on West 8 Mile. State police say a 27-year-old man was shot and pronounced dead at the scene. No one else was hurt. If you have any information about the incident or the people involved, call the number on your screen. And the Michigan Department of Health and Human Services is confirming the state's first child death from influenza for this flu season. It's one of 93 influenza-associated pediatric deaths reported in the U.S. The CDC estimates there have been between 20,000 to 57,000 deaths associated with the flu this season alone. And like many other states, Michigan is currently seeing a rise in cases. Despite this, only 25% of residents have been vaccinated against the flu.
On your block in Oakland County, a new FEMA Disaster Recovery Center is officially open today. The goal of the center is to help those impacted by severe weather events of last August continue their recovery. Specialists can help you apply for federal disaster assistance, learn about ways to make your property more disaster resistant, and get any questions you might have answered. A center at South Lyon City Hall opened this morning at 8 a.m. To find the center nearest you, visit FEMA.gov/DRC. And today marks the start of the holy fasting month of Ramadan for many of the world's Muslims. This comes after officials saw the crescent moon yesterday evening in Saudi Arabia. During Ramadan, many Muslims observe abstaining from food and water from sunrise to sunset. Today is the start of fasting for several countries and territories, including Gaza. The sacred month marks a period of religious reflection, family get-togethers, and giving across the Muslim world.
During this holy month, I hope those breaking the fast are reminded of the simple joys of health, family, and community. Let us also think of those who are suffering and hungry in our backyards and around the world. We pray that they will have some relief from their hardships. We have far more in common than we do that divides us.
However, some other countries, including Iran and Singapore, have said Ramadan will start tomorrow after failing to see the crescent moon yesterday. Now to a travel alert this afternoon for anyone in Detroit. The People Mover is shut down all day, and it's to complete guideway work before the NFL draft. The project is set to be back up and running tomorrow morning at 7 o'clock. And in other news, Sargento is recalling shredded cheese across 15 states over listeria contamination concerns. It isn't clear if Michigan is one of those states. Now, the recall covers bags of shredded cheese with best buy dates from February to July of this year. No word yet if anyone has gotten sick from the recalled products. Thinking of quitting your job? Well, before walking out, here are 3 things to consider when navigating whether or not to leave. Fast Company suggests that if you don't feel valued, meaning the company disregards your work-life balance, you receive frantic emails off hours, or they ask you to meet unrealistic deadlines, it could be a red flag. Secondly, they suggest you consider leaving if they don't encourage time off and repeatedly experience burnout. And lastly, they encourage you to exit if you aren't learning something new and don't feel challenged. Now, if you are considering leaving your job, you're encouraged to not burn any bridges and leave on the best terms possible. All right, time now to check in with next weather meteorologist Troy Bridges for a look at the forecast. Troy, how's it looking out there?
Hey, Meredith, we are looking gorgeous today. What a difference over yesterday. Yesterday was gloomy. We had the clouds in place. Today, tons of sunshine, and the next weather headlines reveal a beautiful day all day long, so you can expect more of the same. Temperatures warming today, 10 degrees above the average, and we're going to be even warmer tomorrow, going 20 degrees above the average, well into the 60s before rain chances roll in by the end of the week. Even as early as Wednesday afternoon, we could see a couple of showers, but not a lot on Wednesday. It's mainly going to be Thursday, and then by Friday we start to dry out again. So we've got really a little bit of everything in the next couple of days. So if you want to get outdoors, this is your day tomorrow as well, with fewer clouds in place for the next 2 days compared to what we had over the weekend. So there's that live view, the next weather tower cam view in Southfield. Blue sky, sunshine, hard to find a cloud out there at all today. Now tomorrow we will see a few additional clouds, but again, the rain holds off until Wednesday, but especially heading into your Thursday. So here are the temperatures. We started off this morning in the 20s. We had feels like temperatures in the teens because of the wind. We've rebounded nicely. Our average afternoon high temperature is 44 degrees. We're already above that here at 12:15 in the afternoon. So it's 48 in Detroit right now, 45 in Pontiac, 47 in Ann Arbor, Port Huron at 41, Lapeer at 43 degrees. You factor in the wind, there's a slight wind chill, but not a big one. Feels more like 38 in Pontiac. Lapeer feels like 38. But here is what you can expect through the day. The average high 44. We're going 10 degrees above that to 54 this afternoon. At times that wind out of the west will kick up just a little bit, but look at the temperatures not dropping off all that much as we head into the evening hours. So as you make those evening plans, we're looking good. By 8 p.m. we're at 51, 49 as late as 10 o'clock. So a light jacket in order, especially later in the evening hours. There's future cast. Anywhere you see white would indicate some cloud cover. We'll see a few clouds here and there, but not many many. Notice more clouds rolling into the picture as we head into tomorrow, but still sunshine getting through. And then it's Wednesday with that slight chance for a few showers, and then Thursday, more of the heavy rain building in. So highs today in the mid-50s, and then morning lows tomorrow milder than this morning, near 40 area-wide. Now look at your next 7 days and look at the warm-up, getting up to 65 for your Tuesday and Wednesday, with the rain chances returning Thursday and Friday. Meredith, back to you.
All right, thank you so much, Troy.
CBS News Detroit.
Anytime,
anywhere. With breaking Southeast Michigan news.
And next weather updates.
Just open the free CBS News app, select Live, then look for CBS News Detroit. On your block, around the clock.
Welcome back to CBS News Detroit at noon. Running a business isn't easy. The Chamber of Commerce reports that half of all small businesses close up shop within 5 years of opening, and 65% won't make it to their 10th anniversary. Through Michigan Made, we want to showcase our local businesses and celebrate their success. But some days like today, that isn't always possible. Our executive producer impacting communities, Amir Makupson, is on your block in Saline with a business owner who says she hopes that sharing her story can be the good in goodbye.
In the former library in Saline, built in the early 1900s, now sits McPherson Local.
McPherson Local is an all Michigan made general store. We have 180 makers with us, and our goal is to highlight and support and showcase to our community and communities all over Michigan the great things that are made here.
Since 2017, the store has been home to knickknacks, jewelry, little odds and ends.
We started with only 25 makers, and we're at 180 now. So we've been able to develop a good reputation. We've been able to spread our message and the word of mouth. And so, yeah, it was great when we opened.
Business was good, but then
things took a turn for us during COVID. I applied for as much as I could, and I was honest with all my answers. For the payroll, the PPP loan, they said my payroll was too small. Being the smallest of the small, you hope that you can get a little bit of relief, and so it just didn't work that way. We are just still in that hole, and it's something that we aren't confident that we're gonna be able to climb out of. It was a super, super hard decision, but we had to make the decision to close it.
And just like that, it's over for Jen and her employee turned close friend.
I think I knew it was coming, and I'm mostly just like, I'm not really worried about myself. I know I'll figure it out, but I really was worried because it's like, this is her baby, and like I got the privilege of like being included in on it. But yeah, I was more just like sad and hurt for her.
It's definitely sad. I definitely have cried like for a month straight, but because it's a dream, and you're watching your dream kind of be sold off piece by piece.
For now, final sales are being made and well wishes are being shared, even from Jen, who hopes that in sharing her story, she can be the good in goodbye and encourage people to shop local.
I would love the people out there to know that like it might be too late for us, but it's not too late to save small business. While it's so hard and it's so sad for us, if my voice can be the voice of other small businesses who maybe are afraid to speak up, then I'll do it. I'm happy to do it because I want to see everybody else succeed.
On your block in Saline,
we're saying goodbye to the things, we're saying goodbye to our customers, and at the end, we have to say goodbye to each other. And I think that's the hardest.
Amir Jacobson, CBS News, Detroit.
It's hard to see in any community. Amir, thank you for that story. McPherson Local will shut down shop for good on March 30th. So if you know of a business deserving of the Michigan-made spotlight, contact Amir at the address seen on your screen. You just may catch it in an upcoming segment. Shifting gears now, do you love dyeing Easter eggs but hate the mess and smell that comes with it? Lifestyle expert Ashley Bellman is here with a fun and mess-free solution. Here's CBS Deals.
This is Hey Buddy, Hey Pal, so easy to use. You take their quick drying marker and just put it up to the egg.
Wherever I want.
Anyone can do this, so we are taking the, how beautiful.
Oh my gosh, this is so
Gorgeous
cool. Oh,
lines, designs.
I'm in.
I have a 2-year-old who does not sit still. We sat, we played, we decorated eggs. He didn't want to wait. He just grabbed the egg, and I'm like, oh gosh, it's going to be all over his hands before dinner. No, gone are the days of the dye, of having that mess, of smelling those chemicals, and then waiting hours and hours for them to dry. It's so easy to use, and for $19.99, the price is so good today that you could get one for each sibling, so nobody has to wait to take turns.
By the way,
right?
I want one for me.
Isn't this right? This is therapeutic.
I'm like, what else can I put in here besides an egg?
29% off. I know, it's so much fun. Hard-boiled eggs. I'm telling you, you will be the hit. This is #1 every year.
Love
my
it.
first time in Peeps, which is so much fun.
To get this deal and more, scan the QR code at the top of your screen or head to cbsdeals.com to start shopping now.
Welcome back. So, Troy, what a difference from yesterday to today in weather. It's unbelievable.
Absolutely. It was so cloudy, so ugly and cold. Today, blue sky and sunshine, already above our average of 44. It's 48. We're headed to 54 for the afternoon high. But look at tomorrow, another dry day and 65 degrees. Now, rain chances roll in, especially Thursday and Friday. Get ready for that. But until then, today and tomorrow, spectacular
Okay,
to
well,
enjoy.
you can't avoid some spring rain, right?
That's how it
We're almost in
goes.
spring. All right, we're continuing our coverage of James Crumbley's trial in its entirety. Head over to our stream for the uninterrupted coverage. Once court is in session, find it on CBSDetroit.com, Pluto TV, or on our app. And be sure to tune in at 6 o'clock for a major announcement regarding the Detroit City Football Club. Thanks for watching us. Sorry.
This case.
It's like a screenplay, something straight out of Hollywood.
But it's not fiction. It's 48 hours.
Human remains found this week.
4 families shattered.
There's no physical evidence.
The mystery would haunt investigators for years.
There's some questions that have to be asked and need to be answered.
Like a John Grisham novel.
A gripping true crime original. 48 hours. Now streaming on the free CBS News app.
This is CBS.
Hello, everyone, and welcome to our Dragon capsule here in space.
Sightseers in space, the thrill of a lifetime.
Seeing the Earth from space, it was so exhilarating.
But the risks that come with the territory.
There have been 4 fatal accidents. That's a 1% fatal accident rate.
Might make you look before you launch.
If you had 1 out of 100 airplanes falling out of the sky, we'd have a public crisis.
Space tourism, now streaming on the free CBS News app.
Welcome back to CBS News. I'm Tony Copeland.
And I'm Errol Barnett. Here's a quick recap of some of the top stories we're tracking for you right now. The third day of testimony is underway at the trial of the Michigan man charged in connection with the mass shooting carried out by his son. James Crumbley faces 4 counts of involuntary manslaughter. Prosecutors say Crumbley and his wife, Jennifer, ignored obvious warning signs that could have prevented their son from carrying out that shooting.
Secretary of State Antony Blinken is in Jamaica for an emergency summit on the growing crisis in Haiti. Gang violence has prompted the U.S. to airlift American personnel out of the U.S. embassy there in the nation's capital of Port-au-Prince. That was over the weekend. Heavily armed gangs calling for the ouster of the prime minister there. He does remain in Puerto Rico, unable to get a flight to Haiti.
And the holy month of Ramadan is underway in Gaza and elsewhere with the threat of a new offensive by the Israeli military. Negotiations for a ceasefire ended last week without an agreement. Israeli Prime Minister Benjamin Netanyahu says the war will not end until Hamas has been completely eliminated. All right, the 2024 presidential campaign season is in full swing.
Yep, and that means President Biden is on the road, expected to visit several battleground states this week, including Wisconsin and Michigan. And that follows some dueling campaign events this past weekend in Georgia from President Biden and his opponent, former President Donald Trump.
So let's talk about it. CBS News campaign reporters Olivia Rinaldi and Aaron Navarro join us from our D.C. bureau to give us the latest on all of this. Aaron, let's start with you. First, just explain the importance of Georgia and how politically it's different now than it was even just 4 years ago.
Errol, this is a crucial battleground state for both of these candidates who are likely to be the general election nominees. In 2020, Biden won by just 11,779 votes. But what's changed? The electorate and coalition that Biden built, especially in the Atlanta metro area of minority voters, Black, Hispanic, Asian American voters, they seem, at least according to polling, to be less enthused about the president's record about voting for him again. And another quick thing to point out is there's no down ballot Senate race to really energize Democrats to vote for the president. You remember in 2020, you had two Senate races on there, the one that John Ossoff and Senator Raphael Warnock were on. That kind of energized Democrats because it was an opportunity for them to capture the Senate. This time around, no such down ballot race.
Olivia, turning to former President Trump, you could say he went on offense against President Biden. What he did is he went into his bag of tricks, which includes mockery. He's mocked disabled reporters. Now he was mocking the president for, his childhood stutter. How do these sort of attacks stick with voters? I know they play pretty well on social media. I know people snicker at him here and there. But overall, it seems like, do people like the negativity? Do they not? Where are we?
Yeah, Tony, that's a great question. When Trump is doing those types of things, he's always speaking to his base. That is the most important thing for him, is for him to speak to those supporters. And that's what they like to see. They like to see that combativeness, that negativity, that sort of framing this between him and Biden, and that he is the more competent one. That was the goal there in pointing out the stutter. But I do want to note, as Aaron was talking about Georgia, such a crucial battleground state, and to the broader point of Trump speaking to his base. He went to this battleground state, but he went to a ruby red district in that state. He went to Marjorie Taylor Greene's district. And what did he do while he was there? He focused on immigration and Laken Riley. That is, of course, the University of Georgia student who was allegedly killed by a Venezuelan migrant a few weeks ago. That has invigorated the Republican base in talking about immigration, and he forced Biden's hand on the topic. That is something we'll continue to see him doing, forcing Democrats and President Biden to really talk about immigration, talk about that border bill that failed at Trump's hands, and talk about Laken Riley, and Biden apologizing on MSNBC over the weekend for using the term illegals when he was talking about the State of the Union. So really, we'll start seeing more of Trump forcing Biden's hand on some of these issues, these hot button issues, and using some of that negativity, as you point out, to energize the base. That's kind of the playbook that he will be using here.
Yeah, Aaron, attacking back to you here, both Biden and Trump have their bases. They've got to play to them, but they also need independents, which are really going to decide who wins this election. Nikki Haley suspended her campaign. She did have a lot of independent voters, and now both Trump and Biden are trying to pick those voters up. How are they doing it, and how are they succeeding?
Well, Olivia can add to this if I'm wrong, but I do believe Trump necessarily hasn't made a concerted effort to appeal to those Nikki Haley voters. Meanwhile, the day that Nikki Haley dropped out, President Biden put out a statement saying that there is a home for you in our campaign. And generally, the Biden campaign and Democrats believe that his message overall appeals to independent voters, noting women's reproductive rights, trying to kind of neutralize that issue of the economy by talking about some of the manufacturing bills that Biden has done, as well as just making some of the contrasts with Trump on behavior, which when you talk to independent voters, more moderate Republicans, that's kind of been the one thing that's kept them hesitant about going to Trump, is kind of the behavior, the rhetoric that he often uses. But generally, the Biden campaign does believe they're running more of an independent, in addition to appealing to the base, but have more independent rhetoric and messaging points that they can use that will appeal to those Haley voters anyway.
And so, Olivia, let's bring you in on that point, because we know that as you shift from the primary and the caucuses to the general election, each side tends to move to the middle to get your more independent and less engaged voter. If we are seeing that effort on the Biden side, what is Trump doing that shows a shift? Because he also has to be more wise with how he spends his campaign money, considering he's up against so many legal challenges as well.
Absolutely, Errol. I mean, over the weekend at that Georgia rally, we heard Trump talk specifically and purposefully to black voters, Hispanic voters, union voters, telling them that I have done more for you than President Biden. That's kind of the tone we'll hear from him. And he also said specifically to black people, I have done more for you than perhaps any president, including Abraham Lincoln, which is quite a statement to make. But it does seem to be playing well with voters. I spoke with Jeremiah Hicks. He's a black Georgian man who's voted for Trump twice, 2016 and 2020, and he's a union worker. Take a listen to what he had to tell me about Biden and Trump.
Because he's not really doing anything for us. He's more misleading. And Trump is straightforward. He's going to tell you how he feels, whether you got to like it or not. You know what I'm saying? If you don't like it, man up, change what you're doing. You know, and other than that, you know, Biden, he pretty much pacifies you and tell you it's going to be all right, but it's never all right.
So that's Jeremiah Hicks there talking about this broader sentiment that Biden's telling people it'll be okay and he's doing all this work for black voters, but they're not really seeing that. Meanwhile, Trump is who he is, and they're going to support him for that. And of course, we've seen some of this in the polling of Biden eroding some of that support with black voters, and we've seen some of them gaining with Trump. It's an interesting trend that we're watching there, and we'll be seeing more of that over the next coming months.
Really fascinating stuff. Good to speak with Olivia Rinaldi and Aaron Navarro there from our D.C. Bureau. Appreciate it, guys.
E. Jean Carroll is not planning to contest the nearly $92 million bond that Donald Trump posted in her defamation case against him.
That's right. Posting that bond means she cannot collect her multi-million-dollar judgment from him while he appeals the verdict. She is asking that Trump's insurer pay the bond sooner than originally requested. Now, if Trump loses his appeal, he has 30 days instead of 60 days to pay up. The former president denies any wrongdoing. The judge still has to approve the bond before things can progress. All right, a beach sperm whale that appeared off the coast of Venice Beach, Florida on Sunday has died. The whale was seen alive and thrashing in the water Sunday night, according to local officials. They're still actively attempting to remove the dead whale off the coast. The whale is estimated to be around 50 feet long and weigh 50 to 70,000 pounds. Once removed, the whale's necropsy will be performed on the beach to determine its cause of death.
A Chilean Navy helicopter airlifted 2 people to safety when they were trapped on rocks in windy conditions yesterday. Take a look at these pictures. The 2 people were found at a scenic coastal spot north of Valparaiso, Chile. The Chilean Navy said the helicopter crew endured some pretty adverse conditions with strong winds and waves, and the 2 people rescued were treated at a local medical facility.
All right, coming up for you all, an apology from a princess.
A new post from Kate Middleton after a photo she shared went viral for the wrong reasons. You're streaming CBS News.
Washington is the seat of power. National security, foreign policy, global economics, every story comes through Washington in some way. We bring some of the most powerful voices in America to the table. We don't just ask the questions, you have to go deeper. We try to understand what's at the heart of the issue we're talking about, to then come forward with solutions.
Face the Nation on CBS.
The justices ruled that Harvard and the University of North Carolina violated the Constitution.
In the aftermath of the Supreme Court decision to end affirmative action in college admissions, uncertainty sets in for some students of color.
Affirmative action really gave us an equal opportunity.
CBS Reports explores the historic decision and what it means for those chasing an opportunity to change their lives.
I knew that college was the ticket to break this cycle.
The end of affirmative action, now streaming on the free CBS News app.
Okay, let's go.
You guys good?
Hey.
All right, we good?
Keep going. The clock, it's ticking.
Off we go.
60 minutes.
60 minutes.
60 minutes.
It's time for 60 Minutes, Sundays on CBS.
An original documentary from CBS reports.
AI is among the most world-changing technologies ever.
Curing diseases, scientific breakthroughs, making lives better.
It can help us with medical discoveries, scientific discoveries, doing better agriculture, having cures for things like Alzheimer's.
It's also going to really transform the way we work.
The uplifting potential of artificial intelligence is limitless.
It gives you a friend, somebody to chat with 24/7 that is non-judgmental. He makes me feel loved and desired.
And so are its downfalls.
The problem with all this AI is that it's unpredictable and uncontrollable. The choices we make now will have lasting effects for decades, maybe even centuries.
The ChatGPT revolution, now streaming on the free CBS News app.
We are about to see American weapons in the hands of Mexican cartels.
A gun pipeline to Mexico.
We are arming the cartels.
100%, no doubt about it.
Happening right under our noses.
Who's doing something about this? Nobody.
A CBS Reports exclusive.
Most Americans have no idea that we are effectively arming the enemy next door.
This is the story the American people need to know.
Arming cartels, now streaming on the free CBS News app.
America Decides, taking you inside American democracy.
The most important stories on a day-to-day, hour-to-hour basis.
You're going to hear a lot of reporting.
It is clearly a pivotal moment.
Gun control, the economy, education.
Both sides of the political aisle fight it out for power.
Bringing you the analysis that you need.
Thoughtfully, with context.
Be part of the conversation.
On CBS News streaming.
Welcome to America Decides, Monday through Thursday at 5 p.m. Eastern.
Kate Middleton is apologizing following a controversy surrounding a picture of her with her family that was posted over the weekend.
Everything seemed fine until people started to look closely. The photo was released by the Princess of Wales for UK's Mother's Day. Several news agencies pulled this image shortly after its release over this concerns that portions of it were manipulated, and you can see issues with that edit on the child's wrist. The Kensington Royal Twitter account posted a statement from Kate saying in part, quote, "Like many amateur photographers, I do occasionally experiment with editing. I wanted to express my apologies for any confusion the family photograph we shared yesterday caused." It was, and this is interesting, the first public image released of the princess since her abdominal surgery back in January.
Yeah, people want to know if she's okay. And so
we hope she is.
We hope she is. If they were looking closely at this picture for news.
Yeah. We also have this for you. The University of Antelope Valley men's basketball team is heading to the NAIA tournament. But once they wrap up their season, they won't have a school to return to.
That is true. That's because the university officially closed its doors on Friday. The government issued an order to cease operation of all degree programs by the end of last week, and this was because of financial issues. Last month, the officials at the private school alerted the coaching staff that the season would be canceled as a result of this pending closure. But despite the obstacles, they made it to the tournament as a 6th seed. So let's bring in the coach of the University of Antelope Valley, men's basketball coach Jordan Mast. He's here with us now. Coach, how are you? Thank you for being here. Glad you're continuing. How did it come? How did you learn the news that you were going to be, the whole school was going away? And then how did you gather the strength to get this continuation and the cash to do it?
Yeah, thanks for having me. Unfortunate situation, but we got an emergency call about 3 weeks ago. And in that call, they stated we're going to lose our campus, our gym, our facilities, our dorms as early as 1 week. And we had 1 week to kind of get out. On top of that, they couldn't afford to pay us our full pay for the next pay period, and they had no funds to continue our season.
Coach,
so obviously, yeah, sorry, go ahead.
In the introduction, I said the government issued an order for the university to cease operations. Is that a typo? Is it actually the government? What's going on here?
Yeah, it's the Department of Education stepped in and basically said that we won't be allowed to remain as a school based on a lot of findings that they had found through their accrediting agency.
Wow. And so now you're writing not just the skills of the team, but the empathy from people who've now donated money to your GoFundMe. I think it was up to maybe $45,000 at last check. You can update us on that because you've made it to the tournament, which is tough, the NAIA tournament. So how do you finish the season without the backing of the school? Where are you guys practicing? Who's paying for lunch?
Yeah, good question. So they did give us, they said you could fundraise to continue on, but we don't have any funds, for the remainder of the season.
Wow.
And so at that point, it wasn't just our men's, but our women's team advanced to the national tournament as well. And we just felt there's no way we can let, their seasons end this way. So we got to do whatever we can. And so we started a GoFundMe with the goal that we could send both the men and women's to not just the conference tournaments, but the national tournaments. And the support, getting national news attention has just been amazing. We've raised the money to allow these young men and women to continue, and couldn't be more proud of our efforts and just feeling blessed of the support around the country for people that don't even know our young men and women, but they just have a heart for the story and care.
Yeah, people want to let the kids play. They want. I hope you get a banner, a championship banner, even if you don't have a gym to hang it in. I'm curious, how are the kids handling this? I mean, how are they rolling with these tremendous punches that they're facing?
I would say it's been a roller coaster ride. When they got the news, obviously they're really down and worried and stressed. Hey, where am I going to live? Where are we going to practice? Is our season going on? Will I finish my degree? Can I finish my classes? All valid points. And we've slowly got a few answers. Unfortunately, not a lot from our school, but the previous owners who are taking over the facilities, they did give us their blessing to stay in the gym and stay in the dorms until the end of the season. So just getting that information, you saw a little bit of stress relieved from our players. But then the cool part about this is, they've almost taken this mentality like, hey, whatever has been thrown at us, we've overcome it and we keep showing up. And so let's just keep this rolling and see how far we can go and see if we can make some noise. Because it is a good team. It's a team that's won the conference. They're 26-4, and we think they have a legitimate chance to do something in the national tournament.
This could be a movie. Okay, and when it gets turned into a movie, Tony and I will play ourselves as we help let people know your story.
Yes,
Coach.
yeah, happy to do it.
Best
happy
of luck.
to do it. Wishing you the best. Coach Jordan Mass, thank you very much.
Thank you.
All right, speaking of movies, Oppenheimer dominated last night's Oscars, taking home 7 awards in total.
But it was not a total sweep. We're going to look at some of the top moments from Hollywood's biggest night. You're streaming CBS News.
Go to the ends of the earth.
Right now.
We got something crazy. And reach for the stars.
Here we are.
Time.
Yes, it's my comeback.
Hey, this is pretty fun.
But wait, there's more. Experience thought-provoking.
I'm open to the idea of being a human being.
Innovative. And truly original reporting.
Look through a telescope and go, wow.
Because there's always something new under the sun on CBS Sunday morning.
At this moment, terrorists could be plotting another attack.
9/11 triggered a counter-terrorist system that included a secret database.
This person needs a closer look.
A growing list of nearly 2 million people, including some Americans who say they're innocent.
For 1 hour flight, I have to spend 6 hours to go and come back.
CBS Reports explores the system, the people responsible for it, and those pushing for change.
I'm not fighting against them. I'm fighting for them to do the right thing.
The Watch List, now streaming on the free CBS News app.
Don't miss true crime anytime you want, anywhere you go. With the 48 Hours podcast. Real crimes, real lives, real justice.
There's some questions that have to be asked and need to be answered.
Listen to 48 Hours on Apple Podcasts.
An original documentary from CBS Reports.
Imagine yourself in Manhattan with no police, no army, no mayor.
The people of Haiti stare down poverty, corruption, natural disasters, and violence.
90% of the guns that are used by gangs in Haiti are American guns.
But with an unbreakable spirit and eternal optimism.
There are days where I cry, but we can't be discouraged. We still believe in Haiti.
They're still able to look ahead with hope.
Haiti is on the brink of transformation, a radical shift. Nations are coming together and saying things must change.
Fighting for Haiti, now streaming on the free CBS News app.
Everybody wakes up in the morning and they are pelted with alerts that frighten them, news that agitates them. With this show, we have the time to explain what's going on. These migrants, they've been released. Explain the status that allows them to be released, to slow things down a little bit. What are the big sets of questions for China and its ambitions? Hackers are stepping up their attacks to extort victims. Let's start with easy. Who's attacking? Here's a deeper understanding of what's happening.
Prime Time with John Dickerson. Stream on the free CBS News app.
When you wake up in the morning, we want to be your go-to team.
On our places, bright, shiny faces.
I don't go to work in the morning. I go for coffee with my two good friends, and we talk about the world.
Your morning routine just got better. CBS Mornings.
Here it comes. And my eyes see Oppenheimer. Yes.
There was nothing else he needed to say, right? That was the moment Academy Award winner Al Pacino announced Oppenheimer had won Best Picture last night.
It was a strange kind of moment, but a moment it was. The historical epic Oppenheimer took home a total of 7 trophies, including Best Director, Best Actor, and Best Cinematography. But yesterday, attention was drawn to more than just the best movies of the year. Last year, several celebrities wore red pins to the Oscars, symbolizing their support for a ceasefire in Gaza.
All right, Nigel Smith joins us to recap Oscars night. He's the senior news editor of Movies for People. And I think, the hosting these events is a challenge, but Jimmy Kimmel, made a joke from a post criticizing him from President Trump in real time. He managed to end the show on time. Those are pretty good marks for a host. How do you think he did?
Those are great marks for a host. And I thought, the funniest moment came near the end of the show. He was wrapping things up, and then he read that mean tweet from Donald Trump criticizing his performance. And he ended it with his line, "I think it's past your jail time," which got a huge laugh from the audience and was one of the funniest highlights from the show. But he did a great job. Look, he's done this many times before. He's also hosted the Emmys. He knows what he's doing. He feels very in tune with, what the celebrities want from him. He doesn't go too hard after them. He doesn't really, veer too much into Ricky Gervais territory. He did get a jab in at Poor Things and about the nudity in the film, which got a little eye roll from Emma Stone. And he also touched on Robert Downey Jr.'s past, which got an eye roll from Robert Downey Jr. But other than that, he played it pretty safe, played it to the room, and he made the whole show run very, very smoothly, I'd say.
There were a lot of speeches, as there always are. Some of them work, some of them don't. What were your favorites, if you don't mind?
Yeah, my favorite speeches were the most emotional ones from the night. Emma Stone winning Best Actress, her second Oscar, came as a huge shock to her. You could tell from the moment that her name was uttered. She got up onto the stage and, being Emma Stone, of course, she opened it with a joke about the back of her dress being ripped because she was dancing so hard to Ryan Gosling's I'm Just Ken performance, which was a huge hit. And she got super emotional. She cried. She made a loving tribute to her husband. She even got in a Taylor Swift lyric. Taylor Swift is a good friend of hers, and she said that lyric while paying tribute to her daughter. And she rarely speaks out about her family, so that was a really, really special moment. And also, I have to say that Da'Vine, she was so beautifully spoken in her Best Supporting Actress. And up until this point, she's been using cue cards to, refer back to notes during all of her award season wins. But this time she came up there with no notes and delivered such a heartfelt speech about feeling seen. And it was definitely one of the highlights of the show.
And speaking of being seen, before you go to you, Errol, I love the detail we learned in the introduction to her about her wearing her grandmother's glasses in the role in the holdovers. So literally seeing through what her grandmother's eyes would have seen. And where we are now.
And all of it is a great reminder of just how nervous they are as actors receiving this award, waiting on edge to receive the award. They're human as well. I thought it was kind of touching to see previous winners give acknowledgement to each nominee sitting in the crowd as also. I want to ask you about some of the performances, though. You mentioned Ryan Gosling as Ken, Billie Eilish also performed. What was at the top of your performance list for the night?
I think at the top of everyone's performance list would be Ryan Gosling as Ken. I mean, everyone was waiting for this moment. It was kind of reminiscent of, when Lady Gaga and Bradley Cooper did their Stars Born song. That was how high the anticipation was to seeing Ryan Gosling just belt it out. And I mean, while I was watching it, I was thinking to myself, I would pay good money to see this guy in concert. He was phenomenal. He held the stage. His voice sounded just as good as in the movie. He danced his butt off, and he had all the other Kens from the movie there. Slash even made an appearance. It was choreographed beautifully. I thought it was a spectacular movie.
Who knew he could sing?
I mean, apparently the people who cast him, he's a one-take wonder. They could have, that's a wrap on that. Nigel Smith, thank you very much. Appreciate your insights.
Thanks, Nigel.
Thanks.
Coming up all afternoon here on CBS News, Secretary of State Antony Blinken arrives in Jamaica for emergency talks on the growing crisis in Haiti.
Plus, the top intelligence experts on Capitol Hill talk about the most serious threats to American national security, why a social media site will be one of the topics of conversation.
And Israel's prime minister stands defiant as the international community demands a ceasefire as Ramadan is underway. You're streaming CBS News.
Okay, so let's just start at the beginning.
Well, let me start with this. What is at stake here?
What is the answer then?
Do you know why?
You want me to just keep going?
Is that a good thing or a bad thing?
Were there death threats?
How is this possible?
What's wrong with that argument?
Are you saying they lied?
Have you told the government that?
Why won't you say the word crisis? You're not answering my question.
This really
Is that scary?
Does that make sense?
What do you mean? What does that mean in
Did any of that make sense?
What's your response?
What happened?
Why?
It's time for the CBS News Original 60 Minutes, Sunday on CBS and streaming on Paramount+.
There is no more room in our city.
New York City is receiving record numbers of migrants.
Today, we're going to have more than 500 adults and children come through that door.
Tensions rise as shelters reach max capacity.
We don't have to take care of them.
CBS Reports goes inside a crisis cities and families are facing as they fight to survive.
The United States still has that glimmer of hope for people to come here.
Fighting for a future. Now streaming on the free CBS News app.
On Face the Nation, the way to learn is to listen.
We may have a recession.
Listening to how someone explains themselves is so key to understanding their perspective.
An original documentary from CBS Reports.
Since you started La Soup in 2014, do you have any sense as to how much food you've rescued from the landfill?
We've rescued 4.5 million pounds.
I can't even fathom how much food that is.
And that's one little person in one little city in America. We're going to call this chicken piccata. We did 450 of these meals today.
This is the exact dish that you and I are going to have.
Yep.
Oh, really good.
Is it good?
Mm-hmm.
Having a plan of how to keep people fed should be in every single city.
If we eliminated food waste, could we eliminate
hunger? Yes.
Eating Trash, now streaming on the free CBS News app.
America Decides, taking you inside American democracy.
The most important stories on a day-to-day, hour-to-hour basis.
You're going to hear a lot of reporting.
It is clearly a pivotal moment.
Gun control, the economy, education.
Both sides of the political aisle fight it out for power.
Bringing you the analysis that you need.
Thoughtfully, with context.
Be part of the conversation.
On CBS News streaming.
Welcome to America Decides.
This is CBS.
CBS News, 60 Minutes, Sunday on CBS.
At the CBS Evening News, we focus on solutions, finding solutions to healthcare problems, how much money we can spend on groceries, finding solutions to help people understand what are the right choices to make for you and your family.
Hey there, folks. We appreciate you kicking off your week with us right here on CBS News. I'm Errol Barnett.
And I'm Tony Nicole. Here's a look at the top stories we're following right now. The Muslim holy month of Ramadan begins without a ceasefire in place between Israel and Hamas in Gaza, but also without an invasion of Rafah.
Secretary of State Antony Blinken heads to the Caribbean for emergency talks on the growing crisis right now in Haiti.
And U.S. Senator Bob Menendez returns to court to face new charges in his federal corruption case.
Coming up for you all later this hour, the 2024 race for the White House shifts into a new gear. We'll look at the new talking points from both candidates as they zero in on each other on the campaign trail.
And the college basketball team without the college. We'll talk with the coach of a team from California still trying to go into the postseason tournament even after the school has officially shut down.
All right, U.S. Secretary of State Antony Blinken is traveling to Jamaica today. He's heading to an emergency meeting with Caribbean leaders on the crisis in Haiti.
And of course, that follows U.S. military evacuating some personnel from the U.S. Embassy in the capital of Port-au-Prince over the weekend. The European Union and Germany have also evacuated staff as gang violence escalates across that country. The U.S. military is deploying additional security to Haiti, and the U.S. Embassy there does remain open. CBS News national correspondent Manuel Bojorquez has more on this right now. Manny, good to see you. So the situation in Haiti has been unstable for a number of months now. So what prompted this latest move, the U.S. military evacuating embassy staff over the weekend?
Well, that just really speaks to the dire situation on the ground there in Haiti, that the U.S. Saw it fit to remove non-essential personnel from the U.S. Embassy there and also to send in reinforcements to beef up security there. And the fact that you have the Secretary of State now at an emergency meeting of Caribbean nations trying to figure out what can be done. For years now, Haiti has been in the grips of gang violence, but these gangs have only grown more powerful. And over the last week, what happened is the prime minister went overseas to try to seek international help, a security force. Well, these gangs saw the opportunity to even take over more of the capital, including trying to take over the airport and preventing the prime minister from returning. They want him to resign, or they're threatening civil war, they said, and genocide. At this point, no indication that he will resign. So that's part of the political calculus here that the United States is trying to weigh at the moment, is how to deal with the prime minister, what guidance, if anything, they should give to him, whether they should ask him to step down. The United States has not made that an official position. But in the meantime, you have scores of Haitians that are caught in the middle of this. You have hospitals that have been shut down. The food that was already scarce is even more scarce now as people are either displaced or hunkering down in their homes.
Manny, Sheila Surfalis McCormick, a Democratic congresswoman who serves as a co-chair of the Haiti caucus, really underscored the importance of implementing some type of justice system in Haiti. Here's how she explained that.
Without justice, these gangs would just lay dormant and come right back when they have an actual election and start terrorizing the people. We've seen this habit over and over again. We need to have a justice system implemented within the Transition Council and also start looking at an international tribunal to actually prosecute the gang members.
It's an ambitious, I guess, option to get to, but in the meantime, Manny, what is the U.S. doing right now to help the people of Haiti?
Well, for years, the U.S. has contributed in terms of aid, millions of dollars of aid, either to fight hunger or to fight diseases. But the U.S. has been loath at this point to do anything that would include possibly putting U.S. troops on the ground. That doesn't seem to be part of the equation right now. So the U.S. has said that it will try to finance any possible mission that would bring some sort of security or stability to Haiti. What exactly that will mean? Well, that may be something that comes out of this meeting that is happening today in Jamaica, this meeting of the Caribbean nations there, CARICOM. But really, it's all up in the air at this point. And I think so many of the elected officials who have family in Haiti, or many here in South Florida, where there's a sizable Haitian American community, are concerned about family members really that are back there right now, struggling, just trying to stay safe. And there's also the possibility that you might have an outflow of people, of refugees from this turmoil, either trying to get into the Dominican Republic, other Caribbean nations. And as we know, here in South Florida, there have been boats that have arrived in past years with Haitians trying to flee the violence there. So all of these are concerns that are factoring in right now.
All right, Manny, thank you very much. Appreciate it.
Thank you.
Tensions are escalating between the U.S. and Israel as Prime Minister Benjamin Netanyahu vows to press forward with his country's expanded military operations in Rafah.
Yeah, over the weekend, President Biden drew a pretty wobbly red line, as he termed it, on the invasion, telling Netanyahu one thing for certain: he can't have another 30,000 Palestinians die as a result of this conflict. And the conflict has entered the holy month of Ramadan. That's officially underway. Israeli leadership had given Hamas until the start of this holiday to agree to terms of a ceasefire, but Hamas has not agreed to terms. And so without a deal, Israel is planning to move defense forces into Gaza's currently most densely populated city.
The escalating tensions between allies coincide with the additional airdrops of humanitarian aid. CBS News foreign correspondent Chris Livesay joins us from Jerusalem with more on this. Chris, Israel has yet to fully invade Rafah. So where do the ceasefire talks stand at this moment?
Hey, Earl and Tony. Well, right now they've failed. However, hope isn't completely lost. You know, as you mentioned, there was a deadline of coming to some kind of an agreement before Ramadan, which is just now starting this week. The reason for that is because it's traditionally been not just a time of prayer and fasting. It's the Islamic holy month, but here in Jerusalem in particular, it's also been a time of violence, prompting clashes between Israelis and Palestinians over Israeli security restrictions to Muslim holy sites here in Jerusalem. And so the hope was to just avoid creating an even more tense environment around that. But as I said, hope isn't completely lost. CIA Director Bill Burns was in the region this weekend pushing for some kind of a ceasefire in exchange for the dozens of Israeli hostages who have been held by Hamas now for 5 months.
Yeah, Chris, it seems like the sticking points on the ceasefire deal is Hamas wants a permanent ceasefire, not a temporary or 6-week one, and it wants all of Israel's forces out of Gaza completely. But the Israeli War Cabinet is saying they can't quit now. They can't go without going through Rafah to eliminate the final battalions of Hamas. So this red line talk from Netanyahu, or from Biden to Netanyahu, it was kind of all over the place. On the one hand, the president said you can't have 30,000 more dead. I think everyone agrees with that. But on the other hand, he said he would always stand with Israel. So what is the status of the relationship between these two leaders now?
Yeah, Tony.
Welcome back. We are continuing our gavel-to-gavel coverage of the James Crumbley trial as the court returns from a lunch break. We are now in day 3 of testimony.
The 47-year-old is charged with 4 counts of involuntary manslaughter for the deaths of the students who were killed when his son launched an attack on that school, Oxford High School, in November of 2021.
Today we've heard testimony from the school counselor and disciplinarian who both testified in Jennifer's trial. Let's listen in to some of that sound.
You didn't look in the backpack?
I did not, no.
You didn't, and I think you said you didn't have reason to look in the backpack.
I didn't have reasonable suspicion, no.
You didn't ask Mr. Crumbley's son to look in his backpack?
I did not, no.
You did not ask Mr. Crumbley or his wife to look in the backpack?
I did not, no.
You didn't look yourself or ask anyone else to look because you didn't feel that there was a reason to look in the backpack. Is that fair?
There was nothing from our conversation or from anything that we had heard so far that would indicate it was enough to reach to that level, correct?
And joining us are attorneys Richard Convertino and Arnold Reed. Thank you both so much for being here throughout the day. So Rick, it really seemed like the defense attorney was trying to perhaps place some blame, hope that the witness would give some sort of accountability in that instance. You didn't check the backpack, all of these things. Did you think that was effective?
I thought it was effective as she could with the card she was dealt. I think in sum and substance, this case comes down to the question that she asked EJAC, and that is the behavior, I'll quote her, the behavior that you saw in the shooter in that meeting did not show a pattern of what might have been. And that's the case. That's what they're trying to, that's what they must demonstrate. So if I stack dominoes from here to Arnold's mug, and they were lined up accordingly, and I tipped one, we could say that it's reasonably foreseeable that the dominoes would fall down and hit his mug at the end of the rail. But if there's a gap there, which is the case here, there's that gap. Will they go all the way to the mug? Is that reasonably foreseeable? And that's in sum and substance what they have to show. What the prosecution has to show is it would go to the mug. Criminal negligence, reasonably foreseeable. And what the defense has to say is there's a gap and it won't.
Yeah, so, and it looks like with the questions from the defense, Arnold, it's kind of along the lines of, we didn't know, you didn't know, how was anyone supposed to know? Is that an effective argument given that there were so many concerns?
At this point, I think it's perhaps one of our strongest arguments. I think we saw a very effective interplay between the skill, the knowledge, the expertise of the particular witnesses, especially the dean of students there, and their testimony with regard to, hey, we didn't see anything untoward where we would even search, have reasonable suspicion. And so naturally she's trying to impute that lack of knowledge, if you will, onto the parents. At this particular point, she's picking and choosing her arguments, as we've talked about earlier, and she's going in necessarily to try to elicit information to show the parents didn't know because the professionals didn't know. That's all she's got at this point, but I think she did a very, very good job. She's lobbing it out there. She, on recross, did an excellent job. Do you remember we talked about the prosecutor coming back saying, you didn't know this, you didn't have that information, you didn't have this. She came back in her recross and established that they had that information, right? And still didn't anticipate that Ethan Crumbley would have done this, so therefore how could the father have anticipated it? Brilliant job this time at cross-examination, a marked improvement from the first witness she crossed.
And there really seems to be an art to so much of being in a trial and being an attorney. You know, from your experience, tell us a bit about cross-examination. Obviously you come with a plan, but that plan can be thwarted based on what witnesses say, how they behave. I mean, the jury is watching every little thing. So how do you effectively cross-examine someone?
Well, that's an excellent question. The trick is not to have your theory thwarted on cross-examination, because in cross-examination, the star, the substance of the information comes from the attorney cross-examining. The only thing that you want from the witness is for him or her to acknowledge what you're saying is accurate, is fair, is true, and so you direct your examination and from the points of and the facts you want to elicit. On direct examination, the witness is the star. So you're asking the broad questions: who, what, where, why, when, and you're allowing them to explain, kind of like the reporter does. You know, what happened next? What did you see? Where were you when this happened? How did you feel? All of those questions are for direct examination coming from the witness, but not on cross. On cross, you have a theory of the case, you have a specific reason for asking questions, and you surgically and concisely go in there and direct the witness doesn't theoretically have a choice in the way they answer. And if they do, if you're inartful and you say, well, why did you do that? What happened then? You're allowing that witness to direct their examination and to control the information that's elicited from the witness and goes to the jury's ears.
Just to echo that, if I may, that's an excellent point. A very smart person once said, cross-examination is the greatest invention to the discovery of truth. And I believe that. One of the most important things about your cross-examination, as Rick said, you want to continue to build on your theme. Understand what you cannot get out of a witness and understand what you can. On cross-examination, more important than a witness's answer is the question that you ask, because the jurors are paying more attention to the question that you ask juxtaposed to the witness's response. You still have to be artful, though, to control the witness and keep the witness within a certain rubric, which we did not see the defense do with the first witness. The second witness, it was short, nothing short, in my opinion, of masterful. It did go on a little bit longer. And what happens in cross-examination, the longer you ask questions, the more credible it makes the witness seem. So if she could have tightened it up just a little bit to shorten it, I think it would have been almost a perfect cross-examination of that witness. And one final thing, her demeanor. Jurors don't like mean attorneys. So no matter how artful you are in cross-examination, if they feel that you're badgering the witness or pushing or bullying the witnesses, it's going to be ineffective. I think her demeanor right now is excellent.
Something we also mentioned with the first trial that we saw, that behavior.
Yes.
Yeah, we saw a little bit of foreshadowing, it seems, too, with accountability being placed on the school. You know, not going too far into it, but at least having the conversation that you all played a role in letting this slip through so many fingers, too. Did you see any of that?
Oh, yeah,
that was effective?
Replete through. I don't think it was effective because, it may be effective right now, but I think at the conclusion of the case, it'll be drawn back to the jury's attention that this is not a civil case, and that I would argue that, you know, you heard evidence in this case that the school, you know, dropped the ball, and that EJAC, maybe he dropped the ball, and that Hopkins probably dropped the ball as well, and what they could have done to prevent this. But ladies and gentlemen of the jury, that's all for another day. That's for a civil case. That's not what we're here for. We're here for the criminal culpability of the defendant, James Crumbley. And I think that can be brought back to the jury's attention, because it's not a matter for them to reflect upon what the school did or didn't do. That's for another time and place.
If I may, I'd like to ask my colleague a question. Maybe you think this is important, Rick, maybe you don't. There were a few instances, if you noticed, she would lean over to Mr. Crumbley, ask Mr. Crumbley a couple questions, and you could kind of tell he was a little adamant about whatever he was telling her. And at one point, after that exchange, she stood up and asked more questions. Do you, as a trial lawyer, with your experience, put any stock in the perception that a juror may have when you're talking to your client like that, or just having your client surreptitiously write out questions?
I prefer my client to write out questions. Now, I've been lucky to have kind of in my defense practice a little different type of defendant than is typical. I represent a lot of law enforcement officers and special agents in the various federal agencies, and they're extraordinarily knowledgeable about things like the use of force continuum, you know, or particular issues regarding law enforcement. And so if there's an answer, or I'm sorry, a question that I need to ask, that they think I need to ask, I can give you a good example. There was a law enforcement defendant I had who wrote me a note, and he wanted me to ask about the painting by light, which is a way that evidence detectives can open the exposure on a camera to make piece of evidence look a little different. So I had no idea about that, and I asked that question knowing and relying on my client's expertise, and it was a very good question that was damaging to the prosecution.
That's an interesting perspective. I've talked to a number of jurors, and I think jurors that look at a client writing too much, they think that they're conspiring, or if they're talking too much, they're conspiring. So I think if it's a healthy dose of it, not anything that's excessive, I think it really helps. But I just noticed that, and she may not want to do that because it's extensive conversation back and forth with him, and it's a whispering thing. The jury may think they have something to hide, a subtle thing, but when you have a number of trials and you talk to jurors about that conduct, they're really vocal about what they see and perceive.
You gotta watch everything you do and say. The jury's actually walking back in right now, so we're gonna go back into the courtroom as they continue that testimony. Be mindful of what you see and hear. Those details could be very disturbing.
Okay, please step up and have a seat. And then state your name for the record.
It's Brandon, B-R-E-T-T-B-R-A-N-D-O-N.
Go ahead, prosecutor.
Good afternoon.
Good afternoon.
All right. Special Agent, can you tell the jury what role you're playing here today and during this trial?
One of the officers in charge of this case.
Okay, and what does that mean?
It means that I've been assigned with Lieutenant Willis to usher this investigation through the prosecution.
Okay. This Lieutenant Willis?
Yes.
Okay. He's normally sitting right here. He's also an officer in charge?
Yes.
Okay. And can you tell the jury what your occupation is?
Yes, I'm a special agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives. It's commonly referred to as just ATF.
And what does the ATF do?
The ATF enforces the nation's firearms, arson, and explosive laws. Obviously, we primarily focus on the firearms laws.
And so you're employed by the state or the federal government?
The federal government.
Okay. As part of that, well, I'm sorry, let me get to this. A little bit about your experience and background that brings you here to testify. How long have you been a special agent? How long have you been with the ATF?
It'll be 15 years in July.
Okay, how long have you been a special agent?
Been a special agent for, it'll be approaching 11 years in July.
And what does special agent mean?
A special agent, so if it means we're a criminal investigator trained in investigating for the purposes of ATF, the crimes underneath the jurisdiction of ATF, but also we assist with other federal investigations and obviously state and local investigations. For ATF, primarily involving the use of firearms.
And what is your educational background?
I have a degree from Oakland University in political science. I spent 1 year at law school at the Catholic University of America, and then obviously I was trained at the ATF National Academy for the requisite training to become an ATF agent.
Is part of your role in the ATF based? You're based in Michigan, live in Michigan.
Yes.
Okay. Do you have any interaction with state investigations, and if so, what are they?
Yes, I've had many throughout my career. Right now I'm assigned to the Pontiac Gun Violence Task Force. It's a partnership between the Oakland County Sheriff's Office and the ATF. In that role, we investigate both state and federal firearms violations occurring within the city of Pontiac, primarily shootings.
And do you ever respond to or have anything to do with investigations that don't involve shootings?
Yes.
What kind of?
So generally, for whether it's the task force or just as an ATF agent, it's primarily the criminal possession and use of firearms.
So in other words, it doesn't have to be a shooting, it could just be a possession of firearms?
Yeah.
Okay.
Yes.
About how many shooting investigations have you been a part of?
Hundreds at this point in my career.
And do you, as a part of in your role, have a general understanding of the laws associated with purchasing firearms, both in the state and federally, or just federally?
Both. Specific to this investigation, it would be both. Yes.
Okay. Can you tell the jury what FFL stands for?
Yes. So an FFL is a federal firearms licensee. I think we heard testimony obviously in here before from Kami Beck. She was the employee from the gun store in Oxford, as we're referring to it. That would be a federally licensed gun store, which is the technical term for that is a federal firearms licensee.
And in order to become a licensee, what does that seller have to do or comply with?
So there's an application process that they have to go through with the ATF to become a federal firearms licensee.
And then are there guidelines or requirements they must follow?
Yes.
All right. We're going to get to that in a minute. Do you know James Crumbley?
I do.
And how did you come to know James Crumbley?
I became aware of who James Crumbley was the date of the shooting on November 30th, 2021, and I had contact with him inside of his residence during an execution of a search warrant that night.
Do you see him in the courtroom here today?
I do.
Can you describe something he's wearing?
He's wearing a white shirt, a blue tie, and headphones.
May the record reflect he's properly identified the defendant, Your Honor.
The record will reflect in-court identification of the defendant, James Crumbley.
Thank you. What, if anything, did you review in your role as officer in charge in this case?
A vast amount of information. So there would be the returns of 7 cell phones that were forensically extracted, social media returns, financial information, firearms records, including from the federal firearms licensee, and other documents and records, and surveillance video, obviously.
You were in the courtroom. Were you in the courtroom when Ed Wogrowski testified about forensic cell phone data?
Yes.
And can you tell the jury what software or program you used?
Yes.
Objection, Your Honor. The question is what Mr. Wogrowski used. I don't know that Agent Brandon knows that.
I corrected myself in that question purposely to say what you used. Are you aware of what was the investigation tool they used in cell phones?
What the ATF used?
They both did. I'm trying to lay a foundation. Are you aware of, may I ask the question, Your Honor?
Go ahead.
Are you aware of that tool?
Yes, it was the same tool. So Detective Wogrowski used Cellbrite, put it in a readable format. When he spoke about a readable format, it's Cellbrite, and that's the format that I reviewed the forensic extractions in.
Okay, which is what I was trying to get at. You have experience. Do you have experience in this investigation reviewing the Cellbrite information, which is the cell phone data?
Yes.
Okay, thank you. I want to draw your attention to November 30th of 2021 and ask you to first explain where you were when you heard about the shooting.
So I was in the ATF headquarters for the Detroit Field Division in downtown Detroit. I was in an office that I shared at the time with my partner, and the assistant special agent in charge at the time came in. He knew I was from the Orient-Oxford area and let me know that there was a shooting at Oxford High School.
You currently are there, or you grew up there?
Both.
All right. What did you do?
I grabbed my bag and I ran out the door.
Did you go with anyone else? Was it discussed about what you were planning on doing, what the plan was, who was going, who wasn't going?
No, I just ran out the door and got to my car in the parking structure, turned on the lights and sirens, and then drove up I-75 in towards the direction of Oxford High School.
Do you typically work with a partner?
Yes.
Was he there that day?
He was.
Did you let him know you were going, or did he come with you?
At the time, no, I didn't let him know. He was stepped out for a minute, and I didn't even think about it. I was so focused on getting to the school.
Okay. About how long or does it take to get from Detroit to Oxford School?
It depends on traffic. It could be an hour. It could be more. It could be a little bit less, just depending on the time of day.
And did you have a familiarity with the area?
Yes.
Okay. What, if anything, did you know about that incident when you left?
All I knew when I left was that there was a shooting. As I drove northbound, I did receive information from our intelligence unit that there was a confirmed shooting. It was not a false alarm.
Okay. And what did you do as a result of that?
I continued to drive north on I-75, and at some point, I believe it was in Troy, met up with other law enforcement, forming like a caravan, like others have Detective Wogrowski testified to, traveling north on 75, and then getting to the exit at exit 81, where the old Palace of Auburn Hills used to be.
So the caravan, were there other people on the highway?
Yes.
Did this whole caravan, was it just law enforcement?
It was law enforcement. I believe at one point there was even a news truck trying to follow the caravan. I wasn't sure if they were aware, but I think they were just running parallel with the caravan.
And was it licensed sirens?
Yes.
Okay. What kind of rate of speed?
It was very fast, but it was as safe as we could be.
Okay. Can you tell the jury and describe what it was like driving up to Oxford School that day?
Your Honor, I'm going to object to the relevance.
Yeah, why is it relevant?
Because he's describing the scene and what he did and how he got into the school, and it was the scene of the shooting, and he was part of the investigation of the shooting.
Okay, so start there. So you arrive at the scene, you arrive at Oxford High School. Is that where you went first?
Yes.
Okay.
Can you describe the scene in terms of, was it easy to get there? Were there cars? Were there students? So as we're getting to the school through, obviously, Lake Orion and Oxford, to travel through there, all the cars were parked on the right side of the road. And so, it was almost like the left lane, there were no cars in it, and people knew what was going on at that point. It had seemed that word had spread because no one was moving. It wasn't just like you normally would get over and then get back over in the left lane. People were just parked on the road. As I got in towards the school, I started noticing that there was a large group of people at the Meyer, and obviously learned later that was the reunification point. When I arrived at the school, there were a lot of law enforcement personnel. I can't even put a number on it. It was dozens, maybe 100 in the main vestibule area where like the front offices were located. So when you arrived, were there more than one law enforcement agency? Was there more than one represented? Yes, there were quite a few. Okay. Did you know anything about where the alleged shooter was? Whether there were victims? What did you know when you approached the building? At that point, I had a conversation with someone in our intelligence group that had confirmed related information that they had received that there were fatalities, there were injured victims. Did you know whether or not the shooter was in custody? No, I didn't. I assumed that I didn't hear any gunfire when I got to the school, so I assumed that either the shooter was in custody or it was a barricade. I wasn't sure what was going on, but I knew that it was not an active shooting scene. Did you do anything before you entered the building? Were you carrying a weapon? Yeah, so I put on my vest and then ran to the front of the school with other people from the parking lot that were approaching the school. As I got closer, the person at the door verified my identity as a law enforcement officer, and then at that time was informed that the shooter was in custody and that they were starting kind of to figure out who was going to be responsible for what inside of the school. As you can imagine, it was a very chaotic scene. And okay. You mentioned a vestibule when you earlier. What do you mean? It was like the front area in front of like the front of the school where you have like offices where you check in if you were taking your kid out sick for the day. It was the main office area, and that's where I was directed to meet with Lieutenant Willis, who was identified as being the officer in charge of the scene. Is there a difference between the phase of clearing a crime scene versus evidence collection? Yes. Can you tell the jury what the difference is and what comes first and what that is like? Sure. So at least the way ATF is trained, it would be an active shooter response, would be a train and to find and eliminate the threat. After that has occurred, you have a clearing of the school, tactical clearing of the school to ensure there's no other bodies, secondary devices, or things of that nature. In this instance, it became clear that there were two things going on at once. There was people volunteering to clear the school for a second time, and then there was Lieutenant Willis, who was directing more of the investigative aspects of this case. When you arrived, do you know about what time you arrived? I don't recall exactly what time I arrived, no. Okay. Were there still students in the school? Not. If there were, if they were in classroom, I wasn't aware of it. I did not see any students when I got to the school. Was part of your role to engage in clearing the school? So generally, yes, with ATF, we would be involved in clearing the school, the active shooter response, the clearing of the school, and then the investigation. I mean, when you got there that day, did you help clear the school? I did not. Based on the fact that the investigation had started, that the shooter was in custody and they had the weapon secured, I thought the best use of my abilities as an ATF agent would be to start the trace of the firearm to determine how it ended up there. Okay. You just said you found Lieutenant Willis
Is that correct?
Yes.
Okay, where was he standing?
He was standing in front of the school offices. At one point, he was standing on a chair directing people around. Like I said, it was very, very chaotic. But I found Lieutenant Willis, and I believe someone had told him I would be coming to help trace the firearm, and that's when I went over and located it.
And before that, had you ever met Lieutenant Willis?
No.
Okay. And what happened next?
So Lieutenant Willis held up a trash bin that had the murder weapon, several magazines, ammunition, and the shooter's cell phone inside, and I was able to take photographs of it.
Okay. A trash bin, a plastic trash bin?
Yeah, so a trash bin, not a one you throw like a school lunch in, but like a small one you have in like an office, like a square or rectangle trash bin.
And if you know, what was it doing there? Or how did it get there?
It was my understanding that evidence was placed in there to keep it safe while they were continuing to clear the school.
Okay. And you said he held it up, and then what happened?
I took photographs of the evidence, specifically the markings on the firearm that I needed to start the tracing process.
And when you say markings, what do you mean by markings?
So the firearms are required to have a make, model, and a serial number. Those three items are necessary to start the trace for ATF to determine where it was first sold.
Did you actually physically pick up the weapon?
I don't believe so. I don't think we wanted to preserve the evidence. I believe that the firearm was already flipped in a way that had the markings visible. I believe I just took a photograph of it and then provided that information to the intelligence group that would initiate the actual digital part of the trace.
Okay. Once you did that, what did you do next?
So once that process had been started, I went to Lieutenant Sam Marsban, who I had known from the Oakland County Sheriff's Office based on prior investigations, and in Pontiac, and asked what could be done, what needed to be done. And at that time, I began collecting facts for the timeline for a search warrant affidavit for the Crumbley's family residence.
Okay. Did you? Well, we'll get to that. As part of your investigation, did you ever look at the surveillance video of the shooting?
Yes.
Okay. Before we get to that, did you? What are the steps, and how long does it take to trace the firearm through the ATF?
So the timing of every trace is going to be different based on the records and how fast they're able to get to ATF. So it'll help you to understand the tracing process starts with those three things, right? The make, model, and serial number of the firearm. Once you have that information and you input it, you can trace it back to the first manufacturer, right? And when the manufacturer is then contacted by ATF, they can tell you which federally licensed gun store they sold it to, and then that gun store has to tell you who was the first person that purchased that firearm.
And did you learn who that was?
Yes, it was an individual in Rochester, Michigan, that obtained the firearm from the gun store in Oxford.
And then, was that person contacted?
Yes.
And were they contacted by you or someone on your team?
It was two ATF agents assigned to the same division I'm assigned to.
And what did they learn?
They learned that that individual had sold the firearm back to the Oxford gun store sometime in early September.
And then what did they do?
They went to the gun store and spoke to Ms. Cammie Back, who testified previously, and learned that the firearm was indeed, in fact, purchased by Mr. Crumbley on November 26, 2021.
So 4 days earlier?
Yes.
Okay. And if we can stop for a moment, did you just say September?
I meant November.
Okay,
sorry.
thank you. Thank you to Mr. Case who pointed that out. November, correct?
November,
okay.
Yes.
If we want to stop here for a moment, walk us through a general purchase of a firearm through a federally firearm licensee.
Sure. So if you walk into a gun store today to buy a firearm, you'd have to fill out what Ms. Back testified was called an ATF Form 4473. It would have information about yourself as well as information about the firearm you're purchasing. The FFL employee then would contact the National Instant Criminal Background Check System, the NICS system, through the FBI. And once they're given the okay to sell you the firearm, they proceed with that.
Do you know if that protocol and procedure was followed here in this case? All right. You just stated that in order to buy a firearm, you have to have go through all those steps. Is that all guns? Do you have to go through this process?
So for every firearms sale from a federal firearms licensee, you do have to fill out the ATF 4473 and have those steps be fulfilled, yes.
Does that include all guns, long guns and pistols?
Yes.
Okay. And are there differences in long guns versus pistols?
Yes.
In terms of who can buy them and where?
Yes, in terms of age and things like that, there are different restrictions on the types of firearms you're purchasing.
Okay, and in general, how would you describe the restrictions on what is more restricted and less restricted?
Sure. So under federal law, if you're going to buy a firearm from a federal firearms licensee, you have to be 21 years of age to buy a handgun and 18 to buy a long gun. That would be either a rifle or a shotgun.
All right. And what about registering a weapon?
So there's no federal requirement for registration of a weapon. There is, however, obviously based on my experience in this case and others through the task force work, I'm aware obviously in Michigan that there are certain registration requirements for handguns.
And why the same requirements for long guns?
No.
And do you know why that is?
Objection, Your Honor. Speculation.
Only if you know. Did you?
I have to ask him first if he knows. That's what I'm trying to do.
Did you say in the state there is a federally, but there's a state?
Correct.
Okay. State of Michigan.
Through your position in the ATF, do you know why?
I think that's my question.
Yes, I thought he did.
State of Michigan.
It is the state of Michigan.
Thank you.
Do you know why there are more restrictions on handguns?
I believe it's due to concealability.
Okay. Under state law, who can register a weapon?
Under state law, register a handgun?
Yes.
Okay. So under state law, you can register a handgun at 18 years old, but obviously you can't buy one until you're 21 from a federal firearms licensee. So you can, in one way, buy a private sale from someone that's 18 to someone that's over 18, and then register that firearm. So I have seen through previous experience that you could register a weapon at 18, a handgun, but you could not purchase that handgun from a federally licensed register, if that makes sense.
Okay. Were you made aware at some point if James Crumbley owned any other weapons other than the weapon he purchased on November 26th?
Yes.
Your Honor, I'm going to object to the reference of a weapon. I think it's a vague question. I think what Agent Brandon is aware of is alcohol, tobacco, firearms, and explosives. I think that the classification of a weapon is vague. If the prosecution is asking about firearms or handguns or pistols, then I think that should be the question and not specifically a weapon.
Well, his response can clarify that.
Correct, Your Honor.
Right? So go ahead.
You were made aware what other... the reason I'm using weapon is because I don't want to specify because I'd be leading, so I'm trying to get him to explain it without asking a leading question. You were made aware, what did he also own or purchase, if you know?
So in June of that year, he had also purchased a Cobra Classic Derringer and also a Keltec P17 .22 caliber pistol from that same gun store in Oxford.
So that was about 5 months earlier?
Yes.
Okay. Were both of those guns bought at the same time?
They were bought within several days of each other, but they were not bought at the same time.
And how did the gun store have any record of those sales?
Yes.
And what was it?
So they had the 4473 documenting the sale of the Derringer, as well as a sales receipt and a Michigan pistol sales record documenting the sale to Mr. Crumbley for both the Derringer and the Keltec pistols.
Okay. So you've indicated now 3 separate handguns. Do I have that right?
Yes.
Okay. All right. I am going to start asking you about each of these handguns and describe the difference in each. I'm putting on gloves because this is evidence and I want to touch it with my gloves on. And the first handgun I'm going to ask you about is the handgun purchased on November 26th. Do you know what type of handgun it was?
Yes.
What was it?
It was a 6-hour SP 2022 with a specified serial number.
And so, was it a 9mm?
Yes, it was.
Okay. This is all right. So, before I do that, Special Agent Brandon, what is the way to handle a handgun safely before you even pick it up? I know there are firearm safety guidelines, but how do you make sure when you're handling a weapon for the first time that you're doing so in a safe way? Before
object to relevance, Your Honor.
Response?
I think the element of the crime that the defendant is charged with goes back to a legal duty in handling and storing a firearm, and so I absolutely think it's relevant.
Okay, do you mean picking it up or?
In every way.
Okay, I'm going to allow it.
Thank you. How do you safely pick up a handgun?
Sure. So based on the fact, so there is a zip tie in it, so everyone is aware that firearm has been made safe already, but for the purposes of this, so if you pick up the firearm, you want to keep it pointed in a safe direction, you want to keep your finger off the trigger, and you want to visually and physically inspect the chamber of the weapon and the magazine well of the weapon to make sure that it's not loaded.
Okay, so I'm going to pick up this. We know that is this the murder weapon?
Yes, it is.
All right. And we know that this has a zip tie in it.
Correct.
Okay.
Can you specify what exhibit number that is?
Yes, I'm sorry.
163.
163. I think it's either admitted or there's no objection to it.
Correct.
Okay. This is the murder weapon. There's a zip tie in it. But even if there isn't, the general principle is to make sure the firearm is safe. You just said you physically examined the magazine well. Is that this right here?
Yes, that's correct.
Okay. And then you also have to do a second step, did you say?
Yeah, so the same thing. So I would say physically and visually inspect the chamber of the weapon. So down the barrel, if you look down the barrel right
so
there.
Right here?
And to make sure there's not a round inserted into the chamber of the firearm.
Okay. And again, there's a zip tie in here, but in order to comply with that, you have to physically inspect to make sure there's no round in this chamber.
Correct.
And why? What's the reason for that?
So with firearm, there's four basic principles of firearm safety. I mentioned two of them. Number one is to treat every firearm like it's loaded. Number two is to point the firearm in a safe direction. Three would be keep your finger off the trigger, and then obviously not for court purposes, but if you're at a range or shooting, is to be mindful of your target and what's beyond it. At least that's the way ATF trains the four pillars of firearm safety. So the purpose would be to make sure that firearm is not loaded, that in case the trigger was accidentally or unintentionally discharged, that there's not an actual round in the chamber to be discharged.
Is it possible for a firearm to discharge without touching the actual trigger?
That would depend on a lot of different factors, including the type of firearm.
Okay.
I probably can't answer that question.
Okay, thank you. So you mentioned earlier that you have to identify certain markings. Where are, and I'm going to give you some gloves if you don't mind. We practice with the gloves, so it doesn't take this long, but it's still okay. If you wouldn't mind standing, if that's okay with the judge,
okay.
I'm going to hand this handgun to you, safely pointed down, so you can show the jury what markings you're talking about to identify the weapon.
So as you can see right here, it's kind of hard to see with the light, but it says Sig Sauer. That would be the manufacturer. And then you have the serial number as well as the caliber generally also stamped on there as well.
Okay. Thank you. I'm going to put this safely back into its box. And then do you know what these are?
Yes, those are the pistol magazines that come with the Sig Sauer SP 2022.
Okay. And just in case there are people on the jury that don't have a familiarity with handguns, what are these for? What's inside here usually?
So in a semi-automatic pistol, you would load your ammunition. Those magazines, I believe, can take up to 15 rounds. So you load the 9mm ammunition to capacity to 15 rounds, and then insert that into the firearm. And then once you send the slide forward, that is what allows the round to be chambered into the firearm to be ready to be discharged.
So it has a 15-round capacity.
So it would have a 15-round magazine capacity. You could also fit 1 round in the chamber, so that firearm has a total capacity of 16 rounds.
Before you would have to reload.
Yes.
Okay. So can you explain to the jury what semi-automatic means?
So a semi-automatic firearm means that for every pull of the trigger, it only fires 1 projectile from the firearm, as opposed to a automatic firearm, which would be that if you pull the trigger 1 time, multiple rounds are dispelled from the firearm with 1 pull of the trigger.
The other 2 weapons you stated were a Derringer and a .22, correct?
It was a .22 caliber Derringer and a .22 caliber Cobra Classic, or a .22 caliber Kel-Tec pistol.
Okay, so Kel-Tec. All right. What is the difference between those 2 guns and a 9mm?
So a Kel-Tec, the Kel-Tec pistol is also a semi-automatic pistol. It's just chambered in .22 caliber as opposed to 9mm. It's a smaller round,
and again, you say round, and I think for lay people they think of that as many. But what do you mean when you say round?
So I know that there's been some talk in this trial about bullets. Bullets are the part of the piece of ammunition that comes out of the firearm when it's shot. The round of ammunition is what's inserted into the magazine before it's fired. That has the fired cartridge case, the bullet itself, and then some type of propellant or powder, usually smokeless powder.
Okay, so a bullet is what comes out of the shell casing and is expelled from the chamber, but a round includes the shell casing and the bullet and any kind of, what was the last name?
Yes, it would be like the powder that's used to yeah. So
Okay.
it would be the round of ammunition is the actual full piece of ammunition prior to being fired.
Okay. And does the .22 that James Crumbley owned, does it shoot or fire faster? Does it have a larger capacity magazine?
So I'm not an expert on ballistics and traveling the speed of firearms, but as far as capacity goes, it's got, I think the Kel-Tec P17 has a 17 round total capacity, but the actual round of ammunition itself, the 9mm versus the .22, the 9mm is going to be a wider round. So what the caliber refers to is the diameter of the bore, the inside of the barrel. So it would mean that the 9mm round is bigger, and based on the size of the round, it's got more. It's going to be heavier. So the damage from that round would be more than a .22 caliber round. If that makes sense.
What kind of handgun does law enforcement usually carry?
9mm generally. At ATF we carry 9mm. Most of the departments and agencies I work with carry 9mm.
And do you know why?
Your Honor, I would object to relevance.
How is it relevant?
It goes to the power and the use for a 9mm versus the weapon that the 2 handguns that James Crumbley already owned.
I guess I would have normally agreed with you, but we've heard testimony in this trial that the shooter was intent, even after the family owned 2 other guns, on having his father buy a 9mm. So I'm going to allow it.
Thank you. Can you tell the jury why law enforcement usually carries a 9mm, or you do at ATF, if you know?
Sure. So my understanding, based on the reasoning that ATF uses and other agencies, is that it's a powerful round that can be used to neutralize a threat. It's not going to over-penetrate, and the advancements in ballistics have made a 9mm the ideal round for law enforcement for using in defense.
And to put this into context, the hundreds of shooting investigations that you've conducted or have been a part of, are those done normally with a .22 or 9mm or something else? If you can say
Sure.
generally.
I don't think I can't recall working a shooting with more than one victim involving a .22 caliber firearm. I can't recall several shootings that I've worked in the past with multiple victims involving a 9mm.
All right, thank you. I'm going to put this back in the evidence box and hand it to Lieutenant Willis, who is in charge of...
Your Honor, may we approach, please?
All right, there's just a brief pause now. They blocked the audio because the prosecution and defense have approached the stand to just ask the judge a few questions, clear out a few things. What would you say, Arnold, this is? How would you describe this in legal speak?
It's very hard to describe other than, and Rick and I were talking about it extensively during the break, it's a lot of things that he's being able to testify to that he's not qualified to testify to. He's allowed to testify to caliber of weapon, how much it weighs, why you use a 9mm versus any other type of a handgun. And I am just astounded that this testimony is allowed to come in at this point. He's even admitted that he's not an expert. And again, during the break, Rick and I were literally fit to be tied about what we saw here. So I'm gonna throw it over to Rick.
Just to explain what's going on right now by the defense attorney wanting to approach the bench. You've been harping on this since the first trial as well. It's just critically important to mitigate the amount of times that the opposition can use speaking objections. A speaking objection can be devastating. It allows the person doing the objecting to kind of focus and gather the information that you want to get across and the purpose you're asking the question, and telling the jury in an improper way why you are asking this question in the ostensibly as an answer by the judge for what's your response to the objection. So the defense attorney is doing a good job. She keeps saying, listen, I want to approach the bench, to cut that off, because it can be absolutely devastating. You know, objection, hearsay, what's your response? Well, I'm trying to get this in, judge, because, and boom, boom, boom. And the jury hears that. And it's very, very important to keep that kind of objection out. Now, I would expect that at some point in time, you know, if it gets out of hand, which it has, that the defense would say, listen, I want to address this off the record. I want to make a formal objection in order to protect the record. These continuous speaking objections are highly prejudicial to my client.
And why is it important to protect the record?
For purposes of appeal, any objection that you make, if you don't make an objection, you can't appeal that issue, right? With certain narrow exceptions. So that's the most important reason, is to protect the record.
All right, it looks like we have audio back in the courtroom. Let's listen in.
Introduce Exhibit 164. And okay, what is this?
That's the Cobra ENT Classic 2-shot 22 caliber Derringer purchased by Mr. Crumbley. I believe he paid for it on the 15th of June of 2021 and picked it up on the 16th of June 2021.
Okay, and this is pretty small. Okay, so what is this used for, typically, if you know? And how many rounds can it hold?
It can hold 2 rounds. I mean, in today's, I don't know if I can say exactly what it's used for. People use firearms for very different purposes, but you know, I know that that's been used in the past for a variety of different things.
Okay, thank you. And again, this was purchased when, if you know?
It was June 16th of 2021.
Okay. And that was 164. Okay. And this is 165. And again, do you know what this is?
Yes, that's the Kel-Tec P17 22 caliber pistol purchased by Mr. Crumbley on June 17th of 2021.
Okay, and if you know, how was this weapon made safe by you or somebody else before I handle it?
Yes.
And how was it made safe?
When I was going through the last trial, cutting off zip ties and putting new ones on, racked the slide 3 times, made sure there was no round in the chamber, and then myself and Lieutenant Willis installed zip ties on firearms.
Okay, so there's a zip tie in this?
Yes.
Okay. And again, can you tell the jury what this is? What caliber of weapon this is?
Yes, that's a 22 caliber pistol.
Okay. And in a moment, we're going to see the defendant's son handling it, a video. Is this the weapon that he was handling in that video?
Yes.
Okay. I'm going to hand this to you because I'd like you to explain to the jury how to safely handle this weapon in terms of what the safety means on and off. Can you do that?
Yes.
Okay.
Sure, go ahead.
So this is the Kel-Tec P17 pistol. So it's not an official phrase, but it's what one a lot of people use is red means dead. So when the safety is off, you can see the red dot. So to engage the safety, you'd have to, put the safety up. I don't think it's going to do that now with the, well, it'll go up now. Yeah, with the zip tie, sometimes it's hard to get the slide to go all the way forward. But now the safety would be engaged. So if you pull the trigger, it's not supposed to fire. And when you come back down, that means red means dead. That means the safety is off.
Okay. And that, is this also, do you use a magazine with this gun?
Yes.
Okay. And how many rounds, if you know, does it hold?
16 rounds in the chamber, 1 round in the in the magazine, 1 round in the chamber for a total of 17.
Okay. Were there any gun cases recovered in the home?
Yes.
All right. I'm handing you what's People's Exhibit 166. Can you tell the jury what that is?
Yes, this is the pistol case that goes with the Kel-Tec P17 pistol that I was just holding. It was located in the kitchen under the, I guess the island in the kitchen of the Crumbley residence.
Okay. And can you, if you wouldn't mind standing and showing how that is opened and what it looks like?
And this is the 6-hour, the cable lock that comes with the 6-hour pistol that was
We're going to get to that
inside the Kel-Tec box.
So this is proposed exhibit 42. This case was this cable lock found in this case?
Yes.
Okay. And you said it was located in the kitchen?
Yes.
Where exactly in the kitchen, if you know?
I believe it was one of the cabinets underneath the island of the kitchen, or a kitchen cabinet.
Okay. Was there any gun in it?
No.
Okay. Thank you.
That's the Kel-Tec box, right?
This is the Kel-Tec box, 166. All right. And was there any other case found in the home?
Yes, one
gun case. Okay. I want to just make the distinction here. Is there a difference between a gun case and a gun safe?
Yes.
Okay. What is it? And when I'm saying safe, I mean a portable safe.
Sure. So a gun case is generally what comes from the manufacturer, or sometimes a gun store, if they're selling you a used firearm, will use an old gun case to give with you. But the Kel-Tec box I was just holding has 2 holes in it that can be locked. That's a gun case. That's what comes with the purchase of a firearm, specifically a handgun most of the time.
Is this what you're talking about?
Yes, there are holes on both sides that a locking mechanism could be run through to lock the case itself.
Did you find any of those locking mechanisms, or was it found just like this?
There were no locking mechanisms in it when it was found.
Okay. I'm going to hand you People's Exhibit 167. And you might have to stand to show the jury so they can. Do you know what that is?
Yes, this is it's a small pistol safe. So it's got a combination lock, and so it would just, you close the lock, it's typical your standard combination lock. You close it, spin the dial, and have your combination code.
And do you know where that was found in the house?
Yes, it was in the on a TV stand in the Crumbley, Mr. and Mrs. Crumbley's bedroom on the right-hand side, inside of a cabinet.
All right. And was there anything in it?
Yes.
What was in it?
So there was the Kel-Tec P17 pistol, as well as a Derringer 2-shot 22 caliber handgun as well, both inside this safe.
And that was the small gun that we just showed the jury, correct?
Correct. Yeah, they both fit in here.
And then the Kel-Tec that you just showed them with the safety.
Yes.
Those 2 weapons.
That's
okay.
correct.
So
this one.
there's a combination on this safe?
Yes.
And do you know what the combination was?
Well, I know what it is. I just opened it. It's 000.
Okay. Was this the combination at the time when this safe was found?
Yes.
Okay. Does the SIG fit in that gun case?
It does not.
Gun safe.
It does not fit.
Even if it's just by itself without any other handgun?
Correct.
Okay. Was there any other case found in the home?
Yes.
And I'm going to hand you what's been marked as People's Exhibit 41. And what is this?
This is the.
Go ahead.
This is the Sig Sauer SP 2022, the murder weapon. This is the pistol case that would have came with it. Similar to the Kel-Tec, it does have 2 holes to be locked as well.
Okay. And I'm going to open that. All right. And where was this found, if you know?
This was found on the on top of the bed in the Mr. and Mrs. Crumbley's bedroom.
Was there anything in it?
At the time, no, it looked like this.
Okay. Was there anything underneath the phone?
I learned later that there was, yes.
Okay. Do you want to tell the jury what that was?
Yes. So there is a receipt for the SP 2022 from the gun store in Oxford, as well as the ATF Youth Handgun Safety Act notice pamphlet that was previously discussed.
Okay. And is that something they have to provide?
Yes.
All right. Special Agent Brandon, what was your reaction to finding that? When did you find that the pamphlet was in here? If you know.
For this pamphlet, I found that this was in the case during preparation for the trial of Mr. Crumbley's wife.
And did you know where it was up until that point?
Your Honor, I'm going to object to relevance on this line of questioning.
About where it was?
Mm-hmm.
I guess I didn't really understand the question, where that box was?
So I don't want to put words in his mouth, but as an offer of proof, it was not clear to Special Agent Brandon, based on the crime scene and the search of the home, where the ATF pamphlet was that he knew must have had to have been sold with this gun. And he picked up the phone and saw it sometime after, is what he's saying.
Okay.
So not the case itself, Your Honor, but the pamphlet that was within the case along with the receipt. I'm objecting to the relevance of questions about that, not the case itself.
Okay, well, I think the pamphlet being sold with the gun is relevant, and its location in the home is relevant, so I'm going to overrule the objection.
Thank you, Your Honor.
Thank you, Your Honor. And I'm going to ask him about the pamphlet and ask to read excerpts of the pamphlet, and I know that opposing counsel actually asked Ed Wagrowski to do that, so I'm hoping there's not an objection, but I can lay a proper foundation if there is.
Okay, now I don't know if he answered the question about where he found the pamphlet.
He didn't. Thank you, Your Honor. What was your reaction to that?
To finding the pamphlet?
Yes.
So when I looked at the phone and saw the pamphlet in there, I was shocked.
Okay, why?
As the pamphlet says on the front, it says Youth Handgun Safety Act notice. Means they were on notice. They had to pick this up and move it to the back of that gun case and basically discard it underneath the phone.
Okay, and can you tell the jury what's the purpose of the law requiring that pamphlet to be given to someone purchasing a gun?
The purpose of it, do you want me to read from it?
First, I want you to tell me the purpose, and then I want you to read.
So the purpose of the pamphlet is to inform the buyer of the firearm that juvenile gun violence is a major problem, and that safely securing your firearm will prevent that from happening.
Okay, and if you open it up, where does it refer to that?
So on the first page it says Youth Handgun Safety Act notice, and there's 4 bullet points. The first says the misuse of handguns is a leading contributor to juvenile violence and fatalities. And the second one says safely storing and securing firearms away from children will help prevent the unlawful possession of handguns by juveniles, stop accidents, and save lives.
I can do that. Thank you. Your Honor, we've marked the pamphlet as, we're going to mark it as 168. I don't know if it was admitted previously. We did discuss it in other witnesses.
Okay, we're moving for the Michigan 168.
Yes.
Any objection?
No.
168 submitted.
All right. I want to go back to make sure, like the Caltech box, there is the same, these two like little plastic loops. What are those?
So those are designed by the manufacturer so that the case is capable of being locked, so you could actually lock your pistol inside that case.
Okay. When this was found, do you know if there was any locking mechanism in it at all?
There were not.
Okay. Were the 3 guns purchased by James Crumbley, including the SIG for his son, did they have to be registered?
So it's my understanding, based on prior investigation as part of the task force and as part of this case, that the handguns were required to be registered in the state of Michigan, yes.
And what's the timing on that?
So if you receive a pistol sales record from a federal firearms licensee in the state of Michigan, you have 10 business days to drop it off, or 10 days to drop it off at like a local county sheriff's office or local police department. In this case, obviously the murder weapon was purchased 4 days before, so there's still some time left to drop that off. Obviously, that never occurred.
Okay. Were any of those handguns registered?
No.
All right. I want to go back to November 30th for a moment, and you said you connected with Lieutenant Marsban, and what was the purpose of doing that?
So the purpose of connecting with him at the time was to help in any way I could. He had started working on a search warrant from the Crumbley family residence, and as part of that, I offered my assistance with whatever was necessary.
Okay. Did you have to watch the surveillance video, or did you watch the surveillance video?
Yes.
Okay. Was there anything notable about it?
Yes, there were 3 things that, and watching the surveillance video from the shooting, that I found relevant.
And what were they?
So the first was the stance that the shooter took for the shot that killed Tate. I noticed that he had some type of firearms training. It appeared to me that he did. I remember remarking to the people in the room at the time that that's what I thought. He had taken what we refer to as a shooter stance. His shoulders were rolled forward, his feet were spread. So that was the first thing that I noticed.
And what did that tell you?
I thought he had some level of proficiency with firearms, whether he had been to a gun range, whether he had training, or just been at least introduced to firearms in the past.
Okay. And then the second thing?
So the second thing was what's called a tactical magazine exchange, or what some other departments call a combat reload. So after the shooter moved through the school, and after reloading his first magazine, his firearm was completely empty, so he loaded a fully loaded magazine into the firearm and continued to shoot. After that, after firing several rounds, he ejected that magazine, placed it in his pocket, and then inserted a full magazine into the firearm so that he was fully loaded in the firearm.
And what's the purpose of that? Why is that significant?
So the way we're trained, at least for law enforcement shootings, is that if you're involved in an incident, you always want to have as much ammunition as possible. So if you have a brief moment where the gunfire is low on the gunfire, if you're in a gunfight, would be to eject your partially loaded magazine, insert a full one, but not to throw it on the ground and keep it for later in case you need it.
Okay. What's the third thing?
So the third thing was when the shooter came out of the bathroom and surrendered to law enforcement. Prior to them coming down the hallway, he took the magazine out of the firearm and he forgot to didn't rack it around out of the chamber, so they were still around in the chamber, I believe. But he took the magazine out and placed it on top of a trash bin, which I found unique. Not something that someone would do if they had just committed a mass shooting.
After viewing that, what did you do next as a result of noting those 3 things?
So my responsibility at the time was to help Lieutenant Marsman create a timeline for the affidavit. After noting those things, the following day, the day after the shooting, I began to start an investigation, thinking that the shooter had been to a gun range, contacted a gun range in the area, and confirmed he had in fact been to the range.
How did you know how did you pick that gun range?
It's probably the most popular gun range in the area and for driving distance from the Crumbley residence.
All right, and as a result of your investigation leading to looking at gun range visits, what was uncovered?
So at the gun range, we were able to, it was gun range in Clarkston, able to locate surveillance video for 2 instances, as well as receipts for visits. I believe there was numerous visits. I believe it was around 8 total visits.
And were there any other tools in the investigation you used to determine visits to gun range and who was there and at what time?
Yes, so in addition to the actual records and surveillance video, forensic review of the extractions of Mr. Crumbley's cell phone, as well as his son's and Mrs. Crumbley's, put together more visits to the ranges as well as videos of those instances.
All right. I'm going to show, just one moment here. Let's start with June 15th of 2021. Do you know why that date's significant?
Yes, that was the date Mr. Crumbley initiated the purchase for the Derringer.
Okay, and the slides in People's 169. What are we looking at?
This is a Facebook conversation between James and Jennifer Crumbley on the 15th of June, 2021.
Okay, now time, it says UTC -4, 11:34 a.m. Is that the actual time?
Yes.
Okay, and can you read the text in blue? What does blue indicate? Which person?
Blue is Jennifer Crumbley. Green is going to be James Crumbley.
Okay, and can you read those texts?
Yes. So
Messages.
Jennifer Crumbley asks, talk at 12, and then Mr. Crumbley responds, taking Ethan to store at 12, and then Mrs. Crumbley asks if you get gun.
Okay, and then the next? He's answering her?
Yes.
Okay.
Mr. Crumbley responds, yes, and Mo, I believe that's supposed to be no. Jennifer responds, huh? And then James says, we paid for the gun and bought it, but can't pick it up till everything clears Washington, in parentheses, FBI. Could be today, tomorrow, or next day, they don't know. And then Mrs. Crumbley responds, gotcha, bring me those fruit punch things when you come to bring hay.
All right, the message about he had to wait, did you, through your investigation, did it reveal that that's consistent with what happened?
Yes.
Okay, and remind the jury why.
So sometimes when you purchase a firearm, the background may take a little bit of time, depending on a lot of different factors. And in this case, it took enough time to where Mr. Crumbley had to come back the next day to pick up the firearm.
Okay, and then the next exhibit, People's 170. Do you know what that is?
Yes, this again is Facebook messages between James and Jennifer Crumbley. Blue is Jennifer, and she says, how much is your gun? And Mr. Crumbley replies, $300.
All right. I'm going to show you what's been marked as, and admitted as People's 29. This is a receipt for, what is it for? Do you know?
This is the receipt for the Cobra, for the Derringer. This is dated 6/15. It says 6/16 at the top, which is the date the actual sale went through, and it's for $180.15.
So this is not $300. Was there a gun he purchased that was $300 that day?
Approximately, yes.
And what gun was that?
That would have been the Kel-Tec P17 22 caliber pistol.
Okay, so the Derringer, the small one, was $169, and this is the receipt for the Kel-Tec. What else is on that receipt?
It's 2 boxes of ammunition at $14.95.
Okay, seems good. I'm going to draw your attention to June 26th, which is about 10 days later. Do you know if James Crumbley went to the gun range on that date?
Yes.
What? Oh, sorry. 1 minute. I'm sorry, I skipped a page. Sorry about that. June 20th.
Yes, that's correct.
And the People's 171 is on the screen. Can you tell the jury what that was? What that is?
Yes, this is again Facebook messages between James and Jennifer Crumbley. In blue, Jennifer asks, "Can you guys answer your phone?" And then James Crumbley responds, "No, at gun range, loud."
All right. And People's Did you find any videos through your investigation of the range on that day?
Yes.
And where'd you find it?
On James Crumbley's cell phone.
All right, and you're looking at 172 and 173. We're going to play those for the jury, but before we do, can you tell them what they're going to see?
Yes, so the first video is at 12:58 p.m. on June 20th, and it's a video of the shooter's son shooting the Caltech pistol at the gun range. And then the following video is a video of the defendant's son shooting the Derringer at an outdoor gun range a couple minutes later.
Okay.
Same range, both?
Yes.
Go ahead.
All right. What, if anything, do you see or notice in that video?
In the second one?
Yes.
It appeared he almost shot his hand on during the video.
And why is that?
He had his hand in front of the muzzle of the firearm.
Okay, when you say he, who do you mean?
I'm sorry, the defendant, Mr. Crumbley's son.
Okay, the shooter.
Yes.
All right. Did you know, did James send those videos to anybody that day?
I don't recall if he sent them that day or the next day, but he did send them to Mrs. Crumbley at some point.
All right, and how do you know that?
I reviewed her cell phone as well.
Okay, and Exhibit 174, can you tell the jury what that is?
Yes, so that is one of the videos being sent on June 21st, 2021.
All right, and this is 2 slides or it's 2 slides. Can you do this one? And then, is this the second video?
Yeah, this is in the reverse order. So the first, they're both videos were sent from James Crumbley to Jennifer Crumbley on June 21st, 2021.
Okay, so these exhibits are him sending her the videos?
Yes.
All right, did you learn what she did with the videos, if anything?
Yeah, she took one of the videos and uploaded it, I believe, as an Instagram story.
Okay, and that's Exhibit 175. Can you read what the post says in addition to the video?
Sure. It says Ethan, and it tags, I believe that's Mr. Crumbley's Instagram account. Both got handguns this week, testing them out at the range.
All right. And then now we're to drawing your attention to June 26th. Did they go to the gun range that day?
Yes.
Do you know where it was?
It was at so for the rest of these, I believe it's the indoor gun range in Clarkston, Michigan.
Okay, and Exhibit 176, can you tell the jury what that is?
This is a receipt in the name of James Robert Crumbley on June 26, 2021 for one range, handgun range fee of $20, and then one small silhouette target at 75 cents.
Do you know if the videos were taken on that day?
Yes.
Do you know if they were sent to anyone?
I do.
And who were they sent to?
Jennifer Crumbley.
Okay. Drawing your attention to Exhibit 177. What is that, if you know?
This is a video sent from James Crumbley to Jennifer Crumbley of the shooter at the firearms range in Clarkston on June 26th. And is
178, which is admitted, I believe. Is this the video that was taken and sent to Jennifer?
Yes, this is actually, I believe, is the Instagram story that was created from that video and uploaded to Instagram by Jennifer Crumbley.
Can you tell from the video which firearm he's using?
Yes, that's the Kel-Tec P17 22 caliber pistol.
Okay. Drawing your attention to July 2nd, did you uncover any evidence that James and his mother-in-law, Jennifer's mother, went to the range with the shooter?
Yes.
And how did you discover that?
So there were messages between James Crumbley and his mother-in-law on Facebook discussing a range visit. I think the conversation occurs on July 2nd, 2021, but it's actually for a range visit occurring on, I believe, July 3rd, 2021.
Okay, can you read that to the jury?
Sure. So in blue is going to be James Crumbley's mother-in-law. She says, still planning on taking the shooter to the gun range tomorrow morning. Then lunch. Is he still available, and do we need to make reservations? Mr. Crumbley responds, he is good, no reservations needed, I'll go with you guys. His mother-in-law replies, awesome, glad you could join us. We don't know what we are doing, LOL.
And then, this is 377.
377. And then the next response from James?
Just take Mabee Road up to Dixie, turn left, and it will be on the right-hand side. The shooter will be excited. We will rent a few different guns. They have a special for 9mm on 25 for a box of 50. His mother-in-law replies, sounds great. Mr. Crumbley says, make it closer to 10:45.
All right, and do we have any video from that day?
We do not.
Do we know who was there? Well, first, it's 179 and 180. What are those?
Those are receipts from July 25th. Those are not from that visit.
Okay, so now we're to July 25th.
Yes.
And what do those receipts show?
So on the left-hand side of the screen is looks like a purchase of ammunition for 6 boxes of 22 caliber ammunition for a total of $47.90 or $50.82 at the bottom. And then on the right, it's a range visit by Mr. Crumbley. It's a handgun range fee of $20, a small silhouette. I should mention that the receipt on the left also is in the name James Crumbley.
What's a silhouette mean?
It's a silhouette of a person that's used at a gun range.
Okay, and Exhibit 181, can you tell the jury what that is?
Yes, so this is geolocation information for the Gmail account for James Crumbley, and for, I believe he is in green on this, and then the purple dots would be Jennifer Crumbley meeting on July 25th, 2021. Both Jennifer and James Crumbley were at the Firearms range in Clarkston, Michigan.
Okay. Drawing your attention to August 15th, Exhibit 183. This is a receipt. What is it for?
This is dated August 15th, 2021. The receipt has a range fee of $20 again. I believe that's so it'll be 200 rounds of 22 caliber ammunition and 1 small silhouette, again, a silhouette of a person target.
And 184, what is this?
This is James Crumbley's Gmail geolocation information showing he was at the Clarkston gun range at that time.
Okay. And you were here for Ed Wagrowski's testimony, correct?
Yes.
All right. Did you see the video that the shooter sent to his friend in August of 2021?
I did.
All right. I'm going to put 70 and 71 up on the screen. That's one slide. First, what are we looking at?
So this is the first video filmed by the defendant's son on August 19th around 9:30 p.m. that was sent to his friend.
All right. And what time was it?
It was 9:31 p.m.
Okay. And can you see that video? Can you stop it right here? Okay, I'm stopping. Mr. Peace is stopping it. What are we looking at?
So this is the defendant's son holding the Kel-Tec P17 pistol. Doesn't appear to have a magazine inserted. Didn't appear to have a round in the chamber. The safety was, again, red means dead. The safety was not engaged.
Okay. And can you continue? All right. Can you tell, based on, I should probably lay a better foundation, were you ever inside the Crumbley home?
Yes.
When were you there?
On the night of November 30th of 2021, the night of the shooting, we executed the search warrant there.
Okay, so you were there during the search?
Yes.
Okay. Do you recognize anything in that video that signifies where the shooter was?
I do, but not from being in the residence. It was from other cell phone extractions from, I believe, Mrs. Crumbley and Mr. Crumbley's phones. I believe they changed couches in that living room at some point. It was a black leather couch that I recognized being in the living room.
Okay. All right. Exhibit 72 and 73. They've both been previously admitted. Can you tell the jury what this is?
This is the video that I believe Detective Bobrowski had testified to previously. It was sent to the defendant's son's friend by the defendant's son on August 20th at 12:30 in the morning.
All right. And was there a text that accompanied this right after or before the video was sent?
Yes, it was around the time that the video was sent. I believe it said, my dad left it out, so I thought, why not? LOL. I'm paraphrasing. I don't know if that's the exact text, but that's the general idea.
Can we have the text? The next slide. Next slide. Is that the text?
Yes, that's it.
Okay. And we're going to play the video, which has been previously admitted. And before we do, can you tell the jury what they're about to see?
Sure. So the defendant's son has the Keltec P17 pistol in his hand. Again, the safety's not engaged. He slams the firearm down on top of the magazine, loads the magazine, and then sends the slide forward, chambering around into the firearm, meaning that if he pulled the trigger at that moment, it would go off.
Okay. All right. What do you see in that picture besides the Caltech?
Appears to be a cat.
And based on your investigation, do you know about that cat?
I believe that's the shooter's cat, Dexter.
All right. And what surface is that? Can you tell?
Yes. So after being in the home for the search warrant, I'm aware that is their kitchen. Really didn't have a kitchen area. It was more their living room or dining room table, so to speak. It was a higher kind of four-top table. That is the same wood grain that's on the table in their dining room.
All right. And we know this was taken at 12:30 a.m. Is that what you said?
I believe it was sent at 12:30, but I think it was taken relatively close to that time.
Okay. Do you hear anything else in the background?
All I heard was crickets and then the sound of the magazine and then the slide going forward.
Okay, and we've previously introduced the GPS data that shows whether or not James Crumbley was in the home during this time. Was he?
He was.
Okay. Okay. Can you just look? All right. I just want to talk to me about this video, Special Agent Brandon, and what your view is on whether or not what was happening in that video was safe.
So I would say that regardless if Mr. Crumbley was standing over his shoulder or not, that would not be safe. The firearm is on top of a dining room table. It's loaded, the safety's off, and it's pointed in a direction that if you're inside their home, you can't tell from the video whether he's facing the front of the home or the side of the home. But regardless, the firearm's pointed in a direction that would be almost chest level if a person was beyond the walls of the house or if a person was standing nearby. Not to mention almost, pointing the firearm at the cat.
All right. That's the magazine. Can you tell if it's loaded or not?
Yes, that magazine there, you can see the rounds of ammunition in the firearm.
All right. And you said, could you see whether there was a round in the chamber?
I don't believe there was until he loaded the magazine and then sent the slide forward, or else it would have malfunctioned.
Okay, where's he loading? That's loading the magazine. Is that's the safety?
Yeah, so the safety's not engaged, and the round is at the top of the magazine is visible there, and if once he sends that slide forward, that's what takes that round and puts it into the chamber.
Okay. What if that was being supervised by somebody like James? Would it change your opinion of the safety of that action?
No, so based on what we spoke about before being the 4 rules of firearm safety, so obviously that firearm is loaded, so treat every firearm like it's loaded. Point it in a safe direction, so there's really no safe direction for that firearm to be if it's chest level on a table. The only safe position would be whether it's outside or pointed at the floor. Obviously if you're loading a firearm to carry on your person, you point it at the floor where it's away from people so it can't hurt anyone at the discharge.
Okay. I want to draw your attention to September 1st. Did the defendant, did James take his son to the shooting range on that day?
Your Honor, I'm just going to ask for clarification. September 1st of what year?
2021. The weapons weren't purchased until June 2021 and November 2021.
Yes, I believe that's correct, yes.
All right, and Exhibit 185, what is that?
It says, it's a Facebook message from James Crumbley to Jennifer Crumbley, and it says, the shooter and I are headed to the gun range.
And Exhibit 186 and 187?
Those are receipts from the gun range in Clarkston, both in James Crumbley's name. The one on the left is for range time. It's like 200 rounds of .22 caliber ammunition, 2 silhouette targets, and then a rental of a .22 caliber revolver. And then on the right-hand side is one 50-round box of .22 caliber ammunition.
Did James take a video of his son that day?
Yes.
And how do you know?
It was located on James Crumbley's phone.
And that's Exhibit 188?
Yes.
All right, we're going to play that. All right. On September 25th of 2021, did you come to learn that James took his son to the range on that day?
Yes.
And this is Exhibit 189. What's that receipt for?
So it's a receipt again, and the name's James Robert Crumbley. It's got a range fee, a rental of a 9mm pistol, 9mm ammunition, .22 caliber ammunition, as well as a black torso target.
All right. And this, do you know if that was a SIG?
That was not. It was a 9mm HK VP9.
Okay. Is there a video of that day?
Yes. So the actual gun range surveillance video. This was the furthest back for the range visits that we could get due to the footage writing over itself. So September 25th was the first date that we actually could get footage from the gun range in Clarkston.
All right, and this is 190. We're going to play that. And what are we looking at here?
So this is at the gun range in Clarkston. This is outside of the shooting area. This is where you pay for targets, ammunition, rent firearms. In the white sweatshirt is Mr. Crumbley wearing the Seattle Seahawks ball cap. And then you have the shooter wearing a gray sweatshirt, dark coated pants, Nike shoes, and a black hat.
And what do you observe James Crumbley wearing at his belt level?
Appears to be a holster.
And can you tell the jury what you're observing?
So at some point, it looks like the shooter was trying to clear a malfunction from the firearm. He's checking the chamber to see if a round's chambered. He's having some kind of malfunction with it, and he is having trouble clearing it.
And can you tell what firearm that is?
The footage here is real grainy. I can't say for certain.
And what does he appear to be doing right at this time?
So he keeps checking the chamber for a round. He's having issues with it. He goes over to Mr. Crumbley. They walk back over. Mr. Crumbley picks up the firearm. He racks the slide 3 times to try to see what's going on with the firearm, and then he inserts the magazine here and gets the firearm back in operating condition.
All right. What is the relative price difference between the 9mm ammunition and 22 ammunition?
So just generally speaking, the 9mm ammunition is more expensive than 22 caliber ammunition. 22 caliber ammunition is more for target practice, and 9mm ammunition we use for anything from target practice to home defense. It's generally more expensive for 9mm ammunition.
And when you say more expensive, can you roughly say about how much generally?
Objection to relevance, Your Honor.
Yeah, what's the relevance?
The relevance is that 9mm ammunition is expensive, and it's typically not something that you would buy just to shoot at the range, particularly if this is your hobby. It's expensive.
That calls for speculation, Your Honor.
Well, unless he knows. Unless he knows.
Is 9mm ammunition, because of the cost, is it something that you typically see at a range?
People do shoot 9mm ammunition at the range. Now, what level of money they're willing to pay for that type of ammunition all varies depending on if you're going to shoot at the range. Obviously, you're going to try to use less expensive ammunition, but I'd be speculating anything beyond that.
Okay, thank you. Drawing your attention to October 3rd, was there evidence uncovered that James and his son went to the range on that day?
Yes.
And Exhibit 191, that's a Facebook message?
Yes, this is from James Crumbley to Jennifer Crumbley on October 3rd at 12:01 p.m. It says, "Cool, just got cleaning our guns, leaving for range in a few."
All right, and then 192 is a receipt. Is it from that day?
Yes, it's from October 3rd, 2021, in the name James Robert Crumbley. It's for a silhouette target, a range fee. I believe that's 100 rounds of 22 caliber ammunition, and then an additional, looks like an additional 2 boxes of 22 caliber ammunition.
All right. Drawing your attention now to November 26th of 2021, you testified earlier that you were involved in the tracing of the weapon and the purchase of it on that day, correct?
Yes.
All right. And was that 9mm SIG purchased on that day?
Yes.
I'm showing you previously admitted 37 and 38. We talked about this. What are these?
This is the receipt from the gun store in Oxford for the Sig Sauer SP 2022 9mm pistol that was sold to James Crumbley.
All right, and the cost?
The gun itself was $489.95 with tax. It was a total of $519.35.
All right, and 38 is what?
This is the pistol sales record that would have been completed by the gun store and signed by Mr. Crumbley, documenting his purchase of the Sig Sauer pistol.
And were you able to, or did you review any posts that the shooter made with this firearm purchased for him?
Yes.
All right, and I want to draw your attention to Exhibit 95, and there are 3 slides here. What's the first one?
So the first one, so the text for the post was November 26th. Said, "Just got my new beauty today, Sig Sauer 9mm. Ask any questions, I will answer." It's a picture in the Crumbley's kitchen. It's hard to see from this photograph, but there's a yellow. You see yellow and then some wood floor underneath it. That's the counters in their kitchen.
So I'm holding the box, so this would be showing through this handle with the circle?
Correct.
Okay.
Yes, and that is the 6-hour SP 2022 purchased by James Crumbley.
All right, and then the second slide?
This is a picture of the defendant's son holding the 6-hour SP 2022 in the Crumbley family residence. That's the same floor inside their house.
And it's a post?
Yes.
All right, and it says?
It's the same. So the same text appears in all three photographs, but there's the second. There's the first photograph of just the firearm. The second of Mr. Crumbley's son holding the firearm, and then the third picture, I believe, is the Mr. Crumbley's son lining up the sights. So on a firearm, there's the rear sights and the front sights, and when you line those up, that's what you're shooting at. That's what you use to aim, and that's where those three dots are aligned. That's Mr. Crumbley's son pointing the firearm at the floor inside their residence.
All right. Drawing your attention to 97, Exhibit 97. This is, where was this photo found?
This was found on Jennifer Crumbley's cell phone. It depicts the top firearm where you see the red dot again is the Caltech SP, the P17. And then the bottom firearm is the murder weapon, is the 6-hour SP 2022. This is all inside of the 6-hour box. You see the two SIG magazines on the right side of the screen, plus the ATF pamphlet and the cable lock provided by 6-hour.
Okay. Anything stand out to you about this picture?
As far as?
The ATF pamphlet?
Well, the pamphlet obviously is on top of the foam in this picture, and the cable lock is still in the box with the SIG Sauer. Obviously, it was later recovered in the Caltech box, not in the box with the 6-hour.
All right, and in addition to the ATF pamphlet, is there anything else posted at the gun store about safety?
Yes, so behind the counter in the gun store in Oxford is the same 4 bullet points that are in the inside left cover of that ATF Youth Handgun Safety Act. It hangs behind the counter.
All right.
That's 193.
Yes, it's 193. All right. I don't know. This is going to. Okay. All right. This is Exhibit 42. What is this?
That is the cable lock that was provided with the 6-hour pistol.
All right, and is this cable lock is specifically provided with the SIG, with this actual gun?
That's correct, yes.
Okay, and looking at this, I'm going to hand it to you now.
I can get another pair of gloves. It's getting a little hot up here.
I know, I took mine off too.
Is it getting hot in here?
Yes.
Yeah.
It's climbing.
Yeah.
It happens all the time.
I don't know if those are the small ones.
That's all right.
We're working on it.
Definitely smaller ones this time.
Sorry.
Sorry.
I do have bigger ones, but
That's all right.
you got them on. Okay. I'm going to ask you I'm going to hand this to you, and then I'm going to ask you to tell the jury whether or not you think this has ever been opened.
So I would say, is it possible that this top part had been opened? Yes. If this was used consistently and pulled out of this packaging, there'd be more tearing on the side, just cheap plastic packaging.
All right, and what's inside of it at the bottom?
So there's the instruction manual in here, as well as the 2 keys that are still inserted in the cable lock.
Okay, and your testimony is this is provided with, I'm going to take this back. This was provided with the SIG when it was purchased on November 26th, correct?
Yes.
And where was this found in the home when you searched it on November 30th, 2021?
That was in the Caltech box in the kitchen.
All right, so it was found not in the SIG box.
No.
So the Caltech box, which is somewhere here.
Underneath the SIG box.
Okay. So the SIG cable lock was found with the Caltech. Where was the Caltech?
The Caltech box is in the kitchen.
Okay, but the Caltech, the weapon, was in the gun safe?
That's correct, yeah. The Caltech pistol was in the gun safe in the Crumbley's bedroom.
Okay, so this was found open or closed?
That was closed.
All right, and did you testify earlier this was found in a cabinet in the kitchen?
I believe it was a cabinet or like a little space in the kitchen underneath an island or whatever.
Okay, and if we go back to the picture that Jennifer Crumbley posted, same cable lock?
Yes.
Okay. On November 27th, drawing your attention to Exhibit 195, what is that?
That is a receipt from the range in the name Jennifer Lynn Crumbley for November 27, 2021. It's for pistol range visit, one target, and 2 boxes of Patriot Defense 9mm 124 grain ammunition at $23 or almost $24 a box.
Okay, so 4 days earlier when the gun was purchased, is there a video of that?
Yes.
The purchase of the gun? On the 20th?
Is there a video of the purchase of the gun? No, the gun store did not have footage for that day.
Okay, so but this is the 27th, the next day. Is that a Saturday?
I believe so, yes.
Okay, and is there a video from that?
Yes, there was footage at the gun range in Clarkson. There was not footage at the gun store in Austin.
Okay, and do you've heard all the testimony before? Were you able to determine where James Crumbley was on this day, on a Saturday when Jennifer and the shooter went to the range?
Yes, he was working that day doing DoorDash deliveries for most of the day.
Okay. All right. It's Exhibit 196. I'm going to play this and the first part of it and stop for a moment at the counter and then move to, I think, just a section at the end because it's long. So
sure.
Just wanted to let everyone know. Okay, so what are we looking at right now?
So the woman holding the pistol case, that's the 6 Hour pistol case, that's Jennifer Crumbley. Behind her is the shooter wearing that gray sweatshirt and sweatpants and black shoes.
Now, she's paying for what, if you know?
So right now, I think she just handed him her license.
Okay.
Based on the receipts for this visit, like I said, there was the target, 2 boxes of 9mm ammunition, and then the range visit itself.
All right. Okay, I'm going to stop it there. What is he doing?
He made a 2 with his hand.
All right, and how many boxes of ammo did they actually purchase?
2.
Your Honor, I'm going to object. It sounds like the prosecution is asking Agent Brandon to speculate as to what the number 2 could be. There are also 2 people there. There could be 2 sets of ear protection. It could be 2 targets. It could be 2 of anything. She's asking for speculation.
That goes to weight, not admissibility.
Yeah, I think it does.
Okay.
You don't know what he was referring to. There's no sound.
I don't. If you play the video and it continues, we'll see what happens next.
Okay.
Okay. And if you know what is happening now?
It's picking up targets and 2 boxes of ammunition. He's bringing the 2 boxes of ammunition up now.
And how much were the 2 boxes of ammunition for 9mm? A 9mm.
I don't recall. It would be on the previous slide for the receipt, but I think it was around $24.
$24 total or $24 for each box?
I believe it was $24 for each box.
Okay. All right, we're going to now go to what happens after they leave here.
So they pay for their range visit. They get their firearm or the ammunition and the targets, they then proceed to go put ear protection on and walk into the range and begin to load magazines and then take turns firing the weapon.
All right, and we're going to go to the segment where they're actually firing the weapon. Okay, what's happening here?
So in the back, the shooter is loading ammunition into the magazines. At one point during the video, Mrs. Crumbley does help load at least a couple rounds of ammunition as well into the magazines, and then they proceed to take turns shooting the firearm.
All right, and that's, we're going to speed to a part. Is there some point where he's, you're observing him instructing or trying to help his mother?
Yes.
All right. Okay, what are we seeing here?
So this is one of the times that the shooter shot the murder weapon. He sends the target down range, loads the magazine into the firearm, and then discharges it several times.
Now, as far as you know, in terms of looking at all the evidence, is that the first time he's fired that weapon, if you know?
Yes, based on all the evidence I was able to locate, this is the first time, yes.
Okay, we're going to jump ahead to, if you know, does Jennifer Crumbley ever fire the weapon?
Yes, she takes, I think, 2 total turns firing the weapon, I believe.
Okay. And what are you observing right now?
So in the video, the shooter's instructing his mother how to load a magazine and chamber around. Right now he's pointing to the slide release, telling her how to send the slide forward and chamber around from that magazine in the firearm.
How many rounds, if you know, did they fire that day?
I believe it was a total of 50. There was 2 boxes of 50 rounds of ammunition, and they left the range with 1 full box of 50 rounds.
Do you know how many she fired versus the shooter?
I don't know the exact number. I know that it was significantly more for the shooter than his mother.
Okay, do you know, how do you know that they left with 1 full box?
So at the end of the video, the shooter packages up the 6-hour in the 6-hour pistol case, and then hands the box. His mom takes the box, Mrs. Crumbley takes the box as they leave, and the shooter walks out carrying the box of ammunition.
Okay, and we're going to fast forward to that part. Do you see any, can you, in watching this video, is it visible, the actual case?
Yes.
And do you see a lock or the ATF pamphlet?
No, not during this video, no.
Okay. And is that the SIG case?
It is.
Now, is he permitted to carry that gun out of the range?
So there would be nothing barring him with his mother's supervision right there for carrying the firearm. No.
Okay. And what about the ammo?
Same with the ammo.
Okay. And we see later, he's packaging it up?
Yes.
Okay. And we see later them leaving, and who's carrying what?
So right now he's trying to figure out how to fit all the magazines and the firearm in the pistol case. He eventually is successful in doing so, closes the clamps on the firearm case. His mother walks out with it, and he walks out with the ammunition.
Okay. And if you know, how many rounds did he take to the school that day?
I believe there was a total of 50 based on the number of rounds discharged being 32 and the rounds recovered.
We talked about the cable lock that was sold with the SIG. If it had been installed in that firearm, about how long does that take to install a cable lock?
I mean, if the slide's already to the rear of the firearm and the magazine port and the ejection port are visible, it would take under 10 seconds.
Okay. I want to, lastly, draw your attention to Exhibit 130. What's that?
So this is an Instagram post by the defendant's son.
It's 100, sorry.
Oh, yeah. By the defendant's son, after returning from the shooting range, took my new SIG out to the range today. Definitely need to get used to the new sights, LOL, and then there's a picture of his target.
All right. And this is a post that Jennifer Crumbley posted that day?
Yes, that same day, Mom and Son Day, testing out his new Xmas present. My first time shooting a 9mm, and I hit the bullseye.
And this is just a different picture with the same post?
Yes, I believe she had 3 photographs with her post, including the 6 hour on the kitchen counter with the ATF pamphlet underneath.
And do you see a cable lock?
I do not.
Okay. Moving to Exhibit 130. This is the math worksheet.
Yes.
Did you have an opportunity during your investigation to look at this?
Yes.
And what caught your attention, if anything, with this drawing?
The very first thing I noticed was that there was an apparent shooting victim on the drawing. Whether it was a fatal shooting, not fatal shooting, I'm not certain, but clearly when I looked at it, it's not a suicide.
Anything else?
Yes, so the firearm that was drawn on the piece of paper, after reviewing the murder weapon, I noted several similarities between the two and believed that this was actually a drawing of the murder weapon.
And what was similar?
So on the back of the murder weapon, there are striations or lines on the slide of the firearm. Additionally, the shape of the trigger guard, so it's the part where the trigger is housed in. It's that kind of let's say that it's like a half U shape where the trigger is inside of, as well as where the ejection port is, and most notably the magazine. So the bottom of that firearm, you see how it's not flush, how there's basically 2 parts there? That part on the Sig Sauer magazines, there's like a lip that's different than other firearms that shows how it kind of like curves down in the front.
All right, next I'm going to, what about is there a picture of any ammo on that drawing?
Yes, there's a picture of ammunition. It's definitely a pistol caliber ammunition. It's definitely not 22 caliber ammunition. It does appear to be a 9mm round of ammunition, or at least resemble one.
Okay, and next I'm showing you exhibits previously admitted, 97, 101, and 130. What are we looking at?
So those are pictures of the murder weapon on either side. You can see the markings I was talking about, the striations on the back of the slide of the firearm, the shape of the magazine, especially when you look on the picture on the right. You see how it's not a flat shape, it doesn't sit flush with the firearm, how there's different levels there. Additionally, the location of the ejection port and the shape of that trigger guard, again, that half kind of U shape there.
And Special Agent Brandon, my last question is, what was your impression when you viewed that drawing?
My impression when I viewed the drawing?
Yes.
That he drew his firearm.
And the entire drawing, what was your conclusion, or what were your impressions through your investigation? What was the drawing up?
He drew a murder.
Thank you. Nothing further. Can we take a break at this time, Ryan? I think the jury's probably...
Sure you need a break, right, Ms. Wayne? Would you
Yes,
like a
sir.
break?
Yes, please, Your Honor. Thank you.
Okay, I have asked about the heat, but this is an old building, and this happens all the time. An hour from now, we'll all be freezing, so. And then let's take a 10 or 15 minute break. You can step down. Please don't discuss your testimony with anyone, all right? Thank you.
All rise for the jury.
All right, court is going for a short 10-minute break. They've been in session for a little under 2 hours now with this one witness. So let's bring back our attorneys, Arnold Reed and Rick Convertino, back into the conversation. So just, Arnold, bring us through what we just saw.
Well, originally he was testifying to some things we had talked about behind the scenes, so to speak, that elicited expert testimony. He's not an expert. I believe the prosecution later in the testimony began to establish its relevance, showing the jury, for example, the box, where it was located, where it was recovered, the lock that was unused. The prosecution is laying the foundation to show the jury that this was a family, a mother and a father, but in this case a father, who didn't take the proper precautions in terms of securing a weapon like it should have been secured. And she artfully used the term weapon a few times, if you recall, and the defense objected to that. But I think what this testimony has established, or at least is attempting to establish, is the irresponsibility of the defendant, James Crumbley.
Do you think it's effective?
Well, I think it's effective to show, right up to this point, without any cross-examination, you have a picture of a father and mother, but in particular the father, who is the one who purchased the handgun, yet the lock for the handgun wasn't even in the case with the Sig Sauer. It was in the case with the Cal-Tech. So a different case, a different area. It was under the foam, so it was ostensibly wasn't used at all since it was purchased. I think we're going to, you may recall that earlier on we were told, excuse me, by the prosecution to be two new witnesses. One a student, and one is the former owner of this particular weapon, the Sig Sauer, and that person is going to say that when he purchased the gun and resold the gun to the same gun shop that he purchased it from, which was later purchased by James Crumbley, that he had the cable lock secured in the same way that it was found later in the Crumbley's home, in other words, unused. The prosecutor McDonald said to the witness, the parents have a legal duty to secure the handgun, and he had agreed. So that was unobjected to, and that was critical testimony. The parents have a legal duty. In other words, that's an element in this case. Parents have a legal duty to secure the handgun in a safe manner, and that was not done. So that is, again, critical to establish a legal element in the charge of involuntary manslaughter.
Just to kind of piggyback off of that point as well, and we saw earlier, and we talked about it quite a bit, there were a number of things that this officer in charge testified to that should have drawn objections but didn't. He's not a ballistics expert, yet he got to tell us about the ins and outs of the weight of the gun, how many bullets it took, how big the bullets were, etc. There were a number of things, again, that should have been objected to. Well, let's talk about imagery for a minute here. I think it's important for the viewers to understand this. Do you notice when the evidence was in the possession of the prosecution, she wore the gloves? She put the gloves on and was touching it very gingerly and putting it down, saying, I'm going to put it here safely. That's to create an image in the juror's mind that, woo, we have a weapon here and you have to put the gloves on. The fact of the matter is, the fingerprints have already been lifted. Everything we need to know about that gun, we know. There's no need to wear gloves, but it's just the drama. It's the suspense in the courtroom of putting the gloves on, taking them out the box. So we see some intangible things going on here that are all designed to set the stage and create an image in the juror's mind and draw their attention to this weapon. And I think the prosecution is pretty effective in doing that with this witness.
In drawing on that concept of imagery, the testimony of the Special Agent Brandon, was that he was asked, what stood out to you when you watched the videotape of the shooting itself? And he said, there were three main things that stood out to me. The shooter's stance. He said it was impressed by the actual shooting stance of the shooter, and that indicated to him that he had prior experience at either a gun range or somewhere else in his backyard, but there was some level of proficiency. Secondarily, he said that there was a combat reload. That was his term, a combat reload, which is the discharge of a magazine before the clip is empty, but not leaving the magazine with rounds in it on the ground, putting them in your pocket in case you have to use the remaining rounds at a later time. He also said that the last thing was that he surrendered tactically. So he was summarily impressed with the way that the shooter in this case, at the time he surrendered, emptied the clip from the weapon, put the clip down and the weapon down separately, and then surrendered to law enforcement in a way as to not risk any danger to his own safety.
You see, the import of that is powerful. We haven't had any testimony that Ethan is particularly trained in any of this. We don't have any testimony from any expert witness that suggests that what this guy is saying is true. But he got to testify to that about putting the gun down and make it seem as if he was some kind of combat expert here. We don't have any testimony. So the defense, again, should have been up on her feet, pounding the pavement, saying, wait a minute, stop. This imagery that you are creating in front of the jury makes it seem like he was purposeful, and he was purposeful. So I think at this particular point, the defense must step it up to kind of slow the advantage I think the prosecution further has in this case.
And the intimation is particularly with the combat reload, which is a very specific, anyone with military experience would recognize that term and phraseology, and the importance of the ability to combat reload a multi-clipped weapon. And the importance of that testimony was the intimation that, in fact, the father, James Crumbley, the defendant in this case, trained specifically his son in that combat reload when they were at the multiple times they were at the range, which, whether or not that's true, that's in evidence now.
You can't unring a bell.
Can't unring that bell.
We will continue the conversation. We're going to take a short break. We'll be right back.
What was your reaction to that?
To finding the pamphlet?
Yes.
So when I lifted up the phone and saw the pamphlet in there, I was shocked.
Okay, why?
Yeah, as the pamphlet says on the front, it says Youth Handgun Safety Act Notice. Means they were on notice. They had to pick this up and move it to the back of that gun case and basically discard it underneath the phone. The purpose of the pamphlet is to inform the buyer of the firearm that juvenile gun violence is a major problem and that safely securing your firearm will prevent that from happening.
All right, Officer in Charge Brett Brandon there speaking during his testimony. Rick, what did you make of those points that he made?
Well, I thought it was silly. I thought it was overreaching. I mean, whether or not a pamphlet is in the front or back of a gun case is inconsequential. And, you know, I just think that emphasizing things like that in a case like this can be detrimental to the credibility of the overall case. You know, what did you think of that? My reaction would be, you know, who cares what this BATF agent thinks about that personally? It's not an element of the case. It doesn't go to show, I don't think, impute any knowledge. They don't know if they sat this kid down and went through that pamphlet, you know, in a manner over the kitchen table. I just think it's overreaching, and I don't think it's necessary.
Mm-hmm. And you have to also think of how that impacts jurors as well, right?
It's
how
no
will they
question.
read into this?
Well, first of all, it's hearsay. He can't testify to a document like that. He didn't create the document. And for him to be attesting to what that document says, like Rick said, it's beyond ridiculous. It's way over the top. The prosecution's got a strong case. They don't have to do this. They really don't have to do this. And this is a bit much at this point for them to be using this OIC, this officer in charge, as an expert witness, because it may play into to their benefit to one or two of those jurors on there. We don't know. Maybe one or two of the jurors are going to go back in the jury room saying, well, yeah, I read all my instructions. I read this and I read that. Mm-hmm. But there's no way to equate knowledge in terms of willfulness or gross negligence, reasonableness, unreasonableness. When we're talking about a pamphlet?
Yeah, reading the pamphlet to me it's akin when you download an app, you know, to read the terms and conditions before you're able to download the app. You just want to download the app, you hit yes and go. You don't read 3 pages of terms and conditions. And so to impute knowledge or awareness regarding a pamphlet about minors in possession of a handgun or use of safety issues regarding minors, I think is overreaching. In the same way, I love you, I love you, I love you, exactly, is overreaching to impute that he was trying to tell his son to stop talking.
This is a great opportunity, Rick, Meredith, Terrence, I think, for the defense to come back and pounce on that they want you to believe so bad that this man knew what his son was going to do, and he was so grossly negligent that we are reducing their prosecution to knowledge of reading a pamphlet. And so I think this is an opportunity for the defense to get out in front of it, perhaps sometime down the road, and diffuse some of that with the jury. It's just too much, and the prosecution, again, there was no reason for that.
So just bring it back to the point of what we're even arguing here.
Right. I mean, what are we going to be talking about next? Pamphlets, with one witness, handkerchiefs with another one, I love you with another one. It's like, come on now, you're doing too much.
Does it seem like we're kind of losing focus of just the fact that the negligence was there, just in terms of being a bad parent, as some have argued?
Not at all. The prosecution hasn't lost focus. This is all purposeful, with knowledge that one or two of those jurors or more, this stuff may resonate with. You've got an officer in charge on the witness stand. Lay persons believe police officers. What police officers say is hard to overcome in terms of trying to, impeach their credibility. So they know exactly what they're doing. This is purposeful. This is with knowledge, and this is with intent to inflame the jury. No question about it.
But I believe some of the jurors are parents who are also gun owners. correct? Wasn't that part
There
of the
are
profile?
gun owners who are
So
parents here.
It's almost like you need to read the room a little bit. You need to understand your audience because they may think this is overreaching.
I think that's a real risk. Yeah, you have a parent in there who, bought a handgun, has the pamphlet. I mean, I just bought a handgun not long ago. It has these pamphlets, and I have no idea what the hell they said. I didn't read through all the pamphlets when I purchased the handgun. And you have parents who are on that jury who may think, well, geez, if he's being held to that standard, am I going to be held to that standard? And you risk the slippery slope, problem where you don't want a juror to think, but for the grace of God, there go I. And that was the argument, the whole argument in the first case with Jennifer Crumbley. That was what the defense, she got up and said, I'm a terrible mother. I do things, off on the fly. I have fights with my husband. You should see our texts. Therefore, I could be sitting right here with Jennifer Crumbley, and wanted the jury to impute that and think, you know what? Yeah, she's right. I'm not going to go along and be a part of this. I'm not going to convict. And that's the risk you have in this case with this overreaching. Am I going to have the government question my motives when I say I love you? Am I going to have the government question my motives because I didn't, counsel my son from a pamphlet in a gun case? That's a real risk.
What about the video we saw of Jennifer training with the shooter there? Do you think that was subconsciously putting in their heads that she's the one who took him and got him prepared for what happened?
It very well could be. You have to remember, people, when they're exposed to video, that's more powerful than anything you can say. If you notice, during the direct and the cross-examination of some of these witnesses, the prosecution has the gun up, they have the math assignment, and they're slow to take it down. So it's quite clear to me that with every video, they're trying to paint a picture and put that picture in the minds of the jurors. So of course, yes, I believe that is exactly the case here.
Mm-hmm. And as Rick mentioned, we are expecting to see 2 new witnesses in these trials. We're expecting to see a student who was injured in the attack, as well as the former owner of this weapon. So considering that those are ahead of us, what sort of witnesses do you think the defense could call down the line?
That's an excellent question. I think based on getting through, especially the student, I wouldn't necessarily be so worried about the gun owner, but assume that she can get through this student. If I were the defense, I would be calling somebody that probably would know his character, their character. Try to introduce character, try to do something like that to diffuse the power that this witness is going to bring, not the previous gun owner. I'm not even sure why they're calling that person. There's no chain of custody issue here. We all know that Mr. Crumbley purchased the gun. So this is just, I think, another overreaching attempt. But be that as it may, if I'm the defense, I'm sitting there saying to myself, I'm probably not going to ask the student any questions, because that is going to be some compelling testimony. So what I'm thinking is diffusing that to get a witness on the witness stand, or at least coach my client and tell my client, again, you've got to fall on the sword. You've got to show some empathy here. You've got to accept some responsibility for being a bad parent. But of course, you're not a parent that could have foreseen this tragic incident. So that's what I'm thinking if I am the defense attorney.
With all due respect, I disagree with my esteemed colleague, Counselor Reed, on the one issue of calling a character witness. I would never call a character witness in a case like this, because he has, frankly, such a bad character. And what you can do with a character witness as the prosecution is you can rebut the evidence that came in as to good character by examples outside of the courtroom evidence to say, well, if you knew that he had multiple affairs, would that change your testimony? If you knew that he had stolen, from Target last week, if you knew that he had done this, and this.
You're allowed to bring those types of elements into
Yes.
play if character comes into
to
play?
rebut the good character. And then at the end of that say, now, knowing all of this new information that you didn't have previously, does that change your opinion regarding his character as to truthfulness or character as to dutifulness or whatever it may be? And then the witness typically would say, yes, that would change. It can be devastating. So with character, what you can get out of character evidence and there are times when you would use it, maybe a fraud case or something, where there's not this extraneous outside evidence, character for truthfulness, etc. But it can just decimate your defendant, your witness.
Oh, no question about it.
Yeah.
And you use it when you know your client's background. You use it when you know that it presents less of a risk to you. In 30 years, I may have used it once. But this is still something I think she should at least think about. But she's got to know her client. She's got to be very familiar with his background to not necessarily avoid, but to mitigate some of the things that my esteemed colleague talked about. But I think she has to at least coach her client, put him on the witness stand, and have him again fall on the sword, admit some things, but show the jury that this man is human, that this is the kind of person that certainly if he had have known, right, that he would have tried to do something about this.
Yeah, there's not a sentient being, in the history of mankind that you can put in this place and time as a parent who would say, anyone, not the counselors, anyone, who would say, listen, had I known this was a remote possibility of occurring, I would have stopped it. So of course he's going to say he would have stopped it. The only knucklehead that I can think of who said that they wouldn't do anything different is Jennifer Crumbley, who's now sitting in the Hooskow waiting to do, 7 or 8 years because of her and her lawyer's stupidity. But I can't imagine there's any circumstance that James Crumbley, if he testifies, would say emphatically, had I known, I would have done differently. I would have stopped it. But that is not the elements of this crime. His knowledge is not even an element. Whether he knew or should, it's whether he should have known, whether it was reasonably foreseeable. And I think that based upon the totality of circumstances at this point in time, it was reasonably foreseeable that something.
You saw the math sheet. They just showed it again.
Yes, of course, something incredibly horrible was about to happen had they just done ordinary care and intervened in a minimal way. It could have been prevented.
And the parents and the school.
No question. And I think that's an opportunity for the defense to segue into, back to Rick's foreseeability point, going back to the testimony of some of the witnesses we've seen without searching, the one that said that, hey, I wouldn't search the bag. I didn't know that this was going to happen. After even hearing the mother's story, the boy's story, the dad's story, I was even less concerned. I think it's an opportunity for the defense to segue into, well, if they didn't know, then certainly they're trained, they're educated, they have the knowledge, they have the experience, they work with all these kids.
But
how can you expect that to be imputed to the parents?
Arnie, so this set of facts, what would you think? They turn over the math test, the quiz, with the blood everywhere, I need help, the bullets, the handgun on there, and they show Mr. Crumbley, and he's sitting there and he says, well, Jesus, you know what? We just bought this handgun 3 or 4 days ago, and these bullets. What do you think of that, Mr. Ejac or Mr. Hopkins? Do you think at that point in time that one of those two would have thought, well, we now have reasonable suspicion to search this handbag at our feet? Or the parents would have said, wow, this is a coincidence. Let's check your bag. How would that change your estimation?
That's an excellent question. My gut reaction is they still wouldn't have searched the bag. Absolutely not.
Interesting.
They wouldn't have searched the bag. But what it would have done was given Mr. and Mrs. Crumbley a better angle at a defense to say they said everything. But by them not saying that, the prosecution is able to say, which we've seen in this case, hey, the school discharged their duty. The parents held back. I think it would have helped the parents a heck of a lot more, but they would not have searched this bag.
I think they would have.
You think they would have?
I do. Yeah, I think they would have. I think EJAC would have searched the bag, thought, yeah, I have reasonable suspicion at this point to search this bag, or ask the kid, you know, do you have a gun or a weapon in the bag? But would have taken other actions. And I think that's the critical
Well, let me
question.
ask you this, though. Let me interject, and maybe you can help me with this one. Reasonable suspicion, we remember now, it applies to police officers. Schools are more legally administrative, so they can take action on less than reasonable suspicion in terms of going into lockers and doing things like that. This reasonable suspicion standard, I don't believe necessarily is dispositive of his ability to have searched that backpack, because schools are different. You see what I'm saying?
Yeah, I don't think that I don't think that's accurate. I think that schools administration, they have a duty based on the Supreme Court case that they have to have reasonable suspicion to search lockers, bags, etc. That it's not an unfettered discretion whether or not they can go through at their own
Not at their
will.
whim necessarily, but
yeah, I think that standard is reasonable
suspicion.
Yeah,
yeah. I still don't think he would have done that. He may have said he would have done it. Hindsight's 20/20, but with that information, I mean, because he's had kids even talk about suicide, who were suicidal. And by his own testimony, he says, well, you know, we have all these kids who are suicidal. He doesn't check their bags. He doesn't suggest that all of them go home. He maybe have suggested some. So if students are in there saying that they're suicidal, right, and he doesn't send them home, he wouldn't have checked the bag. If Ethan had said, I'm going to do harm to somebody, then I think he would have checked his bag. But short of saying or making that threat to other people, I don't think.
See, I think Ethan Crumbley was saying, I'm going to do harm to somebody in that on
What
that
about
math
the
worksheet.
blood everywhere?
Yeah, that's right.
There seemed to, again, hindsight is 20/20. They were thinking, at least what they're saying, both the parents and the school counselors, that they were concerned for self-harm, not for harm of others. But yes, it did seem there were hints in that math sheet that meant it would affect more people than just him.
No question. The amount of blood that they talked about, he had reasonable suspicion. I mean, in my view, he did. You had enough information to be concerned that something was going to happen, right? And it's just not reasonable suspicion that you're going to do something to somebody else. You had more than reasonable suspicion to think that he was going to do something to himself. So for you to sit there and not say, give me the backpack, right? And just let him stay in school, that's a hard pill for me to swallow.
And then Hopkins saying, was so concerned, there was a heightened level of concern whether he admitted it or not, but his testimony showed it, that he was concerned enough to be sure that the shooter was not left alone. Why?
Right.
Why? What articulate why you didn't want him left alone. And that enough is reasonable suspicion.
Exactly.
I agree.
But you know, you brought up an excellent point. The civil trial is underway, at least in terms of motions and whatnot. So we really couldn't expect them, you know, to say anything that even remotely resembles that they thought that they should have searched his bag because of that civil trial,
right.
Number one. Number two, I find it hard to believe that not one somebody who has testified from that school didn't think that that kid should have stayed right in that office and they should have called somebody to come get this kid some help.
Yes, I agree.
And to your point, Rick, the parents did not, in that moment, in that meeting, share any information about owning this gun that he drew.
Right.
If they had just given that, why didn't they share that?
Yeah.
Right.
I feel like if they at least said it, the school would have then been on the track to ask those questions.
Yes.
What was going through their minds? It's almost like they're ashamed or trying to hide something, or it's just, if they had just shared that information, does that in and of itself show negligence?
Well, think about this. If like I mentioned before, if the parents disclosed the information that they had, what, if anything, would those school officials have done at that time? And I believe they would have acted.
All right, well, court has resumed. Let's listen in.
2021, you were employed by the ATF, and you also worked on was it a task force? Did I understand that correctly?
So at the time of the shooting, I wasn't on the task force yet. I was working on cases in Pontiac that which morphed led into the creation of that task force.
In connection with this case, you reviewed a significant amount of information and data in the investigations related to the Oxford High School shooting.
Yes.
And that would be specific to Mr. Crumbley, some specific to Mrs. Crumbley, and some specific to their son.
Yes.
On September 25th of 2021, you testified that that James and his son went to a gun range in Clarkston.
September 25th, yes.
That they rented a 9mm handgun, if you recall, and I can pull the exhibit up if you'd like.
No, that's correct.
Okay. That they purchased 2 boxes of 9mm ammunition.
I believe that's the correct quantity, yes.
If you recall, the price of those boxes was $29.99 each.
I don't recall, but that wouldn't surprise me.
Okay. That sounds about right for a box of 9mm ammunition.
Yes.
There was also .22 caliber ammunition that was purchased.
Yes.
They fired a .22 caliber pistol.
I believe the video we had, yes.
And that was the Caltech that's owned by James Crumbley.
I believe that is the firearm that's depicted, yes.
Okay. And you also learned that they also fired a 9mm pistol.
Yes.
Which is the one that they rented.
Correct.
That was the HK.
Yes.
In October 3rd of 2021, they went to the gun range again, they being James Crumbley and his son.
Yes.
They purchased .22 caliber ammunition.
I don't recall the exact receipt for that day, but that sounds correct for that day, yes.
And in October of 2021, to your knowledge, based on your knowledge of the investigation, there were 2 pistols in the home, and that was there were BB guns as well. I'm not referring to those.
Sure.
There were 2 pistols. There was the Derringer, which you've been shown, and the Caltech.
Correct.
Okay. Those are both .22 caliber handguns.
Yes.
November 26th of 2021 is when the Sig Sauer 9mm was purchased.
Yes.
And that was done so by James Crumbley.
Yes.
And if you recall from the receipt, there was it was a handwritten receipt.
Yes, the receipt was handwritten, yes.
And the receipt had the firearm listed.
Yes.
The serial number of the firearm.
Correct.
Prices and things of that nature.
Yep.
Okay. On November 27th of 2021, James Crumbley's wife, Jennifer, took their son to the gun range.
I'm sorry, what date was that again?
November 27th of 2021.
Correct.
So that was the day after the 9mm was purchased.
Yes.
They purchased 2 boxes of Patriot Defense 9mm ammunition.
Yes.
Based on your investigation, you learned that they fired 1 full box of ammunition, or at least you believe that that occurred.
That's correct.
You recall that each box was approximately $23.99.
Yes.
That they left with 1 box of 50 rounds of ammunition.
Correct.
I'm going to get back to, you compared the handgun on the math assignment and also the handgun in the home. I'm going to get back to that in just a minute, but I do want to talk about keeping a handgun safe in a home. You would agree that there are a variety of ways to keep a handgun safe in a home, and I'm going to give you some examples. One would be to store it in a safe.
I would say that's one way to. Are you saying, when you said keeping a firearm safe, what does that mean exactly?
Sure. Well, just that. Keeping it safely stored, keeping it safe in the home.
See, I'm not trying to play a game. I'm just trying to. So you're saying like keeping it safe from access or from a person? Like I'm trying to understand.
Sure. Safe from others, safe from accidents, safe from accidental discharge, safe from mishandling, safe from ...
Sure. That's one way I think you could keep a firearm securely stored inside of a home.
You can store it in a locking gun case. We saw that the cases that were on the table, they have holes where you could put a lock in them.
Yes,
that's another way.
Yes.
You could store it in the small safe. I guess there's a couple different styles of safes. There's the little safe that you showed us earlier, and then there's other bigger safes, correct?
Yeah, there's a variety of gun safes out there, yes.
You could use a cable lock.
Yes.
You could use a trigger lock, which goes in the trigger.
Yes.
You could store the firearm unloaded. Obviously, an unloaded firearm is not inherently dangerous, correct?
I don't want to speculate on whether that would be a safe way to secure a firearm because you don't know, I'm not whether knowing all the ins and outs of whether someone else has ammunition or magazines or things like that. I don't want to I can't answer that question.
Sure. I guess my question is actually a lot more simple. I'm not asking you to speculate on anything.
Sure.
Simply having an unloaded firearm, is an unloaded firearm in itself dangerous? Or does it become dangerous when you put ammunition in it?
I would say that the answer to that question really depends on the proficiency with firearms of people in the home. If you have ammunition stored separately and it's just the firearm by itself, if someone clearly knows how to load a magazine and insert it, it's no longer stored safely secured, I would think.
My question is a little bit different, though. It's not necessarily talking about, and we can get to the other stuff too. I'm not asking you to avoid that.
I'm really just trying to answer your question. I'm trying to understand what you're trying to ask.
Sure.
Yeah.
What I'm trying to ask is an unloaded firearm, in and of itself, no ammunition in it, no magazine in it, is that itself unsafe?
Again, I don't know what else. Not knowing what else is in the home, I can't answer that question.
Okay. You would agree that keeping a handgun safe depends on a variety of circumstances. And you talked about some of those, not knowing if there's ammunition in the home, right?
Yes, are you talking now again about the same line of it being stored just by itself?
Correct.
I mean, yeah, there are so many factors that would go into whether that would be a secure way to store a firearm, yes.
Where it's stored could also be dependent upon the age of the people in the home.
I think that's one relevant factor, yes.
The people who live in the home, their knowledge of firearms. And I think you mentioned proficiency, like whether or not somebody could load a magazine.
Right. I think we're getting into an area that's kind of, I don't know how to answer that question. I'm just really trying my best here. I don't know how to answer that question. There's just too many variables.
There's a number of variables. That's kind of the point that I'm making. There's a number of variables that go into determining whether or not a firearm is stored safely. Is that fair?
Yes. There are a number of variables that come into play when considering how to store a firearm, yes.
Okay. One of the ways that we just discussed was a cable lock. Cable locks can be removed in more than one way, correct? It can be removed by using a key and unlocking the cable lock?
Yes, that's the way to unlock the cable lock, yes.
And I think that one of our witnesses previously also testified that you can also cut off a cable lock.
Yes, I'm aware that there are tools you can use to defeat the cable lock, yes.
As for the youth handgun safety pamphlet that the prosecutor showed you, you're aware of federal law, which that ATF handgun safety pamphlet is about federal law, correct?
Yes.
It's not about Michigan laws.
Correct. I believe it references state and local ordinances at one point, but generally speaking, yes, it references a federal law.
Okay. And you're aware that it is legal under federal law for a minor to possess a handgun in certain circumstances?
Yes, that's correct.
That includes going to a shooting range?
So we have to be careful about how we're using the words in that sentence. So there's five specified things in particular about what minors can do alone with firearms with written consent from their parents. It could be hunting, ranching, employment, target practice, and hunting, I believe. But there's specific things you have to do with as far as if they're doing it alone with written consent, the consent has to be on them. There's a variety of things in the actual statute itself. I can't recall all of them off my head, but if I'd have to love a little more information to know that was okay.
Sure. And we don't have any evidence, and we haven't looked at any evidence during your testimony, and you've been sitting in court for all the witnesses, correct?
That's correct, yes.
There's been no evidence presented by Mr. Wagarowski or any other witness to show that Mr. Crumbley's son went to the range by himself?
No, not that I've discovered.
Okay. So we're talking about going to a shooting range with a parent. That itself is not illegal under federal law.
No.
Learning firearm safety. A minor can handle a firearm while learning firearm safety. Again, assuming they're with a parent.
Right. There's only certain things that are covered by federal law that federal law even touches upon, and it's the transfer of a handgun to a minor. It's not even contemplating those scenarios you're discussing. So there is not a federal law that says a parent can't show their child firearm safety. No.
And during your involvement in this case, you found no evidence that James Crumbley was aware that his son had obtained unsupervised access to any of the firearms in his house.
Can you repeat the question?
Yes. During your involvement in this case, you found no evidence that James Crumbley was aware that his son had obtained access to the firearms in his home.
I don't recall him ever having the videos of his son playing with the firearm or anything like that, just the fact that he was present during the time.
So he was in the home during those times, but you don't have evidence that James was aware that those activities were occurring. Is that fair? And I'm not trying to trick you.
No, I haven't. I understand your question. If I understand it correctly, you're saying that there's not evidence that he sent a video to his dad saying I was playing with this gun or something to that effect. I never found anything like that, if that's what you're asking.
You've been involved in this case since November 30th of 2021. We heard your testimony about that. You were involved in the search of Mr. Crumbley's home?
Yes.
And that was on November 30th of 2021?
Yes.
And we talked about there were various BB guns found in the home. That's not illegal, correct?
I can't even comment. I don't know. I'm sure they are. I have no idea.
No idea. Okay.
Under state law, I have no idea what's legal and not with BB guns.
There were also 2 pistols which were located in a gun safe, which you testified about previously.
Yes, that's correct.
That gun safe with those 2 handguns were located inside of a TV stand or a dresser of some sort?
It was like, I think it was a dresser that had a TV on it, and it was like had like a couple of drawers and a sliding thing in the middle.
So it was located inside of that dresser in a cabinet?
Yes.
There was also an empty Sig Sauer gun case, which we've seen, found in James's bedroom.
That's correct.
Along with an empty box of Patriot Defense 9mm ammunition.
Yes.
Also found in James's bedroom.
Yes.
You learned that Mr. Crumbley purchased 3 handguns between June and November of 2021.
Yes.
We went over those purchases today.
Yes.
With each purchase, you know that Mr. Crumbley signed a trigger lock statement.
That's correct.
And you reviewed those as part of your involvement in the case.
I reviewed the documents from every purchase, yes.
Now, you also know that for an FFL dealer to be compliant with federal law, that they also have to provide the ATF youth safety handgun notice.
Correct.
With each purchase.
Yes.
So, Mr. Crumbley purchasing 3 handguns between June and November, he would have received 3 of those pamphlets.
I believe that's correct, yes.
So, we've talked about one, the one that was found in the Sig Sauer case, but you don't know the location of the other 2.
I do not.
And there's no requirement in that pamphlet or anywhere that Mr. Crumbley display that notice anywhere in his home?
No.
Okay. Federally licensed firearms dealers provide the cable locks to each seller, and typically the cable lock comes with the firearm from the manufacturer. Is that fair?
Correct. With new firearms, that's generally the case, yes.
Used firearms, the cable lock might come from somewhere else. Is that accurate?
Yeah, either the store will have you buy one, or sometimes people throw it for free. It all just depends, yeah.
And I think Ms. Back testified that the cable lock that we have was from Sig Sauer, correct?
Correct.
Cable locks are not necessarily specific to each firearm. So it's not like a key in a lock, right, which is specific to that lock. Cable locks can be used on other firearms.
Yeah, generally speaking, yes. They can be used on multiple makes and models of firearms, yes.
So assuming that there isn't an issue with the caliber, a 22 caliber we've determined has a smaller bore, so it's more narrow than a 9mm, which has a wider bore.
Correct.
So a cable lock specific to a 9mm may not fit in a 22 caliber, but a 22 caliber cable lock may fit in a 9mm, if that makes sense.
It depends how you use it. I mean, if you were going to put it through the magazine well and not the actual barrel, there's different recommendations on how to use it. But if you were going to put it through the magazine well and lock it, it would fit both.
So that Sig Sauer cable lock isn't necessarily designed just for that Sig Sauer. A Kel-Tec cable lock could have been used on a Sig Sauer, correct?
Kel-Tec, to my knowledge, does not make cable locks. They provide trigger locks, but I get your point. Yes. A different model could work just as well.
Okay. There are also universal cable locks, which we've kind of talked about, which could work on any caliber handgun.
Correct. Semi-automatic handgun, yes.
Semi-automatic, thank you. Again, Mr. Crumbley, we know, received 3 either cable locks or trigger locks in connection with the purchases of the handguns.
Correct. Based on the documentation we have, yes.
Right. You found 1 cable lock in the home.
That's correct.
The keys were still in the lock.
Yes.
You did not find the other 2.
No.
Or their keys.
Not to my knowledge, no.
You don't know where those other 2 cable locks are?
I believe there would have been a trigger lock with the Kel-Tec, but to your point, yes.
Okay. You don't know whether Mr. Crumbley had a cable lock on the SIG or not at the time that it was taken by his son, based on your investigation.
Son, based on statements made that we've heard in court and other things like that, I've never heard mention of a cable lock. I've always heard hidden.
Okay. You don't know that. Is that fair, based on your investigation?
I know that one wasn't recovered at the school or in the house. So is it a certainty? No, I think it's highly improbable.
You said that one was recovered at the school?
I said one was not recovered at the school.
Oh, I'm sorry, I didn't hear you.
So it would, yeah. I found no evidence that a cable lock was ever installed in that firearm.
The prosecutor was asking you about the difference between a 22 caliber round and a 9mm round, and there was something about the size of it, the bigger the round, the bigger the hole, things like that.
I don't know if I said that today, but I know it, yes.
Okay. There's no evidence that you've learned to show that James bought a gun because he wanted more damage. I think that's what you said, more damage.
More damage? Yeah, I don't think I found any evidence that James decided to purchase that firearm. If my understanding is right, based on things, is that the only person who ever researched the purchase of the firearm was the shooter.
We also heard Ms. Back testify that and confirm that when Mr. Crumbley went and purchased the 9mm Sig Sauer, that he had made indications that he had been looking at it for a few days. Do you remember that testimony?
Yeah, I remember it was either a few days or quite some time. I'm not sure the phrasing, but I remember hearing that testimony, yes.
And we know that James Crumbley also has fired a 9mm prior to November 26th of 2021. I believe it was September or October of that year.
Yes, I recall he had at least fired it then, and then maybe in July of that year too.
We talked about Exhibit 167, which was the small safe.
Yes.
The combination on that was 000.
Yes.
You have no knowledge if anyone other than James knew the combination of that safe?
I do not.
Specifically, you have no knowledge if his son knew the combination of that safe?
I do not know if he knew the combination was 000, no.
You don't know if James was aware if his son had the combination to that safe. Is that fair?
I have found no evidence that he provided the combination or his son knew the combination, but based on the fact that we recovered the firearms in the home in the safe and that we have videos of, at least there's the one video on, was it August 19th and August 20th, the two videos of Mr. Crumbley's son playing with the Kel-Tec. There's also a video, I forget the date, of the shooter playing with a Derringer inside the house at one point. So if they were in the safe, I don't know if his father was there or not. I can't answer that question for certain whether his son knew the code to that safe.
Okay. And you talked about August of 21. That was obviously before November 30th of 2021 when you recovered that safe from the cabinet.
Correct.
You testified with the prosecution that you were, I believe you used the word shocked to find the ATF youth handgun pamphlet in the Sig Sauer gun case, right?
Yes.
Now, we just talked about the fact that there were at least, we believe at least, 2 other pamphlets that were provided to Mr. Crumbley. Correct? Because we know that because there were 2 other firearms in the home, sure. And you have no reason to believe that those were not sold in compliance with federal law.
Correct.
You don't know when or how often Mr. Crumbley reviewed those pamphlets with his son?
I do not.
Prior to November of 2021?
No.
In fact, it would be an assumption that because it was in the Sig Sauer case, that must mean that Mr. Crumbley wasn't reviewing those rules or following the rules with his son. Is that fair?
Can you either rephrase or repeat the question?
Yes. It would be an assumption about whether or not Mr. Crumbley reviewed those pamphlets with his son just because it was found in the Sig Sauer case.
Correct, yeah, I think that's why I said I was shocked that it was just kind of discarded to the back, yes.
And we also established that there was no requirement that he post that pamphlet anywhere in his home.
Correct.
The prosecutor asked you about registering handguns. You don't know whether James mailed the pistol sales records, correct?
You mean mailing them in to, if they were mailed in process?
Good afternoon, and thank you for joining us on CBS News Detroit at 4. Terrence Friday.
And I'm Meredith Bruckner. Testimony continues on day 3 of James Crumbley's involuntary manslaughter trial.
So we have special gavel-to-gavel coverage for you in the trial. Before we listen to the courtroom, we want to warn you that some of what you may hear and some of the images you may see may be disturbing.
So I'll take your word for it.
Well, and I can show you the exhibit if you'd like. The pistol sales record actually lists the penalty at the top.
Sure.
You talked about Mr. Crumbley's son's stance while at the shooting ranges. And you said that it shows that there's some level of proficiency, that he has some level of proficiency with firearms. Do you remember saying that?
Yes, I believe I was talking about the surveillance video from the school, but yes.
Okay. You would agree that it's important for people in a home where there are firearms present to be familiar with them. And let me clarify that question a little bit.
Sure.
Obviously, if you have a 2-year-old in a home, you are not going to familiarize your 2-year-old with a firearm. Is that fair?
Sure.
Not intentionally.
Correct.
If you have a teenager in the home or other adults in the home, they should be familiar with the firearms if they're going to be in the home. Is that fair?
I think that's obviously a personal decision. It's not something covered by federal law that you're required to do that. I think some people may choose to not do that and just keep them away from their kids and out of view. But like I said, that's not something I can speak to.
Prosecutor specifically asked you about Exhibit 169, which was the firearm purchase on June 15th of 2021, and that there was a delay. You testified that sometimes the background may take time. That's not a negative or a positive, it's just a fact that sometimes they take time.
Correct.
You heard voices, if you recall, in Exhibits 172 and 173 at the outdoor range, which was where the videos on Mr. Crumbley's cell phone of his son firing the Kel-Tec and a Derringer. Do you remember those videos?
Is that the June videos? June 20th?
Yes, June 20th, yes.
Yes.
And you recall that there were other voices. Do you recall hearing other voices?
I don't recall hearing them. I don't disbelieve you.
Do you recall hearing other firearms being fired? I don't know what they were, but you can hear other firearms being fired.
I don't recall after watching it right now this time. I've just focused on the shooter in this instance. I don't think it's out of the realm of possibility that other people may be shooting at a range as well.
Exhibit 175 is the Instagram post by James Crumbley's wife that both Mr. Crumbley and his son, quote, both got handguns.
That was the Instagram story?
Yes.
Yes, yeah.
And that was, that video is showing Mr. Crumbley's son firing the Kel-Tec.
Yes.
Which was in the safe in his room. In the safe in Mr. Crumbley's room.
On November 30th, yes.
Correct.
Yeah.
Exhibits 70 and 71 are the August 19th of 2021 video and text that we just talked about a few minutes ago. That is of the Kel-Tec, correct?
Yes, both the August 19th and 20th videos were of the Kel-Tec, yes.
So you would agree that these may have been the same night. The August 19th video was about approximately 9:30 p.m. and the second video was about 12:30 a.m. the following morning.
Correct, yeah, it was the same night into the following morning, yeah.
Exhibit 70 and 71, you specifically can see that the Kel-Tec is unloaded.
In the 819 video?
Yes.
Yes.
That there's no round in the chamber and that the safety is not engaged.
Correct.
Exhibits 72 and 73 are the August 20th of 21 videos. Your testimony was that Mr. Crumbley's son slammed the firearm down onto the magazine and released the slide forward.
Correct, yes.
You testified that the way that Mr. Crumbley's son was handling that firearm was not safe handling.
Correct.
You may have also testified about this, but I wanted to clarify. There was nothing in your investigation that showed that James was aware that his son had made that video.
No, again, just only what I testified to, that he was in the home at the time of the video, but no.
Exhibit 190 is the September 25th, 2021 gun range. There was some 9mm rental, some ammunition purchased, and then targets also purchased.
Yes.
There were silhouette targets and also non-silhouette targets purchased, if you recall.
I don't recall, but I take your word for it.
There were also range safety officers present, if you recall.
Yes, I think that's standard at that range in my experience.
You described a little bit and discussed a little bit watching Mr. Crumbley's son, and I don't know if you used the word misfire, but you indicated in your testimony that Mr. Crumbley's son was having an issue with the semi-automatic handgun.
Yes.
That he was struggling and was unable to clear something, correct?
Yeah, I think he thought a round was in the chamber, and he thought he cleared it, but there was actually nothing in there, and that's when Mr. Crumbley picks up the magazine and inserts it and makes it operable again, yes.
And obviously we know that Mr. Crumbley and his son went to the shooting range.
Yes.
And Mr. Crumbley's son handled the handguns. We watched it.
Correct, yes.
You would agree that it's important for a person who fires a firearm or a handgun to know how to properly clear a misfire.
Well, I wouldn't say that it was a misfire. I would say that, what appeared to me is that he was, being instructed by his father on how to properly deal with any malfunction of the firearm, which is when he racked the slide and then, insert the magazine.
So same question, but worded a little bit different. It's important for somebody who handles a firearm or who fires a firearm to know how to deal with things that come up while you're firing it. Is that fair?
I would say that's a safe way to, if you're going to be shooting a firearm, that's correct.
And if somebody handling a firearm or shooting a firearm doesn't know how to properly do that, it can have potentially very dangerous consequences.
Yes.
Okay.
Exhibit 95 is the social media post by Mr. Crumbley's son about the one where there's the multiple photos of the Sig Sauer. He talks about his new beauty, his 9mm, his Sig Sauer. That.
I recall the post.
Okay. There was no evidence other than those pictures. Well, let me say this, and I've asked this question before. You've heard it. Based on those photos, you don't know if Mr. Crumbley is standing right outside the frame of the photo, correct?
I do not know.
Okay. You've learned nothing during your investigation to show that Mr. Crumbley wasn't standing there with his son.
On the day he purchased the firearm, when he took those photos?
Yes, November 26th.
Correct.
There's no evidence that Mr. Crumbley gave his son that Sig Sauer and that he had it unsupervised. Is that fair? Other than on November 26th of 2021.
So I recall there being another video that Detective Bobrowski testified to that I've also observed. I believe that was later that night, showing the shooter in possession of that firearm, filming down the barrel of it. I don't recall any other videos or photos of that on the devices.
And along the same lines as I've asked previously, you learned nothing during your investigation that Mr. Crumbley was aware of that video, the one that you just described, later that night on November 26th of 2021.
Yeah, again, the only thing I believe he was also present in the home for that one, but that's the only thing that I could find. Yes.
In fact, the Sig Sauer case was found in Mr. Crumbley and Mr. and Mrs. Crumbley's bedroom.
That's correct. It was on the bed it was open next to the box of Patriot Defense ammunition.
Exhibit 97 was a photo taken by, I believe, Jennifer Crumbley of the open Sig Sauer box with the Kel-Tac and the Sig Sauer in the case, correct?
Yes.
That has the ATF pamphlet and the cable lock.
Correct.
In looking at the Kel-Tac, there's no magazine in the Kel-Tac.
I don't believe so in that picture, no.
You testified about the Exhibit 42, which is the cable lock that was found at the Crumbley home. Your testimony was if it was used regularly, the bag would be damaged. That cable lock was provided 4 days before you found the cable lock in the home, correct?
Correct, yeah. But if you tried to take that in and out of there, the way that the cable lock expands in that bag, it would tear up the edges of it. So there would be more wear and tear on the bag.
Exhibit 95 is the receipt on November 27th of 2021 when Jennifer Crumbley and her son went to the shooting range.
Yes.
I think I've already discussed this. There was Patriot Defense 9mm ammunition purchased that day, 2 boxes.
Correct.
Based on your investigation and your involvement, that was the first time after that Sig Sauer was purchased that ammunition was purchased.
From records we've located, yes, that's correct.
If you recall, and if you don't know the answer to this, please tell me. You reviewed a lot. Did you also review any statements made to law enforcement or the interview from the substation of Mr. Crumbley?
Yes.
Okay. And if you recall, during that interview, James did not know how much ammunition was purchased that day, November 27th of 21.
I recall there being a conversation between him and his wife, and I believe he ends up correcting her, saying it was 50 rounds, but I don't recall the exact words he used.
Okay. They discussed the cost.
I believe so, yeah, because he was. I think she initially thought there was like 200 rounds, and I think he eventually informed her it was 50 rounds.
Okay. Exhibit 196 is the video of Mr. Crumbley's son and Mr. Crumbley's wife at the range. You can see when Mr. Crumbley's son is actually in the booth handling the handgun, the 9mm handgun, the 6 Sauer, that there's actually a range safety officer standing slightly behind him to the right. He's got like a bright yellow vest on, correct?
Yes.
And if you know, and I assume that you do know, the purpose of a range safety officer is to ensure that people are handling the firearms correctly.
Yeah, I would say it's in compliance with whatever the rules are for that specific range, yes.
So if that, we would assume, and if you don't want to assume that's okay, but if that range safety officer had seen Mr. Crumbley's son doing something incorrect or inappropriate, it would have been raised as an issue that day.
I would assume so. That's his job, so yes.
The empty box of ammunition that was discovered in the Crumbley home on November 30th of 2021 was Patriot Defense ammunition.
Yes.
And I think you testified earlier that there are 9mm ammunition is more expensive than .22 caliber ammunition, correct?
Generally speaking, yes.
Okay. But within that, there are varying levels of expensive for the 9mm ammunition, correct?
Correct.
And we know that there were 2 different prices on 2 different purchases of 9mm ammunition in 2021 by James Crumbley and by his wife Jennifer Crumbley.
Yes.
And obviously, if you're going to the shooting range, you need ammunition to shoot, correct?
Yes.
So it's not unheard of for somebody to buy rounds of ammunition at a shooting range.
No.
During your involvement in this case, you saw no information that James Crumbley was aware of the Instagram post by his son. Let me clarify, because I think there were a couple. The Instagram post where his son commented, it was Exhibit 100, about his, quote, new SIG.
I don't recall if he saw that one. I know he saw the social media post by his wife of the firearm, but I don't believe that there was evidence of the him viewing that specific post that I found.
You also talked, lastly, you talked about the similarities between the drawing of the handgun on the math that we've seen, the math assignment that we've seen in Exhibit 130, and also, and let me see if I can get back to it, and also the similarity to the handgun, the 6 Sauer handgun. Do you remember making that comparison?
Yes.
Okay. Let me see if I can pull that up.
Any person that's turning on the TV, guys?
Oh, yeah, there's a button on the back.
Bottom. There we go. That's fine.
Can you see? Okay.
Yes.
So you talked about the similarities were the striations on the back of the slide.
Yes, that was one of them, yes.
The location of the ejection port.
Yes.
The shape of the trigger guard.
Yes.
And for those reasons, you believed that that was the same as the 6 Sauer handgun.
And also the shape of the floor plate of the magazine. When all those are combined, each one taken in isolation, not the case, but if you put them all together, then yes.
And you're obviously work for the ATF.
Yes.
You have some significant familiarity with handguns.
Yes.
This is the 6 Sauer handgun. It's Exhibit 86. This is the Smith & Wesson handgun. A photo that was sent to James Crumbley by his son prior to the purchase of the 6 Sauer handgun.
Correct.
There's striations on the back, correct?
Not on the front.
There's striations on the back?
There are striations on the back, but not the front of that firearm.
And that's the ejection port that we can see on the top. Well, the side facing us. Obviously, you can't see what's on the other side.
Correct. There's also a black line that's not, it's a two-tone firearm, and there's a black line. There's vast differences between that one and the one that's drawn. There are some similarities like we discussed, but I said again, taken in isolation, it could be a different firearm, but when all put together, it appears to be the same firearm.
And you don't know if anyone who viewed that handgun on the math homework even made the connection between that and the 6 Sauer. Is that fair? Other than you. We know you did.
I found no evidence that they did. I know that if you buy a firearm, you generally know what it looks like, but
Okay. I have no further questions, Your Honor.
Redirect.
Briefly,
Special Agent Brandon, Defense Counsel just asked you some questions about other cable locks being used or could have been used. Do you remember that?
Yes.
All right, and she asked you about the other 2 cable locks. Do we have any evidence there were 2 other cable locks ever given to James Crumbley?
No, there were 2 trigger lock forms. It could have been trigger locks or cable locks. And honestly, the cable lock for the Derringer probably wouldn't even work because you'd have to have one small enough to fit through the actual firearm itself, which the SIG one would not.
All right, and you just testified that you believe a trigger lock was what was sold with the Caltech. Did you say that?
Yes, that's correct.
Okay. Did you find any evidence of a trigger lock or another cable lock anywhere in the home?
No.
Anywhere in the school?
I didn't search the school, but I'm not aware that one was ever located.
Okay. She just asked you about the comments at the substation. Do you remember that?
Yes.
Okay. What did James Crumbley say when he was asked where that weapon was?
I believe he said it was in the armoire, hidden in the armoire, and then he said the ammunition was underneath a pair of jeans.
Did he ever say locked?
No.
Was there anything that struck you about his mention of the SIG?
Yes. So when he mentions the SIG Sauer, he mispronounced Sauer as Sawyer, which if you purchased that firearm and it was for yourself, you'd be familiar with how to say SIG Sauer.
Okay. And
Your Honor, I would object to that response and ask for it to be stricken. He's making an assumption about what Mr. Crumbley knows.
I'll move on. Special Agent, last question. You mentioned earlier that you reviewed the cell phone data and web searches that were on the phone of James Crumbley.
Yes.
All right. And did you ever find any searches that he did relating to firearm safety or minors?
I did. There were searches related to that topic. It was after the shooting had occurred.
Okay, so December something, after the shooting occurred.
Yes, I don't recall the exact date, but it was after the shooting.
Anything before?
Regarding firearm safety, not that I recall.
Thank you. Nothing further. May this witness be excused, Your Honor?
Yes, you can step down and you're excused.
Thank you, Your Honor.
You don't have someone brief for today.
Not 15 minutes, Brief Judge. We have somebody here, but we wouldn't get through my direct, that's for sure.
All right, so 9 o'clock tomorrow?
Yes, sir.
Thank you, Judge.
I need to tell you, ladies and gentlemen, during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses and sworn.
All right, we are watching the trial for James Crumbley, day 3 now, father of the Oxford school shooter. We have to take a break right now, but we're going to be joined back by our legal experts to unpack some of what we saw play out in the courtroom today. Stay with us.
The trial for the father of the Oxford High School shooter is moving fast, and court just wrapped for the day.
Today, more witnesses took the stand, including employees at Oxford High School. Andres Gutierrez is live outside of the County Circuit Court in Pontiac with a recap of day 3. Andres, good afternoon.
Good afternoon, Terrence. Unlike other days of testimony, today wasn't as emotional or heavy. We did hear for the better part of the afternoon from the ATF special agent who traced the murder weapon and talked to the jury about the shooter's history with it, and that he had practiced with other firearms that his father, James Crumbley, had bought him earlier in 2021. You may recall that on Friday, the jury got to hear Crumbley tell investigators on the day of the shooting at the police substation that he had been taking his son to the range to try and teach him about gun safety. Today, they learned more about those visits at least 6 different times between June and November of 2021. The trips were to an indoor range in Clarkston that began shortly after James bought a .22 caliber Cal-Tec and a Derringer. In one video, you can see James helping out his son at the range when the .22 caliber jams up. Earlier in the day, we heard extensively from the school counselor who had several teachers reach out to him raising concerns about the shooter's mental state. The questioning zeroed in on November 29th, 2021, when Crumbley's son was looking at bullets in class. Then the next day, the morning of the shooting, 2 teachers contacted this counselor, one saying Crumbley's son was watching a movie scene of a person shooting people, and the other teacher raised a red flag over that infamous math assignment with the drawing of a gun and the words, "The thoughts won't stop, please help me." That prompted the counselor to call the parents, and here's how that meeting went.
My hope was that they were going to take him and either take him to get help or even just to take him to let's have a good day. Let's have a day where we just spend time with you, where we are with you.
To take him out of school?
Yeah.
Did you believe that he could be left alone at that point?
I didn't want him left alone. I didn't want to make that decision that he was okay to be left alone. So that's why I stayed with him for as long as I did, until I had parents there.
And he went on to say how he did give the parents 3 pages filled with mental health resources in the area and suggested that the parents that they go out and get him some help. Jennifer Crumbley telling him that that was not possible to do that day and cut the meeting short, leaving him in school. And without knowing that there was a gun that had been purchased days before, the dean of students testified shortly after that counselor that they would have not gave no reason to search his bag, where they would have found that 9mm that was used to commit the worst school shooting in state history. Reporting live in Pontiac this afternoon, Andres Gutierrez, CBS News, Detroit.
And Andres, how fast is this trial moving compared to Jennifer Crumbley's trial?
Well, at this point, in opening statements, the prosecution said they would call about 15 to 20 witnesses. That ATF agent that you heard is the 9th witness they've called thus far, so more than halfway through the list. One witness that we are anticipating to hear from, they said at the beginning of this trial, was the original gun owner, the person who sold the gun to the gun store where James Crumbley purchased the weapon. And he'll testify that he sold it to the store with the gun lock, that gun lock being at the center of this, that it was never used, and so we're expected to hear from him at some point, either tomorrow or later on in the week. And then the defense, we are going to see if they'll call James Crumbley to the stand or not, because in his wife's case, Shannon Smith, the attorney, only called her up to the stand, and that was the only witness. So we don't know who, at this point, Muriel Lehman plans to call. We are waiting with bated breath, as all of us are at home.
All right, thank you, Andres. Yes, certainly with bated breath. Let's bring in our legal panel to break down day 3 of testimony in James Crumbley's trial. And joining us are attorneys Arnold Reed and Rick Convertino. Thank you so much for being here throughout the day. So as Andres mentioned, it was not a very emotional day when it came to testimony. It felt very sterile at times, going over very small details with regard to weapons and law enforcement policy. But a lot of important things did happen under the surface today, Rick.
Well, I'll tell you what my perception is. My takeaway from today was that the defense hit a home run, and not a Cecil Fielder home run, but a John Carlos Stanton 119 mile an hour exit velocity home run. Quick, bam. She did an excellent job of diffusing all of what all of importance what the special agent from the BATF said. She took the evidence and viewed it in an alternate way, and that's what we talked about earlier. And I thought she did a very good job of doing so, and I thought diffused and mitigated all of the assumptions that were testified to on direct examination regarding the drawing of the gun. Well, maybe that wasn't the exact gun that was drawn or the bullets drawn, and who would draw that conclusion based on that? And he said he was probably the only one who would, based upon his knowledge and expertise in handguns. I think she did an excellent job telling the jury that there is a different way to view this, and you don't know if because of the pamphlet he was shocked. Shocked. I'm shocked that there's gambling going on. Casablanca. That how could he be shocked, and how could he say that when he doesn't know if Crumbley took his son in the kitchen table and said, hey, let me tell you about handgun safety, holding the pamphlet, took him outside, or had a talk with him in the car going to the gun range. All of that he admitted to not knowing, that there was no evidence whatever. Just because that pamphlet was found where it was evidence that they never talked about handgun safety. So I think she did an excellent job in really diffusing this testimony. And as we sit now today, March 9th, at the end of testimony, end of the third day, I'm convinced in my own mind that there are jurors on that in that box who have a very reasonable doubt.
Interesting.
Yeah.
A lot of conversations as well, Arnold, about the school and the school's involvement. What have been some of your thoughts on that?
I think, just to pick up on Rick's point, and I'll address that in a second, Terrence, she did an excellent job in countering, as Rick said, the conversation about the lock. The prosecution made it seem like the fact that the lock still wasn't out of the package was dispositive as to the parents' derelictions. She came right back and she said a lock could be cut, couldn't it? I thought that was a brilliant move. I thought she did an excellent job, point for point. We've been talking about that since the beginning of early this morning. She's got to come back point by point and refute. She did an excellent job today. I'm telling you, she really did. She stood in there. Her demeanor was excellent. She didn't question only one witness a little bit too long. She wasn't Michael Jordan, Scottie Pippen maybe, and I think she's got a lot left in her. Now, we've had a lot of talk about reasonableness, and we got into it before for the break. Rick is correct. The legality of a school search depends on the reasonableness under all circumstances. So when we heard testimony that there had to be a reasonable suspicion that a law was broken or a school violation to get in that bag of Ethan Crumbley, that's absolutely correct. But here's an interesting dichotomy to that. As to lockers owned by school district or public school academies, there is no expectation of privacy under Michigan law in a locker or its contents. So if that backpack had been in the locker, there is no expectation of privacy. They could have went in it, they could have searched it, they could have did it whatever they wanted. The only issue here is during COVID, which this was, many schools had policies that said that students couldn't go to lockers. And I believe Oxford was one of them. So it's an interesting dichotomy when we talk about reasonableness, whereas in a locker, it's fair game. But when you're carrying around a backpack, you have to have reasonable suspicion that a law is or about to be broken or a school rule.
And do you think having parents on the premises too might have made them feel like maybe they couldn't? I don't know. just floating that out there.
That could very well be. They may have been intimidated somewhat by that. They shouldn't be, the school officials, but they may very well have been. I want to pick up on something that you said, Arnie, because I think what's going on here and what is coming out slowly is a case of overreaching on little and bigger things, and one of the things Arnie mentioned, the bag, the gun lock. The defense attorney said, basically, how the hell do you know if the gun lock was used? And his answer was ridiculous. If you took the gun lock out of that bag, the bag would be bent or damaged, which is nonsense. I've taken a gun lock in and out of that particular bag several times, and people who own guns who are on the jury, would certainly be able to do that as well, without damaging the bag or making it obvious that it was unused or pristine. And the other thing about the gun lock was there was no other evidence to show that because the bag was still in pristine order, that's the only evidence that he could surmise as to why the gun lock was not used, which is, again, overreaching. And I think a juror or jurors are going to sitting there that own a gun are going to be made aware of that. It was only 4 days old, right? The gun was, and the gun lock. So removing it once, putting the gun lock on, wouldn't damage in any way the bag, the external bag. And whether he, there's a reasonable doubt whether this shooter, that could have been locked, and he could have unlocked it, found the key, unlocked it, and put it back in the bag. I mean, that is not beyond the realm of possibility.
100%. When you look at a case like this, and we've talked about it earlier, this is not a case where you need to exaggerate. You don't need the extra, the histrionics. You don't need that. You already have behind you the terrible facts of this case. Come in, try your case as the prosecution, avoid the extra. Don't have witnesses on the witness stand kind of exaggerating, embellishing it all. And I think Rick is right. There's got to be at least 1 or 2 jurors at this point saying, well, wait a minute. I'm having kind of second thoughts about, this lock and the parent's responsibility in terms of not, securing the gun and knowing what this kid would do. I think this is textbook 101. Every law student, every young attorney out there needs to pay attention to this. When you got the facts on your side, try your case, don't embellish.
Arnold and Rick, thank you so much for your insight today.
Thank you.
Thank you.
And be sure to stay with CBS News Detroit for complete gavel-to-gavel coverage for James Crumbley's trial and expert analysis. You can stream the entire court proceeding each day live on the CBS News app, on Pluto TV, and cbsdetroit.com. We'll be right back after a break.
CBS News Detroit.
Hey there, thanks for sticking with us on CBS News Detroit at 4. I'm Terrence Friday.
And I'm Meredith Bruckner. Let's turn now to next weather meteorologist Ahmed Badji for a look at the forecast. It's been a beautiful day today.
It really has been. I mean, the fact we've got the sunshine sticking around out there, the 50s as well after yesterday's snow. We got a little bit of it. 50s, though, continue at least going into the evening hours. That is not bad. It is, however, quite breezy. We're going to have that here for at least a little while longer. All the way up through the 5 o'clock mark is when we'll actually hit our peak. Thanks to the time change yesterday, we've got later and later sunset times. Almost, I believe it's 7:37 for today, which means we get almost all the way to 8 o'clock before it really starts to get dark outside. Tomorrow morning, our lows are in the 40s, low 40s. That's what our average highs are. So we're doing just fine when it comes to some of those lows to start off the day. But highs tomorrow, well, I mean, I think that kind of speaks for itself. We got more sunshine for the vast majority of the day. We're dry. We start off basically near 40. And by the time we make it into the afternoon, by 5 o'clock is when we hit our peak close to about 67. It is going to be breezy, though, but all the wind is coming in out of the southwest, so not off of the water. That's going to be a big factor in keeping us more mild tomorrow. Are we breaking any records? No, but the upper 60s sure look nice. We're going to show you if that sticks around this week, because there are a couple of changes we'll have to break down. That's next.
All right, thanks, Ahmed. We're learning more about 2 Warren police officers charged in a violent traffic stop from last summer. The city of Warren settled out of court for $400,000, but this information was just released within the past few days. Prosecutors say former officers Damian Player and Carlos Taylor were fired and charged with a felony. Video of the attack shows the officers throwing the victim to the ground and tasing him. This happened in August of 2023. Investigators say the delay in releasing those details and the settlement is just an oversight. The prosecutor's office say they've always been transparent about police misconduct.
And now to an update on a Lions fan in hospice care we followed during the playoff season. Larry Benjamin died Sunday from chronic obstructive pulmonary disease. You may remember Larry went viral after he dyed his hair Honolulu blue to support the Lions. He was inspired by Lions wide receiver Amon-Ra St. Brown, who dyed his hair blue before the team's playoff game against the LA Rams. Larry was 83 years old. New at 4:30, Michigan has seen record-breaking temperatures this winter.
February 27th is when Detroit reached a high of 73 degrees. That's the hottest February day in record history, which dates back to 1874.
Our Alicia Bergio is on your block in Mount Brighton to explain the major impact these warmer temps have had at local ski resorts across southeast Michigan.
Most Michiganders would agree it's been an interesting winter. It's snowing. The next, it's sunny skies and warm temperatures. For local ski resorts, the back and forth with Mother Nature has not been ideal, and it's led them to wrap their season early because there's simply not enough snow. At Mount Brighton, after many snowmaking attempts, the staff was unable to repair and rebuild the slopes, saying in a post on social media that their talented mountain ops team did their best to piece the hill back together, but ultimately determined there was no longer enough snow to remain open. In a statement to CBS News Detroit, Mount Brighton employees remain in good spirits and are already looking forward to next season. The resort also says, though the season ended earlier than expected, season passes will not roll over into next season, but